हेलो।
हाँ गौतम।
कर रहा है सर, कर रहा है।
ना ठीक है, उसके लिए नहीं, हम उन्हें पूछ रहे हैं।
वो लाइव हो गया विकास, हो गया ना। वही जिसे बैक कहते हैं उसमें बैक चले जाइए, जिसे बैक कहते हैं उसमें बैक चले जाइए।
हेलो। टेली से कीजिए।
आशुतोष बाबू का है ना।
टेली से तो नहीं हो रहा है, टीवी से करना पड़ेगा।
हेलो हेलो।
हेलो
से एक बार कर दीजिए
हेलो
ना।
हेलो
यूजर से नहीं ले रहा है तो सकलेन वाईफाई दीजिए,
हेलो
पासवर्ड में पासवर्ड दीजिए।
ग्यारह 1 2 3 4 1 2 3 4 आ रहा है थोड़ा सा।
इधर वाला में
क्या चेक करवाए हैं आप लोग? देखिए आपके सामने लगा हुआ है, देखिए क्या हो रहा है।
कनेक्ट नहीं हो रहा था
अब बोल रहा है बहुत सारा कोर्ट
कुछ
में
देर
problem
पहले।
है। क्या चेक करवाए आप लोग? क्या चेक हुआ है देखिए तुरंत।
नहीं टेली वाले से हो ही रहा था।
क्या बबलू जी क्या
हाँ मेंशन करना है,
ज्यादा आगे मत बढ़िए
ना? अच्छा, आसो सौ है ना? पूछना पड़ता है कि ऐसा नहीं गलत जगह आके बैठ।
वही पुलिस लोग या फिर ऐसे ही कौन दे दिए? और दीजिए ना, ये छोड़िए ना, और दीजिए 32 नंबर।
चला ले ऐसे
22 दीजिए, वो दीजिए।
उसको बोलिए कैमरा ऑफ कर देगा दोनों में। कैमरा ऑफ कर देगा। अरे वो ऑन कौन कर दिया?
It is with the Bihar School Examination Board.
All the formalities and regulations.
My lords, in fact, they allowed so far as 50 students are concerned, and thereafter, my lords, time and time again, they are constituting a special team, my lord, for conducting the raid.
Now, what in your mind would be the urgency to hear it this week or next week?
My lords, for the reason, my lord, that now they have come up with a plea. They have filed a counter affidavit pursuant to the direction of this honorable court only, my lords. And there was a direction for posting this matter in the December itself.
Tell us now.
Now they are saying that there is no GNM institute which is available, my lord. So I think a limited what would be required, my lord, at the present.
All right, you make a note of it, but postmaster, you take on Sunday till the next week.
Very well, my lord. I will.
Keep it on Thursday.
Very well, my lord.
May I mention a case, my lord? My lord, there's one representation which has been pending before the registrar, my lord.
Your Lordship, the matter.
Just a minute. Let him give a date.
My lord, same matter, my lord.
He is only burdening the High Court. Doesn't matter. Yes.
Yes.
May I mention, Lord?
Mr. Rupa Kumar.
My lord, may I add to mention CWJC number 7143/2021, my lord. This is matter is related to the, my lord, the recovery, my lord, made from the petitioner's salary, 25% salary, my lord, due to non-completion of the PhD, my lord. Only the thesis and viva was is
Was there any condition fixed that if you would not have your PhD, you will not get this sort of salary? Was there any condition?
there was no condition, but there was a, my lord, there was a time limit with immediate, my lord.
That's right. So, time limit, and with the time limit, was there anything contingent?
Yes, my
Now,
lord.
where is the requirement? Mr. Rupa Kumar, you have to be very specific.
My lord.
Where is the requirement if the salary is being deducted without any rule of law, without any
There was
intimation to
there
you?
was a bond, my lord, that if it is not complete,
So
my
you
lord,
have- you have-
that was, my your lordship, they can appreciate, my lord. This PhD could not be completed only because of the absence of the co-advisor from the VR
All
University
right.
who did not accompany, my lord.
You have not been able to complete your PhD, which is not attributable to you.
My lord.
That's right.
Only thesis and viva was come to, my lord.
All right. So,
Thesis and viva was is only
you are
required.
arguing something against your bond, but it's a
No,
misnature.
that I can, my lord, I cannot, my
Third
lord,
week.
conceal the.
All right, third week.
May I have your Lordship leave? The case running on serial number 164. It relates to counseling of teacher, Your Lordship. Your Lordship was kind enough to hear the matter prior to closing, Your Lordship. But since there was no date, specific date, the 17th is now the date fixed for counseling, Your Lordship.
17th of January.
Yes, Your Lordship.
Well, let's see. We might give you a hearing on 30th.
File your right.
13th.
May I mention, Lord?
Serial 164.
Just a minute, Mr. Allo.
Yes, sir.
164, if we reach before 13th, it's all right. Otherwise, make a mention on 12th. So that I give it on 30th. All right. Yes.
My Lord, a batch of identical matter, Lord, is coming on 5th January, my Lord. These two cases may kindly be heard along with that matter.
How many cases you are expecting to be heard? I hope we will be going online. This is what I hope.
In that case also, in leading case, I am arguing, my Lord.
Leading case you are arguing.
My
I think it's a lead case and not leading case. All right.
Thirdly.
All right. Tag it with that case. Have you given the number?
No, my Lord. I have given the number.
एक साथ
My Lord, one salary matter.
Sorry, Mr.
I have permitted
Yes.
mention from Lordship. The petitioner filed a petition because she has qualified the IET examination, my lord, and seat and college has already been allotted. But thereafter, the authority concerned is not ready to take admission in the petition, my lord.
No, why? There has to be some reason. You just can't make a statement like this, Mr. Manoj Kumar. There has to. You must have been communicated
Yes,
some
yes,
reason.
my lord. Yes,
Tell us
my lord.
the reason.
She has earlier appeared in the examination. She was not qualified. Thereafter, she has another appeared, my lord, and she has qualified. The reason has been given.
I didn't follow. You were allotted a college.
Yes.
Now the college is refusing to take admission.
Yes.
Now there has to be some reason.
Reason behind that you are already appeared before this examination. So we are not permitted to allow the admission below.
Earlier one.
Yes.
No, but why did you write another examination when college
The
was
reply should be given by the authority, my lord.
All right, we'll see.
I have already qualified, my
What
lord.
happened to the earlier examination?
Earlier examination, she has not qualified. But later on, she has appeared.
There must
The admit.
There must be a provision for
Yes, yes, yes.
upgrading
Yes,
yourself.
yes.
No.
Yes, yes.
Then why should they take this plea? Perhaps you're not stating the correct fact, or maybe you're not communicating it properly.
No.
Place it with the file, देखें क्या है? We are not fixing any date. इसको file के साथ लगाइए, देखेंगे. If the matter is urgent, we'll have it
Yes.
listed somewhere.
May I have my mention a case, my lord?
Just a minute, a senior advocate is mentioned.
It's transfer matter, my lord. Transfer order has been issued in violation of statutory rule.
What violation? Which rule?
Yes, my lord. It is section 10, subsection 5.
What does it say?
It says, my lord, that a head of the department of a particular faculty shall retain the post for a period of 3 years, tenure post.
It's a tenure post.
It is a
Which
tenure.
department is this?
It is, my lord, Dr. Rajendra Prasad, Central Agriculture University, Pusa, my lord. And
who is the
petitioner
first?
is Professor of Agronomy in PG College of
We are
Agriculture.
not concerned with those details. Tell us whether he falls squarely in that group which protects him from being transferred before 3 years.
Yes, yes, my lord.
Where
The
have you made
specific
that-
rule
have you said that?
Yes.
Since when is he heading the department?
Yes,
For
yes,
him to
my lord,
come under the
that
protective cover.
14/9/20.
14/9/20.
20.
And he has been transferred when?
On my lord 8/12/21.
And let us hear that rule, concerned rule 10 sub clause 5 of what? whichever
Yes, 10 sub
statute.
clause
What is
5
that?
says,
Just
my lord.
read the statute if you have the file with you.
At the moment, I don't have, my lord, but I have quoted in the
Alright.
writ application itself, my lord. It
You
is
have
in
been
the
asked-
consolidated list, my
Just a
lord,
minute.
at serial 3204, consolidated
आप
list.
जो काम जो पूछ रहे हैं बहुत ज्यादा जरूरी
जी.
है ना? You have been asked to vacate your place and join another
Yes,
case
yes,
when?
my lord. Yes.
When?
Yes,
Yes,
my
तो समझा when.
Yes, my lord. It is 13/12/2021.
So the date is over.
My lord?
Date is over.
Yes.
So what have you done?
My lord, I am on leave.
You are on leave.
Yes.
Let's see. If it is beyond the rules, we might consider
Yes.
next week.
Deeply obliged.
May I permitted to access Lordship? CWJC number 10/9/57/2021 Lordship. It is posted as item number 140 Lordship. She is working as a Urdu teacher Lordship since 2019.
वो तो facts हो गया, urgency
But
क्या
his
है?
salary was not paid by the
Why?
responsibility.
You must not have passed your DLED examination.
Yes, Lordship.
Also,
I-
all the teachers who have not passed their DLED, there is a direction to reduce 25% and thereafter 50% and thereafter entire salary. What do we do?
Lordship.
Have you challenged that notification by which this instruction was given? No,
Yes.
you have not.
Lordship,
February, March, February.
May I mention the case, my lord? The petitioner is the block teacher, my lord. She went in service training, my lord. But unfortunately, she became ill, my lord, and went on leave, my lord. He is requesting their BNR training college, Gujarat, Patna, my lord, for completing the remaining session,
Training.
my lord. But she was not allowed. Now
And therefore,
this-
without full training, you would not be posted anywhere.
so back to the school, my lord.
Did you communicate with the authorities that you have been taken ill and that you can't attend the training?
Yes, my lord. I
Or
have.
were you a deserter?
I have annexed, my lord, the application when I went on
For
leave,
how
my
long?
lord.
For how long did you expostulate yourself? How long did you remain away from the training?
Training for about 6 months, my lord.
That's right. That's what I wanted to know. Because normally this kind of restriction is not put to a person who has been communicating with the authorities. You must have gone completely AWOL.
That is.
You know what AWOL means? Absence without permission, absence without any leave. So therefore, you would be treated as a deserter. Anyway, we'll see.
My lord, she went to the school, joined there, but now
She
the
will not
district.
be. She will not be normally allowed to join because
She-
you have remained absent for
नहीं,
6 months.
She has joined, my lord.
March,
But
February.
मार्च में जो इनको टर्मिनेट किया जा रहा है अजीत भैया
February.
फरवरी में कर
Your
दिया।
Lordship. 17/6.
Mr. Singh, he had begun but earlier. Yes.
Your Lordship, petitioners are teachers, my lord, and they have been still working continuously, but salary has been withheld.
February end.
बस रिजल्ट हुआ जो रिजल्ट ऑफ बीसी एग्जामिनेशन
Same है sir.
Same product. Why don't you say that you're offering 4 slips?
My lord.
Why the court master should tell the court? You can take permission of the court that these are similar matters and This gives an impression that you are passing on the slip on stealth. That's not done. You say that you have 4 slips.
Sorry,
I would reject whatever. That decision shall be mine.
my lord. Sorry, my lord.
All 4 are identical matters.
My lord.
Please,
Same impute not.
absolutely behave like an officer of the court, not like an advocate.
My lord.
Take all. February. All right. Yes.
My lord, result of BCA examination was withheld, my lord.
Why?
My lord, it was because, my lord, I did not appear in second semester examination.
You did not?
Did not appear in second semester
ये कौन सा
examination. Then after, my lord, then after I was permitted
पहले
to
तो
appear.
बात सुनिए ना. Did not appear तो हमने आज तक सुना नहीं है. Did not appear.
Ma'am.
Did के साथ ED कहाँ लगा? High Court में.
My lord, did not appear
Don't
in.
laugh. Yes.
Did not appear in semester 2 examination. Subsequently, petitioner was permitted to appear in along with semester 4 examination, and he was passed, my lord.
He passed.
My lord. My lord, he passed, my lord. Fourth slip.
You passed, so well and good.
My lord. My lord, but my lord, result was withheld, my lord.
Why?
My lord, this was the reason, my
No,
lord.
you were granted permission to appear.
My lord.
So that was a kind of compartment examination. They must have permitted you to appear.
My lord, they permitted me to
Where
appear.
is that permission for you to appear?
My lord, sir, it was they given me admit card, my lord, and they
Admit card may have been given on your wrong representation.
My
But
lord.
did you require? Does the rule say that?
Rules say, my lord.
Just a minute.
I have been close rules, my lord.
Does the rule say that even if you don't pass a particular semester, you can go and take examination
My
for
lord,
the other
the rule
semester?
says, my lord, I have
Show us
enclosed
the
rules. Rule 9 is, my lord, I have showed the rules.
Read it. Read
My lord,
it.
I have mentioned a writ petition, my lord.
Come tomorrow and tell us what is the
My lord, sir,
situation.
two cases, my lord, salary was
That's all
stopped.
right, but we must be satisfied that you.
My lord,
require
I will place with along with the rules, my lord.
Tomorrow.
My lord, sir, 2 cases, my lord, in which salary was stopped, my lord. But, my lord,
February end. And for that examination matter where your result is withheld, you show us the rules tomorrow.
Tomorrow.
Online mentioning and
Ji,
we'll see.
tomorrow, my lord, हम भेज देते हैं.
May I permit to mention the case, my lord? In this case, my lord, petitioner's intermediate result has been withheld.
Yeah?
Petitioner's intermediate result has been withheld by the
Why?
respondent, my lord.
Why?
My lord, he is saying, my lord, copy has been misplaced.
Copy has been misplaced.
Yeah, वो one copy, my lord, हिंदी को कर रहे हैं कुछ misplaced.
आपकी कोई गलती तो है नहीं?
हमारा जो गलती।
तो आपने क्या कहा कि हमारा जनरल मार्किंग कर दीजिए?
कॉपी रिजल्ट हमारे के रिजल्ट नहीं दे रहे हैं withheld किया मैं 20 तक
कराइए।
एडमिशन करना है।
Third week.
Second appeal, my lord, I have earlier mentioned also, my lord, the execution court.
You are the plaintiff?
No, yes. No, I am not the plaintiff, I am the defendant.
You are the defendant?
Defendant, my lord. Actually, my lord, 10/1/2022, he has fixed for orders, my lord.
Who has fixed for orders?
My
Execution
lord,
court.
executing court.
And what is the order? What is the decree?
My lord, decree is, my lord,
It was a suit for what?
it was suit for, actually, my lord, the plaintiff has purchased.
No. Tell us. I mean, don't go to that. Those
Title,
details.
title.
Tell us what title. Title suit for what?
No, it was purchased by the plaintiff, my lord, and therefore, my lord, he has gone for execution. We say, my lord, that the property was earlier
Sold to you, to
Yes.
your ancestors,
Yes.
and therefore you have come in
Yes.
possession of that property.
Yes.
Very well. So the what is the date fixed before the
My lord,
court?
10/1/2022.
10/1/2022.
Although, my lord, earlier mentioned, my lord, and my lord, I have filed a certificate there also, but he has fixed for all.
All right. This will come under order 41/211.
Yes. Past तारीख को रखी।
नहीं ऐसे you do decide the date.
Actually, my lord, 10 is the last date.
Well, all right.
Anyway, your
We'll
lordship.
fix it on 7th. Come prepared. We will give you a hearing that day only.
Yes.
Lordship, may I permit the case? Sorry.
Yes.
Lordship, may I permit the case, Lordship? Lordship, in this case, Lordship, the petitioner has been dismissed from service on in the year 2017, Lordship. And Lordship, he has come before this court, and his dismissal order was Lordship satisfied by this court.
Then what happened?
Lordship, thereafter, Lordship, they remanded the matter before the authority concerned.
That's right. Again you have been
For
dismissed.
fresh
Again you have been dismissed.
Lordship.
March.
Oh, like this.
Who is coughing? Anybody who is coughing, would you be please kind enough to all the colleagues to leave? or use your mask. Yes.
May I mention this case? I had mentioned it last month, and the slip was taken.
I have forgotten. Tell us what is.
My lord, the case was a teacher was dismissed in '98, and he went to court, and then he filed a writ here. 5 years he did nothing. Court dismissed. Then again, after 2 years, he filed another writ, which was allowed. And then in LPA, it was dismissed, the whole writ was dismissed. Then he went to Supreme Court.
Because you must not have disclosed that the first writ was.
So therefore the LPA was, all the writs were dismissed. Then my lord, he went to Supreme Court, and the lower Supreme Court said, okay, now there is a rules made for appeal, so you may go. So, okay. Now the lower court ordered us to pay fee 60 to reinstate him, because there was some flaw in reinstate him with right wages, with interest, with penalty, etc., etc. My lord, now the state commission has ordered this one, and I have challenged the order. Now, my lord, my interesting part is, my lord, I applied this to IS.
Tell us the urgency.
They refused. Now I am under penalty 50,000 rupees for not getting order from the High Court staying the thing within 2 months.
The order of penalty would not have been couched in the terms in which you are communicating.
Yeah.
That cannot be the reason for saddling you with a fine of rupees 50,000. There is something else.
No, my lord, it is for contempt for not obeying the order of the.
We'll see. We will see.
Tomorrow,
you have not paid you have not come for 6 months to High Court. You have not paid your money.
I have come. My writ is pending.
All right. Your writ is
two
pending.
IS are pending.
All right. We'll hear you. We are fixing a date sometimes in February.
My lord, the question is, if we are not paying, the certificate proceeding is to start for realization.
That's all right. Certificate proceeding, you're not asked to pay up overnight. You also know the procedure. You know Section 9. You know other sections. So therefore, we are giving you an early date sometimes in February.
Okay.
16th of February.
Yeah.
Only one, Mr. Joseph.
Yeah.
Just a minute. 16th of February.
Okay.
Yes.
My lord, in this case, the petitioner is arrested, my lord. May I permit you to withdraw this case?
Withdraw. नहीं अभी कर देते हैं. लिखिए. फाइल मंगवा के कर दीजिएगा. अच्छा, tomorrow.
And as serial number 11, my lord, petitioner is already arrested, my lord. May I permit you to withdraw this case, my lord?
That when I start taking up the list. Yes.
May I mention a case, my lord? My lord, I have received the order of state appeal authority in which there was order of penalty imposed, and my application, my recovery has been, order of recovery has been issued.
It is with respect to teachers.
My lord, it is with teachers.
Appointment.
My lord, appointment. I have been working since more than 10
State
years.
Appellate Authority passed order when?
My lord, in November 2021, my lord.
November 2021.
My lord.
So, all right. February 18.
My lord, if he is not in, there are 3 cases all arising from same.
It is very inconvenient for the court today to hear you, hear your slip in all 3 cases. Try another day. One I have accepted, 18th of February.
My lord, any earlier date if I can.
18th is good enough. 18th February. Yes.
My lord, may I permitted to mention a case, my lord, from the list, my lord, serial number 9 and 32. Prayer for not today, my lord.
I'm not going to tell you the procedure of this court in the first day. When the case is called out, make a mention, we'll accommodate you. Yes.
My lord, permitted to mention a case in consolidated list. It is listed at serial number 2999. My lord. The petitioner have been appointed on the post of teachers on contract.
What has happened?
My lord, in the name of verification of their certificate, since May 2020, the payment of salary has been stopped.
No proceeding has been initiated. Nothing against you. Only February first week. All right. February first week. Yes, Mr.
Lordship. One case, serial number 169, Your Lordship. In this case, a dean of Animal Husbandry School, college, has been removed in the month of August this year. I had filed a writ. Now the proceeding has been initiated to reappoint a dean, Your Lordship. And in my case, I have been removed without giving any so cause.
That's all right. So the maximum that you can now agitate before this court is you will challenge your ouster.
No,
but
Your
perhaps you can't ask the court to restrain the process of appointment.
Your
That we
Lordship,
will not do.
Your Lordship, Your Lordship
If you succeed, the entire process would be set at naught. Don't worry.
Your Lordship, it is
Concentrate on your file. Tell us where is the case.
It is at serial 169, Your Lordship, and today itself it may be fixed on any day in this month.
In this month, I cannot promise. We can give you a hearing in the first week of February.
Obliged, Your Lordship. Obliged.
Give it on 4th of February.
Obliged.
With us here?
Yes, sir. Just I am writing down some.
Yes.
Serial
Call out करिए अब इसके बाद.
Serial 10 में kindly withdraw.
Only when it is called out. चलिए call करिए.
My lord, in case I am retreating at the second appeal, execution is going on. Next day it will be first. Before that, it may be hard.
What is this decree by this?
Decree is about the dwelling house. That is
Who are you?
And this is an ancestral house.
Is it?
In trial court, I have succeeded.
Is it a judgment of reversal or both the courts?
Judgment of reversal.
(18th of January). Ask somebody to switch on this heater. Yes, call out.
And the hearing order. Mr. Ram Babu.
Yes.
May it please your lordship. Lord, this is an application for anticipatory bail. The main offence is under section 302 of the penal code.
Let us see the FIR.
In the case, my lord, where petitioners have not been named in the FIR.
That's right, but let us see the background in which the occurrence is said to have committed.
सादर सूचित करना है कि मैं राकेश कुमार सो एंड सो का रहने वाला 28/5/2019 को संध्या करीब 6 बजे अपने घर से मेरा भतीजा अभिषेक कुमार is also deceased. So and so अपने फुफेरा भाई आशुतोष अभिषेक एंड आशुतोष दे आर द डिसीज पर्सन रफीगंज मेला पर मिलने के लिए गए थे. पता चला कि अभिषेक और आशुतोष रफीगंज से अपने मोटरसाइकिल से पुनः देव के लिए करीब 7 बजे चला, संध्या 7 बजे. जब रात का घर नहीं पहुंचा तो पता लगाने का प्रयास किए.
No, that's all right. How? Why you have been named? No, you have not been named. Mulayam, Balawadhi and Malu.
Some 7 or 8 other persons have been named. Petitioners have not been named. दिनांक 29/5/19 को देव द्वारा थाना द्वारा बताया गया कि अभिषेक का हत्या हो गया है. लाश के पॉकेट से पैन कार्ड मिला है, जिससे जानकारी मिली है कि शेरघाटी थाना क्षेत्र में 2 आदमी का लाश मिला है. इस सूचना पर हम लोग लाश को पहचानने के लिए आमद थाना पर गए तो वहाँ पता चला कि लाश को पोस्टमार्टम के लिए मगध मेडिकल भेजे हुए हैं लोग. हम लोग मगध मेडिकल जाकर लाश को पहचान किए तो मेरा भतीजा अभिषेक कुमार सिन्हा और भगिना आशुतोष कुमार सिन्हा का लाश है. अभिषेक सिन्हा के पास मोबाइल नंबर आशुतोष के पास था, जो मोटरसाइकिल तथा मोबाइल हत्यारा लोग ले लिया है. मुझे विश्वास है कि and then some 7 persons and some other persons, 7 persons have been specifically named. कि अन्य अज्ञात के साथ मिलकर मेरा भतीजा और भगिना को हत्या कर दिया है. So in spite of the fact that 7 persons have been named, petitioners have not.
Yes.
Yes. So far as FIR is concerned, I am not named. There is absolutely no eyewitness to the occurrence or any part of the occurrence. Even the informant is not an eyewitness to the occurrence. His version is based on.
That's all right.
I mean, during investigation, the only material, Lord, my names of the petitioners have come. The only material which have come during investigation is love affair of these two accused persons with two other.
Mr. Verma, you need not trivialize this issue like that. I mean, the impugned order says something else. Now that's true. A love affair between two women and two girls and two boys. Both the boys have been found dead. Now, so far as you are concerned, you are Mama of Sarita. I mean, I have read this in the impugned order. You are not telling me all this.
I'm Sala
Mama
of
is
one of the
Mulayam.
accused.
Right. Mama is Mulayam. And Lalu is his brother or son. I don't know who is Ram Rahim. We don't know.
Now, Mulayam and Lalu, they are Sala of Dr. R. Kumar.
So therefore, the better reference would be with respect to the deceased, with respect to the girl. So you are Mama of Sarita. Sarita was in affair with Abhishek or Ashutosh, whoever. और बताइए क्या है? इसको love
I mean,
affair
minus
ऐसे कर देंगे
that,
तुम्हें?
so far as this love affairs is concerned, that it has also come during.
Heard Mr. Yogesh Chandra Verma, learned senior advocate for the petitioners and so on and so
And
forth.
one person he has been allowed.
That we are not. Who has been allowed? Any reason given?
Not named and.
Unnecessarily, when I am granting you bail, why are you showing all that
I'm
orders?
sorry, I beg.
Because I might find that if it is not
I'm
in
sorry,
consonance
Malay,
with my reason.
I'm sorry.
Suppose I am not granting you bail, then only you can take advantage of order by appointed bench.
I'm sorry, Milord.
All right. Heard Mr. Yogesh Chandra Verma, learned senior advocate for the petitioners and so and so for the state. The petitioners seek bail in anticipation of their arrest in connection with Shergati PS case number so and so, dated so and so, instituted for the offences under section so and so. Two boys said to be in love with two other girls, were found dead. The informant, who is the uncle of one of the deceased boys, has raised suspicion against some of the relatives of the girl with whom his nephew was carrying on an affair. During the course of investigation, it came to light that a girl by the name of Sarita was having an affair with Ashutosh, who is the niece of petitioners number 1 and 3. Because of such relationship between Sarita and her paramour, her father is said to have sent her to Visakhapatnam for prosecuting her studies. When aforesaid Sarita came back home, she was not made to stay with her father, but she was asked to stay with petitioner number 1. It is in this circumstance that the name of the petitioners has transpired as having managed to have one of the deceased persons come to the house and thereafter he was killed. The counsel for the petitioners has submitted that except for this vague suspicion and general presumption that petitioners number 1 and 3 being the uncle of the girl with whom one of the deceased was carrying on an affair, much to the chagrin of all other family members, that they may have conspired to have one of the deceased killed. Beyond the suspicion and the relationship between the deceased and the relationship between the two girls, who relationship with one of the girls with whom one of the deceased person was carrying on an affair. There is no other material to connect the petitioners with the offence. Thus, it has been argued that the petitioners were not named in the beginning because there was no material against them. Only during the course of investigation, they are sought to be prosecuted on an unfounded suspicion without there being any cogent evidence to connect them with the offence. For the reasons above stated, 10,000.
Thank you. Mr. Devendra Kumar.
Yes.
My lord. Section 498, my lord.
Who are you?
Husband.
Mask उतारने मत कहिए.
Oh.
You can wear your mask. I am without a mask, so therefore give me protection. You wear your mask. मास्क पहन लीजिए.
जी जी.
हमें लिखाना है आपका ऑर्डर, इसलिए मैं मास्क नहीं पहना. आप तो मास्क लगा कर बोलिए.
नोटिस जो हुआ था इसमें अपीयर नहीं कर.
अभी क्या सिचुएशन है? Notice to the OP number 2. Has notice been served? Requisites of notice awaiting the appearance. Who is Rama Devi? Who is Roma? Is she the opposite party number 2? What is the name of the wife?
Rama Devi.
Roma Devi. It has been served upon her. Item delivered to Roma Devi. Address. क्या लिखता है? लिखिए. The petitioner. What is your name, Mr. Counsel?
Subodh Kumar.
Heard Mr. Subodh Kumar, learned advocate for the petitioner and so and so for the state. The petitioner, who is the husband of OP number 2, seeks bail in anticipation of his arrest in connection with so and so. On 4/3/2020, a bench of this court had issued notice to opposite party number 2 and had granted interim protection to the petitioner. It appears from the office notes that the requisites for issuing the notice was promptly filed by the petitioner, but the notice has not been received by the OP number 2. The petitioner maintains his stand that he is ready to cooperate in the petitioner is ready to enter into negotiations with OP number 2 for an amicable settlement of marital discord between the spouses. He is ready for any eventuality, namely either resumption of matrimonial life or for any other alternative settlement, whichever is mutually agreeable between the spouses. Looking at the aforesaid stand of the petitioner, this court deems it appropriate under the circumstances to direct that in the event of the petitioner surrendering before the court below within a period of 6 weeks, he shall be released on provisional bail on his furnishing bonds in sum of rupees 10,000, 2 sureties of like amount. Simultaneously, notice shall be issued to the opposite party number 2, and on her appearance, the court shall provide ample opportunities for negotiation between the spouses and their family members, if so deemed necessary, for an amicable settlement. In case the dispute is settled, the provisional bail of the petitioner shall be confirmed. While taking a decision regarding confirmation of the provisional bail, the court shall also look at the attitude of the parties, and in case it is found that any one of the parties has been non-cooperative or unreasonable, that shall also be taken into account before passing a final order. The petition stands disposed of accordingly.
Actually, my lord, the case is under section 471, 420, 120B, IP.
Yes, Mr. Vigilance, you are here?
Lord,
Yes.
I have filed the counter affidavit.
Have you given him a copy?
No, Lord. Today itself I have filed.
His filing means nothing. Give him a copy today.
Lord.
Hand it over to him now, if you have a separate copy.
He said that he filed today. Means
Today
that
through email.
वो रिकॉर्ड पर भी होगा नहीं
You accept a copy. देखिए, Mr. The Learned Counsel for the Vigilance has stated that a counter affidavit in this case has been filed today online. On the request of the court, a copy of the same has been handed over to the counsel for the petitioner in court today. Let the physical copy, let the hard copy of the counter affidavit be placed on record on the next date. Re-notify this case on 5th of January. 6th of January, 6th, Thursday. Mr. If the High Court finds it difficult to have the hard copy, you give us a hard copy, we'll hear it then. Keep one other copy, hard copy, with you. In case you might have it. If you are sitting physically, all right. Let's see what is due. All right. Yes.
Okay.
498 your lordship.
Yes, Mr. JP Singh.
दोनों शादी कर लिया
No, but therefore you are not desirous of.
Earlier, your lordship was asked me whether the girl has married or not. She has been married with another person, but she has a baby child. She wants to live, but subsequently in the pendency of this case.
Mr. JP Singh, you represent the girl who is married now.
Ji.
Now, are you interested in prosecuting because anything that he has done prior to, I mean, when the marriage was subsisting,
yes.
For that you can always prosecute him. But would you be interested?
Your lordship.
For the purposes of grant of anticipatory bail, it's not. Both of you could not live together happily. That's unfortunate. But nobody becomes a criminal because of that. So if you are married and you are happy, be happy, prosecute him, but don't oppose his will.
Yes, your lordship.
बोलिए सर क्या नाम है?
रामेश्वर।
तो आपसे बिना सहमति के बिना
पहले इन्होंने शादी किया, दूसरा फिर
आपने पहले शादी कर ली।
दोनों लगभग
Heard Mr. Rameshwar Singh for the petitioner and Mr. JP Singh for the opposite party number 2. The petitioner is the husband of opposite party number 2 and seeks bail in anticipation of his arrest in connection with so-and-so. Without referring to the factual aspects of this case, learned counsel for the parties have intimated this court that both the spouses have now married different persons and are satisfactorily living with their new spouses. Considering this aspect of the matter, the petitioner is directed to be released in the event of his arrest or surrender 10,000.
One recommendation, my name is not appearing in this.
उसमें जिसमें vigilance का ना, the name of the counsel for the vigilance, Mr. Arvind Kumar, be printed in the cause list henceforth. Yes, follow up, Mr.
Yes, my lord. The anticipatory bail application under section 420, 468, 120B.
Comfortable chair. Yes.
इन्फॉर्मेशन के लिए इनका नाम हुजूर
ये बस इन्होंने कोशिश किया, आप वेट करिए। बोलिए। Louder, there is no mic before you. You'll have to use your lung power. वो लगा कर रखिए, लेकिन जोर से बोलिए।
Okay. My lord, petitioner appointed as a assistant manager, my lord, scale 1, my lord, in branch, my lord, said branch, my lord. And during probation period, my lord, his ID has been as per similar.
Please read the FIRs.
Yes, my lord. सूचित करना है, पेज 16 पे है, my lord.
बोलिए।
मैं रोहित राज, इन्फॉर्मेंट मालिक, उत्तर बिहार ग्रामीण बैंक बरियारपुर कंद शाखा जिला मुजफ्फरपुर में शाखा प्रबंधक पद पर पदस्थापित हूँ। मेरे शाखा के अंतर्गत विभिन्न खाताओं में कुल 22,07,326.03 रुपए
रुपए का गबन हुआ है जिसकी सूचना संलग्न है हमारे बैंक के विशेष अंकेक्षक टीम के द्वारा।
हमने ये बहस सुना है किसी और एक्यूज्ड के लिए?
हाँ जी,
किसी कैशियर के लिए सुना है जिसके नाम से 90,000 रुपए का कुछ था?
यस माय लॉर्ड।
आपका क्या है?
हमारे ऊपर हमारे आईडी माय लॉर्ड, ये पेज नंबर
योर विक्की जायसवाल।
ये विक्की जायसवाल माय लॉर्ड।
विक्की जायसवाल क्या है?
नंबर 18 पे है माय लॉर्ड। 31 को माय लॉर्ड हमको कहा गया कि क्लोज करना है ब्रांच को, इसी समय एक ही डेट का है माय लॉर्ड। 31 को मेरा आईडी यूज हुआ है माय लॉर्ड।
फॉर विड्रॉल ऑफ व्हाट अमाउंट?
विड्रॉल के लिए नहीं माय लॉर्ड, ये गबन नहीं है, ये है कि जो इंटरेस्ट आता था अकाउंट में डिफरेंट अकाउंट का था, तो इनका कहना है कि दूसरे अकाउंट का दूसरे अकाउंट में डिस्पर्स किया गया है, यानी क्रेडिट कर दिया।
your ID card has been used.
आईडी कार्ड एज पर डायरेक्शन, क्योंकि हम तो प्रोबेशन में थे माय लॉर्ड, उस समय हमको डायरेक्शन दिया गया कि आप इसको वेरीफाई देखा ना एंट्री।
इनका आईडी कार्ड यूजर आईडी यूज हुआ
होने दिए इन्वेस्टिगेशन। You are appealing for whom?
बैंक।
Yes.
स्टेट में लो इसका इनका आईडी
हमने किसको बेल दिया है?
बेल हुई नहीं है किसी।
डायरी मांगा गया था, जो
डायरी मांगी गई है,
ओरिजिनल दिया गया है।
दीपक कुमार।
All right. Same fate will befall on you.
जी।
I'll give you interim protection and we'll call for the case diary.
इसमें केस डायरी आया हुआ है हमारे।
केस डायरी में क्या है?
कुछ नहीं मैंने तो पारा।
बोलिए मिस्टर बैंक।
जी पैराग्राफ 13-14 में सपोर्ट किया गया है केस को।
क्या सपोर्ट है
इनके द्वारा?
पैरा 13-14
जी। रविभूषण चौहान, उम्र 32 वर्ष, पेशा चौहान, बयान
विशेष अंकेक्षण वो सब छोड़िए, डिटेल्स। विशेष अंकेक्षण में क्या पाया है?
इन्होंने इरेगुलरिटी पाई, गलती पाई।
क्या गलती? कुछ लिखा नहीं, ऐसी खाना पूरी है ये।
सपोर्ट किए हैं केस।
क्या सपोर्ट करेंगे बताइए, आप एक लाइन पढ़ के बताइए जिसमें सपोर्ट दिखता हो। Give me one line also that this is the reason why you suspect his hand. It's just a repetition of what the informant has said.
तत्कालीन अधिकारी कार्यालय सहायक शशिभूषण राय गबन में शामिल हैं। इन
ये तो बड़ा मुश्किल है, उस समय के सारे लोग बैंक में शामिल हैं, आपके बैंक के एमडी भी शामिल हैं।
नहीं, इनका यूजर आईडी तो यूज हुआ ना।
Heard Mr. What is your name?
शशिभूषण।
And gentleman, what is your name? Bank, Mr. Bank.
उत्तर बिहार ग्रामीण बैंक।
आपका नाम?
बताइए सर। सत्यानंद सर।
Heard Mr. Sashibhushan Kumar for the petitioner and Mr. Satyanand Sharma for the which bank?
अखिलेश्वर दयाल।
उत्तर बिहार ग्रामीण बैंक।
North Bihar Gramin Bank. And Mr.
अखिलेश्वर दयाल।
Akileshwar Dayal for the state. आप अखिलेश्वर दयाल हैं?
जी।
Somebody else was appearing with this name?
No.
I don't know. And Mr. Akileshwar Dayal for the state.
Another Sameshwar Dayal.
The petitioner seeks bail in anticipation of his arrest in connection with so and so. So stop. The accusation in the first information report is that a huge amount of money was deposited in different accounts with the connivance of the employees posted in the aforesaid branch. So far as the petitioner is concerned, he was posted as a probationer officer in the said bank. So far as the accusation against him is concerned, he is said to have lent his identity card for deposit of interest in some other account where it ought not to have been deposited. The overall accusation is that in different accounts there was an embezzlement of approximately 22,07,326 rupees. Land Council for the petitioner has submitted that the accusation is absolutely vague and does not signify anything except for naming all such employees of the bank when some embezzlement was found out during the regular audit of the bank accounts. So far as the petitioner is concerned, the case diary indicates that he is also responsible for deposit of for the anomaly in the credit and debit of interest in the bank in respective bank accounts. And counsel for the petitioner therefore submits that such accusation is based on no material whatsoever. The petitioner had been a young probationer in the bank at the time when this anomaly was unearthed. Without his knowledge, his ID number appears to have been used. It does not appear from the entire records that the petitioner has been a beneficiary of such embezzlement or that he was acting on the dictates of some other beneficiary in an illegal manner. Considering the aforementioned submissions and the facts of this case, the petitioner is directed to be released, 10,000 to sureties. However, the petitioner is cautioned to participate in the investigation to the fullest. In case it is found that he is avoiding the investigative process or is not forthcoming with the information which he has, it will be open for the investigating agency to proceed for cancellation of his anticipatory bail. In that event, the court below shall proceed promptly in that direction.
May I please? 498, my lord, unfortunate husband, my lord.
Why unfortunate?
Unfortunate because
you have had good relation with your wife for some time, and now with this dispute, you will have another round of marital bliss or something.
It was not the allegation. She was undergoing.
Unfortunate is the wife.
Mental illness, my lord, she was undergoing. And concealing this fact, his marriage was solemnized.
Suppose, Mr. Counsel,
I was conducting treatment of her.
Suppose she would not have, she would have disclosed, she would not have been suffering from mental illness. And later in life, as your wife, if she would have fallen ill, would you have behaved like this?
But I am not behaving in any ill manner, my lord. I am always ready for treatment and I am conducting.
Now, what does the wife say?
The wife has only said that there was a demand of bullet motorcycle which she was not able to fulfill the same, and therefore omnibus and general allegation against all the.
What is the illness according to you?
My lord, I have annexed the.
If you don't treat your wife well, she goes in depression, and that's an illness.
This is not the allegation.
All right.
Indeed.
Now, what
Annexure 3, my lord,
defense? I mean, all this reaction on the court is only because of your opening argument that you are unfortunate that your wife is ill, and therefore it has evoked a sharp response from the bench.
Therefore, my lord, I am saying myself unfortunate. Annexure 3, my lord,
this should not have been your gambit argument.
Yes.
You don't begin your case with this, that my wife is suffering from mental illness. It's not done, it's not said. Unless you say that these are the grounds which makes it almost impossible for me to live with her, and taking this opportunity, a case has been lodged against me. This cannot be your gambit argument. I think I have communicated the fallacy of your argument. You can say that because you were insisting for treatment of your wife, which she was not agreeable to, and therefore the relationship has soured. I mean, if you have to conjure up a point, do it which is acceptable to the court.
She was undergoing treatment since 2014.
You can say this in a different way, that the allegation of ill treatment is bad. I have been spending money and time on her treatment. तो आप ये सब छोड़ के आप unfortunate she is ill. Starting argument कर देंगे तो बहस कैसे आगे बढ़ेगा? So you will hear all. Sorry. No, not sorry. A matter which could have been decided in 1 minute, you have made the court say so many things to you. Why? Mr. Sudhamas.
18 में शादी हुई है, 18 से इनका.
He is ready for settlement and negotiation. Are you ready?
Always.
My lord, ले दें. हम जाने के लिए कभी भी
दोनों चीज के लिए तैयार हैं. या तो ले जाएं और नहीं ले जाएं.
हमारे पास तो कोई ऑप्शन ही नहीं है. हुजूर से तो
वो तो
हम जाने के लिए तैयार.
जाने के लिए तैयार हैं और नेगोशिएशन के लिए भी तैयार हैं.
एक मेरे पास है लड़की हुजूर जो डिप्रेशन से सफर किए. अब हम क्या बोले?
करें क्या ये बताएं आप. बोलने की जरूरत नहीं है. हम करें क्या ये बताएं.
हमको ले दें और हम
क्या बोलेंगे?
अगर नहीं ले जाए, अगर ले जाने में कोई परेशानी है तो वन टाइम सेटलमेंट वगैरह एग्रीएबल हो गया
हुजूर ये
तो मैं खारिज कर दूंगा इनकी बेल। अगर उससे आपका फायदा हो तो मैं खारिज कर दूंगा।
ओम प्रकाश बोले हम लोगों की शादी जो अभी ऑल्दो बैड हो चाहे गुड हो, सिस्टम है उस जो लड़की
इंसेन वाला ग्राउंड नहीं लेंगे, वो बहुत डिफिकल्ट है टू, इट्स एन अपहिल टास्क फॉर यू टू प्रूव दैट।
I am not taking that ground, my lord. His
Don't take
father
that
has.
ground. That's an advisory from the bench. You may not be able to get any relief. Yes.
हुजूर इसके साथ तो ये है कि दूसरी शादी तो हो नहीं सकती, इसके साथ प्रॉब्लम यही है। और हुजूर एमए पास लड़के लड़की में कोई कमी नहीं है, ले जाए जरूरत है तो ट्रीटमेंट कराए हम लोग।
आप देखिए, explore the possibility and please be sympathetic and compassionate to a person with
I am
whom you have
always.
betrothed yourself.
I am always.
Heard Mr.
Om Prakash Upadhyay.
Heard Mr. Om Prakash Upadhyay for the petitioner and Mr. Sudama Singh for the opposite party number 2. The petitioner, who is the husband of OP number 2, seeks bail in anticipation of his arrest in connection with so and so. Though the accusation in the FIR is ill treatment because of non-fulfillment of dowry demand, but learned counsel for the petitioner has submitted that the story is otherwise. The marriage had been solemnized after concealing the mental illness of the opposite party number 2. Notwithstanding the aforesaid fact, the petitioner has been spending time and money over the treatment of his wife. For some reason or the other, the relationship between the spouses have now soured and they are staying separately. Mr. Sudama Singh, learned advocate for the OP number 2, however, has a different story to narrate. He submits that the opposite party number 2 has been suffering from depression because of the disturbed matrimonial relationship with her husband. It has been submitted that she is ever ready to enter into negotiations with the petitioner for an amicable settlement of dispute, preferably for resumption of matrimonial life. Mr. Upadhyay, learned advocate for the petitioner, however, learned counsel for the petitioner, submits upfront that the petitioner also would be desirous of exploring all possibilities of an effective and amicable settlement between the spouses, which would be good for both of them. Considering the aforesaid stand of the parties, this court directs that in the event of the petitioner surrendering before the court below within a period of 6 weeks, the same order.
May please, your lord. Anticipatory bail, my lord, under section 325, 353, 379 and 511 IPC. So far the allegation is concerned that
ये रखिएगा, उसका स्लैंटिंग ऐसे रहे, जो सब कोई एकदम कंफर्ट लेवल एकदम नहीं है इसमें। पैर के नीचे का करिएगा, इसको ऊपर उठा के नीचे करिएगा, so that I can read it like this. Yes.
anticipatory bail 325, 353, 354, 379 by 511.
Oh, that's true. What is the FIR? Let us see.
My lord. निवेदन पूर्वक कहना सूचित करना है कि मैं सहायक और निरीक्षक पवन कुमारी सिन्हा उम्र 100 वर्तमान में महिला थाना नवादा में पदस्थापित हूँ। कल दिनांक 7/6/20 को महिला थाना अध्यक्ष एवं सशस्त्र बल के साथ महिला थाना कांड संख्या 620 अंडर सेक्शन 498A में अभियुक्त की गिरफ्तारी हेतु न्यू एरिया राजेंद्र नगर नवादा के लिए थाना से समय इतना बजे प्रस्थान किए और समय करीब 17:10 बजे राजेंद्र नगर पहुंचे। विधिवत छापामारी कांड के नामजद अभियुक्त के घर पर छापामारी किया के क्रम में कांड के नामजद अभियुक्त मनीष रंजन पिटिशनर बिफोर लॉर्डशिप एंड मंजू देवी पति सो एंड सो को विधिवत छापामारी के क्रम में पकड़ा गया। प्राथमिकी अभियुक्त मनीष रंजन सशस्त्र बल के गृह रक्षक सिपाही सो एंड सो एवं मेरे तथा थानाध्यक्ष के साथ गाली गलौज और मारपीट करने लगे तथा जब सशस्त्र बल के गृह रक्षक सिपाहियों से रोकने का प्रयास किया तो उनका हथियार छीनने लगा जब मैं उसे रोकी तो उसे मेरा बायां हाथ मरोड़ दिया था, जहां था मेरे शरीर को पकड़ लिया, जिससे मेरा कपड़ा फट गया। मैं और मेरे साथ के सब गृह रक्षक सिपाही जख्मी हो गए। इसी बीच अभियुक्त हम लोगों को मारपीट कर जख्मी कर गए।
What has happened in that 498A matter?
498 मैटर में कॉम्प्रोमाइज हो गया, बेल हो गया, हमारी वाइफ कॉम्प्रोमाइज कर ली, सब काम हम लोग खत्म हो गया। ये ऑर्डर मेरे पास है, आ गया। कोई हम अकेले हैं, 5 गो सिपाही को अकेले कहता है, इम्पटी है ना, मेरे पास कोई गोली बंदूक न कुछ नहीं।
वो नहीं ठीक है, लेकिन 5 लोग इंजर्ड हैं, आपने बहुत ताकत दिखाई।
हमको धृतराष्ट्र
एक्सप्लेनेशन क्या है?
ना महाभारत के हम
एक्सप्लेनेशन क्या है?
एक्सप्लेनेशन है कि झूठा केस हम कर किया।
नहीं, वो एक्सप्लेनेशन तो
5 आदमी,
बेकार सा एक्सप्लेनेशन।
मेरे हाथ में एम्प्टी हैंड, खाली हाथ था।
लिखिए, heard Mr. Ramadya Singh, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. First off, the FIR has been lodged by a police officer alleging that when the police team had gone to arrest the petitioner and his mother in a case of dowry, in a case under section 498A, the entire police team was misbehaved with and were assaulted, leading to simple injuries on their person. First up, learned counsel for the petitioner has submitted that the case is absolutely false for the following reasons. First up, the dispute between the petitioner and his spouse was long settled. First up, the spouses are living together under the same roof as man and wife. First up, knowing this fact, the police party were trying to harass the family members of the petitioner and the petitioner himself. First up, this might have, it has been argued, resulted in some clash between the supporters of the petitioner and the police party. First up, the nature of injuries suffered by the police party does not reflect that any serious assault was made on them. Learned counsel for the petitioner therefore submits that it appears that because of the insolent behavior of the police party, there was some resistance from the side of the petitioner and his supporters, which has led to the lodging of the present case. Regard being had to the background facts, namely the settlement of dispute between the petitioner and his wife, the case for which a case had been lodged and the petitioner was sought to be arrested by the informant in the aforesaid case, having been settled, the petitioner is expected to be released.
Mr. Praveen Kumar Sinha.
पता लगा कि फाइनल हो गया, लेकिन क्लाइंट से में कोई इंस्ट्रक्शन नहीं है। हमको 1 सप्ताह का इसमें समय दे दिया जाए।
1 सप्ताह का समय तो नहीं दे पाऊंगा, क्योंकि ये केवल बेल का कोर्ट बना हुआ है, तो आप हमें कल पता करके बताएं, मैं जो भी होगा ऑर्डर पास करूंगा।
कल, नॉट टुडे, नॉट टुमारो, वेडनेसडे को कर देंगे।
आप कल भी पास ओवर करा लेंगे। If you don't get any information, make a mention. I will pass it over tomorrow also.
कॉन्टैक्ट नंबर नहीं हो, जो कॉन्टैक्ट
मैं तो कह रहा हूँ कि कल पास ओवर रहने दीजिए, कल फिर आप आएंगे, पूछेंगे, कहेंगे कि पास ओवर कर दीजिए, फिर पास ओवर।
Mr. Suresh Pandey.
Kindly pass over the demand. Kindly pass.
Mr. Mohammed Isam.
सुबह मांग रहे थे, विड्रॉ के लिए प्रयास कर रहे थे।
Where is he? Muhammad Irshad.
Yes.
Well, I don't know whether he is the person. Anyway, unless he comes up, don't write the order. But as of now, Muhammad Irshad himself had mentioned.
Yes.
You identify him?
Yes, sir.
Mr. Muhammad Irshad, learned advocate for the petitioner, seeks permission to withdraw this application. Dismissed is withdrawn.
Mr. Sanjeev Kumar Singh.
Mr. Sanjeev Kumar Singh, learned advocate for the petitioner, seeks permission to withdraw this application. Dismissed is withdrawn.
Mr. Ravi Gupta. Mr. Ravi Gupta.
case under section 307 and 27.
File, Mr. Yes.
This is case under section 307 and 27 R Act, my lord. कहते हैं कि वो पिटिशन पर एलिगेशन है कि मारपीट किया है, फायर किया है।
नो, ऐसा नहीं, बस करिए। आप FIR पढ़िए।
my lord, सुनने निवेदन है कि मैं सुनील कुमार पेशा स्वर्गीय स्वयं रामपुर स्वयं लखीसराय निवासी हूँ। श्रीमान से कहना है कि आज दिनांक 24/9/2019 को सुबह अपने बच्चा को स्कूल छोड़ने जा रहे थे। उसी समय रामपुर शहीद गेट पर मुकुल राम पिटिशनर मिला सर स्वयं ननो लखीसराय, वर्तमान में स्वयं नौघारा वानवटा निवासी हूँ। कोई अपना बुलेट मोटरसाइकिल से आया और गाली गलौज देते हुए बोला कि मेरा बालू वाला ट्रक पकड़वा दिए हो, हम तुमको जान मारेंगे, और अपने पास से पिस्तौल निकालकर हम पर फायर कर दिए, जिससे हम बच गए। इसके बाद हम पर हमला कर दिया, मेरा गला दबा रहा था और फेंट मुक्का से मार रहा था। फिर हमारे ग्रामीण उदय सिंह स्वयं मौके पर वहाँ मौजूद थे। उसने मेरी जान मुकुल कुमार से बचाई।
क्या नाम है आपका?
श्याम कुमार सिंह।
सरकार की तरफ
जी।
Heard Mr. Ravi Bhushan, learned advocate for the petitioner, Mr. Shyam Kumar Singh, for the estate. The petitioner seeks bail in anticipation of his arrest in connection with so-and-so. The accusation against the petitioner is of having opened fire at the informant and also assaulted him for the suspicion that he had got the vehicle of the informant. He had got the vehicle of the informant he had got the vehicle of the information vehicle and caught by the police. Mr. Appellant Counsel for जाओ उधर, तुम खांसते हो बहुत। The Land Council for the petitioner has submitted that there is no gunshot injury on the informant, and the injuries suffered by him are simple in nature, which could have been caused in any other transaction. First off, regard being had to the aforestated fact, namely dispute between the parties with respect to suspicion about the informant having been falsely implicated at the hands of the petitioner. The petitioner is directed to be released 10,000.
The petitioner has made an accusation under section 307 and 27 Arms Act, my lord. There is a specific allegation for open firing against Nagesh Kumar and Amarjit Kumar. The allegation against this petition.
FIR पढ़िए।
जी हाँ। मेरा नाम मनोज कुमार सिंह, उम्र 100। आज दिनांक 7/12/19 को समय 15:25 बजे शांति मेमोरियल आरा के रूम नंबर 7 में आप नवादा द्रोह जी के समक्ष अपने पूरे होशो हवास में बिना भय दबाव अंकित करता हूँ। दिनांक 6/12/19 को समय 9:40 बजे संध्या में अपने घर के दलान आगे खाट पर बिछाकर लेटे हुए, उसी समय दो मोटरसाइकिल पर दो आदमी सवार मेरे नज़दीक आकर रोड पर खड़ा किए। एक मोटरसाइकिल काला रंग के अपाची, दूसरा मोटरसाइकिल काला रंग का पैशन प्रो था। दोनों मोटरसाइकिल पर पीछे बैठा हुआ व्यक्ति मेरे पास आए और मनोज उठो, जिस पर मैं उठकर बैठ गया और दोनों व्यक्ति अपने अपने कमर से निकाला और दोनों व्यक्ति ने एक गोली मुझे मारा, जिसमें एक गोली पेट में, दूसरा जांघ में। मैं वहीं गिर गया, मेरे परिवार हल्ला के गोली मार दिया। इसके बाद दोनों मोटरसाइकिल पर जाकर बैठ गया और मोटरसाइकिल चालक पहले से स्टार्ट करते फायरिंग करते हुए उत्तर दिशा की ओर निकल गए। गोली मारने वाला व्यक्ति था मोटरसाइकिल चालक को पहचानता हूँ। पहला नागेश कुमार, दूसरा कल्लू, पिता स्वयं, तीसरा संतोष, चौथा अमरजीत। खुलकर पेट में गोली मारने वाला व्यक्ति का नाम नागेश कुमार, जांग मारने वाला व्यक्ति अमरजीत कुमार है। अपाची मोटरसाइकिल चलाने वाले व्यक्ति का नाम सतीश कुमार तथा पैशन प्रो चलाने का कल्लू कुमार है। That is allegation, my lord. The petitioner has not made any overact regarding this allegation.
Okay, I heard Mr. Manoj Kumar.
One thing.
I'll give you an observation. We are not granting anticipatory bail in a gunshot, even if you are not fired. We will say that the dispute was during celebrations in a marriage party, and that you are not supposed to have fired and you have only driven the motorcycle. These shall be taken into account while considering your regular bail. No anticipatory bail.
One thing, Lord. Both the parties have made compromise.
That I have seen.
And another thing,
We will
Lord,
record that.
your Lordship last time says that what type of injury? Nothing has been mentioned, Lord.
No gunshot.
No, gunshot injury is there, but nothing has been mentioned regarding the nature of injury.
Gunshot में मैंने लिखे.
But there is no allegation,
Heard
Lord.
Mr. Manoj Kumar, London.
Neither 307 is made out, nor Arms Act made out.
Anyway, heard Mr. Manoj Kumar, learned advocate for the petitioner and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so. The accusation in the first information report is that 4 persons came on 2 motorcycles and opened fire at the informant. The informant has been very specific in his accusation that the shot fired by 2 other accused persons and not the petitioner hit him in his abdomen and thighs. So far as the petitioner is concerned, he is only said to have driven one of the vehicles which was used for carrying the miscreants. Land Council for the petitioner has submitted that there was some dispute in the celebrations which had taken place in the previous night in a marriage ceremony. So far as the petitioner is concerned, he does not have criminal antecedents and is not attributed with any overt act. Apart from this, it has further been pointed out that the parties have now settled their dispute and the informant does not wish to prosecute the petitioner and others any further. He has also submitted that though the injuries suffered by the victim are of gunshot, but no nature of such injuries has been asserted. Be that as it may, considering the background facts in this case, I am not inclined to grant anticipatory bail to him, notwithstanding the fact that the parties have decided not to that the informant has decided not to prosecute the petitioner any further. The prayer for anticipatory bail is rejected. However, the aforementioned ground shall be taken into account while passing an order for regular bail should the petitioner surrender and pray for so. Should the petitioner surrender and pray for the same.
Same day कर दिया जाता हो कोई इंसिडेंट नहीं है, मेड आउट नहीं होता, दी सेक्शंस नोट मेड आउट.
जितना आपने कहा है उससे ज्यादा ही लिखा दिया है. Yes.
Offense under section 147, 149, 323, 307, 379.
What have you done?
हुजूर एलिगेशन है FIR is at page 10. मैं जानकी देवी रहने वाली हूँ ग्राम पंचायत काठन में ग्राम में वार्ड नंबर 11 में आंगनबाड़ी के सेविका के पद पर पट्टी नियुक्त हूँ. आज दिनांक 26/2010 को अपने केंद्र संख्या 149 पर चावल दाल एवं सोयाबीन बड़ी गर्भवती धात्री एवं बच्चे को वितरित कर रही थी कि इसी क्रम में समय करीब 12:30 बजे गाँव के रविकांत कुमार शाह उम्र 23 वर्ष पिता सुखदेव शाह साकिन हसाय थाना सो आए और बोलने लगे कि मेरे बच्चे का चावल दाल एवं बड़ी दो. तो मैं बोली कि आपके बच्चे का नाम सूची में नहीं है, तो आपके चावल दाल कैसे मिलेगा. यह बोलते ही चावल दाल इत्यादि सामान फेंकने लगा एवं गाली गलौज करने लगा. गाली गलौज देने के मना किया तो मुझे उठाकर जमीन पर पटक दिया जो मेरे सिर.
क्या नाम है आपका?
सुनील कुमार. सुनील कुमार.
Heard Mr. Sunil Kumar, learned advocate for the petitioner and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so. The accusation against the petitioners is of having assaulted the informant who is an Anganwadi Sevika and her family members for not having given goodies to them when demanded, on the ground of their not being enrolled as beneficiaries. The Land Council for the petitioners has submitted that the son of one Ravikant Shah, who has been attributed with the main allegation, is a beneficiary, and there was some dispute between the Anganwadi Sevika and the family members and the beneficiaries who are not being given the quantity of food grains to which they were entitled. This perhaps led to a minor scuffle. The injuries suffered by the victims are said to be simple and superficial in nature. The accusation against the petitioners is absolutely general and omnibus. Considering the aforesaid background facts and the claim of the petitioners that the informant, who is an Anganwadi Sevika, had not been distributing food grains in a proper manner, the petitioners are directed to be released and held.
Three 307, 302, my lord. All the petitioner was named in the FIR, my lord, but during investigation, police submitted final form against this petitioner, my lord. I have annexed Annexure 3 at page 19, my lord.
Differing with the report, cognizance has been taken.
My lord.
Or in complaint, cognizance has been taken.
Complete, total.
नहीं उसी FIR में
हाँ उसी FIR से, my lord. उसी FIR से
डिफर करके कॉग्निजेंस
ले लिया गया है। Annexure 3 पेज 19 पर हम ऑर्डर शीट दिया है।
एलिगेशन क्या है?
एलिगेशन जनरल और व्यवस्था महिला है।
बैकग्राउंड बताइए।
FIR पर इंटरनल पेज 5 पर मेरा नाम पप्पू राम पेशर सोनसो सौरी में अपना बयान पुलिस पर देता हूँ कि आज दिनांक 10/1/4/20 समय 6:30 बजे शाम में मेरी चचोरी पतोहू सुधिया देवी शौच के लिए खेत में जा रही थी। जैसे ही गांव के दक्षिण दलान में पहुंची तभी मेरे ही गांव के विकास कुमार विकास कुमार पेशर सोनसो जिला पटना में आकर मेरी चचेरी पतोहू सुधिया देवी के साथ गलत नीयत से छेड़खानी करने लगा। मेरी पतोहू किसी तरह से बचकर घर आई और घटना की सारी बात बताई अपनी चचेरी सास सविता देवी से। उसके बाद घर के सभी लोग पूछने के लिए उसके घर गए तो विकास कुमार, रहीश कुमार, संगीता कुमारी, चीफ पिटिशनर माय लॉर्ड।
How is she related to विकास कुमार?
गोतिया है, एक ही फैमिली मेंबर है। फैमिली विकास का तो फैमिली मेंबर में है, वो भौजाई लगेगी। रवि उर्फ जितेंद्र, पीटू सोएंसो, छठा रजनीकांत, सभी ने मिलकर मेरे भतीजा पंकज कुमार को घसीट कर अपने घर के अंदर ले कर चला गया और मेरे भतीजे पंकज कुमार को लाठी से मारने लगे। पंकज इंजर्ड है, जिससे मेरे भतीजा पंकज का सर फट गया। मारपीट देखकर मुन्ना राम पेशर सोएंसो वहां से भाग चला तो विकास कुमार पीछे से दौड़कर तलवार से उसके माथे पर मार दिया, जिससे मुन्ना कुमार बेहोश होकर गिर पड़ा। माथा से काफी मात्रा में खून निकल गया। हम सभी लोग दौड़ कर वहां पहुंचे तो देखे कि मुन्ना कुमार इंजरी सिंपल, एक इंजरी खाली पंकज को पाया गया। हमने लगा दिया
आपका नहीं। Heard Mr. Gajanan Mishra Leonard advocate petitioner and Muhammad Aslam Ansari for the state. The petitioner seeks bail in anticipation of her arrest in connection with Bhagwanganj PS case number so instituted for offences under sections 302, 307, 323, 341, 334, and 34 of the IPC. The accusation in the first information report is that one Vikas Kumar tried to outrage the modesty of the daughter-in-law of the informant. When this was protested, a scuffle took place in which Vikas Kumar is said to have assaulted Pankaj, who became injured. Later, one Munna was assaulted by opposite Vikas Kumar by means of a sword, which ultimately led to his death. So far as the petitioner is concerned, she is also named as one of the associates of opposite Vikas Kumar in repelling, in attacking the informant and the other family members of the victim woman. And counsel for the petitioner has submitted that the police, after investigation, found the accusation to be absolutely false so far as the petitioner was concerned and did not send her up for trial. However, differing with the police report, cognizance has been taken and cognizance has been taken against the petitioner also, and her prayer for bail, anticipatory bail, has been rejected. Mr. Appellate Counsel for the petitioner has submitted that even otherwise, except for being named in the first information report, there is no overt act against her. The petitioner is an agnate of aforesaid Vikas Kumar, and merely because she has sympathies with the family of Vikas Kumar, she too has been involved in this case. For the reasons aforestated and taking into account the gender of the petitioner, she is directed to be released in the event of arrest, surrender, and arrest.
Mr. Lokesh Kumar Singh.
Yeah, but who appears?
Mr. Lokesh Kumar Singh.
Any difficulty faced by the lawyers in finding courtrooms?
Yes, that is correct. Yes.
I'm not giving any long date. Maybe the advocate.
Passover, yes. 270. Mr. Rajesh Roy.
Maybe pass over a few cases.
Why?
Advocate Ravinder Kumar had to argue.
Where is your file? आइए खड़े हो. The court will help you. Had you not been a young counsel, maybe I would have allowed your prayer. But you're the file and you're before the court. Let us see how the court can give you some
allegation.
बोलिए.
The allegation is under 304, 307, 379.
307 and 379.
There are available of lordship. The allegation is that
FIR पढ़िए.
न्यूयॉर्क का कहना है कि कलानी द्विवेदी आज दिनांक 8/5 दिन शुक्रवार समय करीब 2 बजे दिन में मेरे भसूर का लड़का करण कुमार गोंड वो मोहन कुमार गोंड क्रिकेट अपने बगीचे में खेल रहा था. उसी समय संजय गोंड वो प्रदीप गोंड वहां पर आए और बोले कि हम लोग भी क्रिकेट खेलेंगे. मेरे भसूर का लड़का खेलने से मना किया. इसी बात पर संजय गोंड वो प्रदीप गोंड मेरे भसूर के लड़के को मारने लगे. हल्का अगला होने पर मैं वहां गई और इसी बीच बाद में मेरे पति हरकेश प्रसाद गोंड संजय गोंड के घर पूछने गए. इस पर सभी व्यक्ति संजय गोंड रामश्री गोंड उम्र 30 वर्ष, दूसरे प्रदीप गोंड रामश्री शीश गोंड उम्र 28 वर्ष, तीसरे शिवशंकर गोंड स्वर्गीय
छोटी सी बात के लिए आपने बहुत लड़ाई कर ली.
Lordship, this is a counter case, and one case I already filed. This is an extra 2 lordship. That Prathamiki 53. That is my the petitioner's mother has Shilwanti Devi have filed. Actually, the case is that the informant husband is Jal नल योजना चलाते हैं लॉर्डशिप, और उसमें गड़बड़ी कुछ हुआ तो पिटिशनर की मां ने पिटिशनर ने उस पर कुछ कंप्लेन किया था. इस पे आके उन्होंने वहाँ हंगामा किया और मारपीट किया था. तो उस पे इन्होंने प्राथमिकी दर्ज किया था 53 और उसके काउंटर में इन्होंने 54 किया है लॉर्डशिप.
इंजरी का नेचर कैसा बताता
सिंपल है लॉर्डशिप. हमने सप्लीमेंट्री फाइल किया है, उसमें इंजरी सिंपल है लॉर्डशिप.
और आपकी तरफ से जो आपकी मां ने जो केस किया है उसमें जो एक्यूज पर्सन है उन लोगों को बेल हो गया है. इंजरी कैसा है देखें. सप्लीमेंट्री आप अपनी फाइल दें, खोल कर दिखाइए. तो आप यहाँ पर वो नहीं रखा है.
नहीं किया हुआ नहीं किया हुआ है.
चाकू से किसको मारने का इल्जाम था?
नीचे में सप्लीमेंट सिंपल है लॉर्डशिप.
हम बता देते हैं हमको कहाँ नहीं होगा.
देखते हैं. आपने बहस किया है तो अभी केस डायरी मांगते हैं. नाइफ कट इंजरी है, आपको इंटरिम प्रोटेक्शन भी देते हैं. लेकिन ये वो क्रिकेट के खेल के लिए जो लड़ाई की है आपने वो ज़्यादा प्लॉजिबल लग रहा है, और वो जलधन वाला थोड़ा हमें गलत लग रहा है.
ये जनरल
वो कुट्टल कहानी लग रही है। आपका है कि आपने बहुत
ये एक दिन बाद इन्होंने केस किया है, हमने तो उसी दिन किया जिस दिन हुआ है ये जनरल वाला लॉर्डशिप।
उसी दिन किया है
लॉर्डशिप इन्होंने एक दिन बाद किया है ये, बल्कि दिस इज अ काउंटर ब्लास्ट केस ऑफ देम ऑन अस।
प्रदीप गोंड का क्या हुआ है? यू हैव नो आइडिया? देखिए क्या नाम है आपका?
आनंद वर्धन।
Heard Mr. Anand Vardhan, learned advocate for the petitioner and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so. The accusation in the first information report is that the petitioner and one Pradeep Gond assaulted the members of the prosecution party for having tried to preempt the petitioner and his friend from playing a game of cricket. The petitioner has a different story to narrate. He has alleged that his mother had earlier filed a case against the father of the victim for having not done or for having not executed the Jal Nal program in an effective manner. The injuries suffered by the victim at the hands of the petitioner is stated to be simple in nature, but with a knife, which is a sharp cutting weapon. Call for the case diary and list this matter on receipt of the same on give a date in February end. 22nd of February. In the meantime, the petitioner, in the event of his arrest or surrender, shall be released on provisional bail on his furnishing bonds in the sum of 10,000 to be or a lease of life.
They took the secretary bail offense under section 379 other minor offense. FIR page 11 पर है। पता है जी? निवेदन पूर्वक कहना है कि मैं मैं अपने परिवार के साथ घर पर था इसी समय वीरेंद्र यादव, अंशु कुमार, रामविलास यादव, कृष्णा कुमार, अमन कुमार, किशोरी यादव, ये सभी ग्राम कल जिला गया के निवासी हैं। ये सभी लोग हथियार और रॉड लेकर गाली गलौज देते हुए मेरे घर में घुस गए, जिसका मैंने विरोध किया तो वीरेंद्र यादव अपने हाथ में लिए देसी कट्टा मेरे सर में सटा दिया और मेरे गले से 3 भर सोने का चेन छीन लिया। इसी बीच संतु कुमार ने जान मारने के इरादे से लोहे का रॉड मेरे सर पर मारा, जिससे मेरा सर फट गया, खून से लथपथ होकर गिर गया। इसी बीच मेरी भाभी मंजू देवी बीच बचाव करने आई तो रामविलास यादव ने मेरी भाभी के साथ अभद्र व्यवहार करते हुए गले से मंगलसूत्र छीन लिया। यही है एलिगेशन योर लॉर्डशिप। हमने भी केस किया है जो एनेक्सर 2 में लगा हुआ है मुझे, और ये इन लोगों के बीच एक सिविल डिस्प्यूट।
क्या नाम है आपका?
पृथ्वीराज।
Heard Mr. Prithviraj Singh, learned advocate for the petitioner and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so. The accusation in the first information report is of the petitioners and others having entered the house of the informant and misbehaved with the female inmates and also assaulted some of them. Lead counsel for the petitioner has submitted that a day prior to the lodging of the subject FIR, one Urmila Devi, mother of one of the co-accused persons, namely Santu Kumar, had lodged an FIR against the informant and other members of his family while Magad Medical PS case number 153 of 2020. There is land dispute between the parties and a title suit number 11 of 2005/153 of 2005 is being contested between them. The report of the Amin, it has been brought to the notice of this court, reflects that the land of the petitioner has been encroached by the informant. On the aforesaid grounds, and that except for 379, all other offences available, the petitioners have prayed for anticipatory bail. Considering the submissions aforesaid, the petitioners are directed to be released 10,000.
May I please, Your Lordship? Offence major section under 365 of the IPC, Your Lordship. Date of occurrence, Your Lordship, 9/9/2018, Your Lordship. Prosecution case is that, Your Lordship, husband of the informant was missing on
FIR.
9/9.
Read the FIR.
My-
Mukul Tiwari.
FIR has been lodged on the basis of complaint case, Your Lordship.
पढ़िए।
My Lord. यह कि परिवादिनी के पति ने लीज पर खेती करने के लिए लिया हुआ था, उसी में धान का फसल लगाया था। दिनांक 9/9/2018 को परिवादिनी स्वर्गीय इसका पति और उस लड़का दोनों धान की सोहनी करने गए और लौटने के क्रम में अपराह्न 7 बजे संजय पासवान आया और बोला कि उपेंद्र पासवान बुला रहा है, कुछ काम है। परिवादिनी दिस पिटिशनर लॉर्डशिप उपेंद्र पासवान बुला रहा है, कुछ काम है। परिवादिनी के पति संजय पासवान के साथ चले गए। यह कि शाम तक परिवादिनी के पति नहीं आए तो परिवादिनी संध्या 7 बजे खोजबीन करने लगी तो अन्य गवाह
ये आपने ओबरा पीएस केस नंबर 25 of 2000
My Lord,
तो किसके तहत है?
Son of the informant has given an application on the same very day, Your Lordship, that his father was found missing. May kindly see annexure 2, Your
Diary.
Lordship.
That's right.
Annexure
Diary there. Call for the diary. वाला पैराग्राफ लिखने के बाद लिखिए।
In the meantime, Your Lordship.
ये केस मीन टाइम वाला नहीं है, रहने से मैं खुद
Your Lordship, after 3 months, prosecution case.
नहीं, that's true.
Complaint
We
case
will grant you only after seeing the
Several
diary.
situated persons have been granted bail, Your Lordship. May kindly consider annexure.
Regular bail, anticipatory bail.
Anticipatory bail, Your
नहीं
Lordship.
तो आपका केस औरों से डिफरेंट है। You are the person who called. ये इसमें एंटिसिपेटरी बेल फर्स्ट इंस्टेंस में मैं बिना डायरी देखे नहीं दे सकता।
In the meantime, Your Lordship.
कर देंगे। अब जब ऐसा रहता है तो मैं खुद ही कर देता
Your Lordship,
हूँ। Without asking, I grant interim protection in diary.
Your Lordship, इतना दिन बाद केस टेक अप हुआ है। May kindly consider. No foreseeable stay.
हमें कुछ रीजन देना होगा ना, ऐसे तो होगा नहीं। आप डायरी के बाद आइए, फिर मैं देखता हूँ। पहला पैराग्राफ लिखिए, call for the case diary and list this matter on receipt and same. I am fixing an early date. जब आ जाएगा date. But you have been rather persuasive. मैं 2-3 बार सोचा कि anticipatory bail दे दूँ interim protection, but I don't think it would be appropriate. Let me see the diary. Re-notify on receipt of the same on 10th of April.
Mr. Ramakant Yadav.
May please also petition for anticipatory bail. Offense under section 4.
Louder, mister. Louder.
Application for anticipatory bail under section 493, 376, 504/34 of the IPC and 4/6 of the Act. Case is, my lord, who accused Ramesh Paswan made physical relationship with informant and after pregnancy made pressure for miscarriage. Thereafter informant denied or same and contact the महिला helpline.
एक सेकंड जरा सा आप रहने दें, मैं FIR जरा पढ़ लेता हूँ, इसके बाद बहस करेंगे आप। It's a long FIR.
Long.
Have you provided the typed copy?
Lord, next sir, next FIR के बाद next copy है।
ठीक है। ये एड्रेस ठीक कराइएगा। आपका नाम कैसे आया है? आप लोग कौन है?
हम लोग फैमिली मेंबर हैं रमेश पासवान के।
फैमिली मेंबर मतलब क्या है? फादर है?
फादर हैं सुरेंद्र पासवान इज द फादर में लॉर्ड।
मदर है?
देवी मदर।
लखिंदर भाई है?
लखिंदर पासवान इज भाई हैं और एक
भाई नहीं हो सकते, 50 साल के हैं ये।
और एक फुफेरी बहन।
आप रिलेशनशिप ठीक से बताइए।
क्या तो बताइए।
Where is Ramesh Kumar?
Ramesh Kumar is
Where is he? Has he surrendered in the process of law?
Anticipated file में लॉर्ड।
नहीं। Sorry, बहुत लंबी चौड़ी कहानी है। मैं लेडीज को पूजिता कुमारी को मैं अभी इंटरिम प्रोटेक्शन दे सकता हूँ, रीता देवी को भी दे सकता हूँ, लेकिन आप उसे सरेंडर कराएं।
आफ्टर सरेंडर यदि हम लोग सरेंडर करते हैं तब इन लोगों को बेल दिया जाए।
ऐसा तो ऑर्डर नहीं करूंगा, सरेंडर कराना मेरा काम नहीं है। मैं कन्विंस तब होऊंगा बेल देने के लिए, वो कहूंगा नहीं। मैं और सबके लिए डायरी मांगता हूँ और 2 और 4 को मैं इंटरिम प्रोटेक्शन देता हूँ। देखते हैं क्या है। आपका है नहीं कुछ, बट द काइंड ऑफ स्टोरी व्हिच हैज बीन नरेटेड इन द एफआईआर, without your support, without your active assistance, this would not have happened.
दो लाइन बताता हूँ, ये हैबिचुअल है और केस है इन पर। दूसरे केस के साथ जैसे केस फाइल की थी वो फाइल किया, इनके चल रहा है 3-4 केस है इनके ऊपर दूसरे किसी के साथ। ये हैबिचुअल है, मैं लिखा हूँ।
वो लिखना तो गलत किया है ना आपने, वो सब तो नहीं लिखा जाता है। किसी महिला के चरित्र के बारे में ऐसा अगर आप लिखेंगे तो बेल से महरूम हो जाएंगे। आप अपनी बात कहें, उनके बारे में नहीं। आप उसी चीज को कह सकते हैं कि हमारे जैसे अन्य लोग भी हैं जिनके अगेंस्ट उन्होंने मुकदमा किया है, और इतना ही बोलकर चुप हो जाए। यस, स्टोरी बड़ा वियर्ड सा स्टोरी है, 4 पन्ने में 5 पन्ने में।
डायरी इसमें आई थिंक दैट नेसेसरी टू कंफर्म।
Heard Mr. Ramakant Yadav, learned advocate for the petitioner, and Mr. Rampriya Singh for the state. The petitioners seek bail in anticipation of their arrest in connection with so-and-so. The prosecutrix has alleged that she was always being stalked by one Ramesh, and when she became pregnant with him, aforesaid Ramesh got her aborted on 2 occasions. The promise to marry her by Ramesh still remains elusive. So far as the petitioners are concerned, it has been alleged that they have given tacit support to the illegal activities of aforesaid Ramesh. Mr. Appellate Counsel for the petitioner has submitted that Ramesh is not the only one who is being prosecuted by the prosecutrix with such an accusation. First up, there are many others also. Apart from this, it has been submitted that there is no direct accusation against the petitioners except for their being related to aforesaid Ramesh. Call for the case diary and list this matter on receipt of the same on 16th of February. The लिखाने के क्रम में मुझे लग रहा है कि सबको इंटरिम प्रोटेक्शन मिल जाना चाहिए। In the meantime, the petitioners, in the event of their arrest or surrender, shall be released on provisional bail on their furnishing bonds in the sum of 10,000 to sureties.
So, Judge Pandey.
Offense under section 3.
You are Prajit Pandey?
No, Lord, may Rajesh Kumar Sinha.
All right. This question is only for identifying the advocates. But
Rajesh
somebody
Kumar.
else used to appear on the name of Prajit Pandey. I don't have any problem. You can appear, but as far as my memory goes, you're not Prajit Pandey.
Yeah.
All right. Yes.
I mean, that offense under section 3.
What is your name?
Rajesh Kumar Sinha.
You are also one of the advocates
Yeah.
on record. All right.
Offense under 307 Milord, or petitioner or informant both are own brother
Own brothers.
ये मिला वो लैंड डिस्प्यूट मकान का बंटवारा था उसी के लिए झगड़ा हुआ
Assault कैसे किया है आपने?
जो इंजरी सिंपल है एनेक्स
कैसे किस चीज से assault किया? तलवार से, लाठी से, डंडा से?
तुरंत जो पढ़ के सुना
जानकारी रहनी चाहिए ना, पढ़ने की क्या जरूरत है, पढ़ेंगे तो हम।
उस ये राजेंद्र मंडल मेरे साथ
How many persons have been injured?
1 or 2 है मेरा। अयोध्या मंडल और अमित मंडल ने ईंट और पत्थर से मारा।
पोजीशन में स्पेसिफिक नहीं बोल रहे हैं वकील साहब, आई एम नॉट हैप्पी। और ठीक है, इंजरी सिंपल है, भाई है, प्रॉपर्टी का डिस्प्यूट है,
ईंट और पत्थर से मारा है।
वो ठीक है। कितने आदमी इंजर्ड हैं ये बताएं?
How many persons?
3 पेज की पिटीशन में 3 लाइन की बहस है। अब वो आप सोचेंगे तो
बाप बेटा है, 2 लोग हैं।
मुझे हैं जो कितने इंजरी इसको बताएं, कितने इंजर्ड हैं?
और एक कोई केस का बेल हो गया है जो क्रिमिनल में 7-5
that doesn't convince me. Heard Mr. Rajesh Kumar number 1.
Rajesh Kumar Sinha.
Heard Mr. Rajesh Kumar Sinha, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. The petitioner and the informant are own brothers and there is a dispute between them with respect to partition of family property. The petitioner and others are said to have resorted to brickbats leading to simple injuries on 2 of the victims. Regard being had to the background facts and the relationship of the parties death
May please see the application for anticipatory bail. Major offence below 307, it will be 354. The informant allegedly stated below that
FIR.
Yes, look, that is relevant to this point. 17.
Yes.
The informant alleges that all the 4 petitioners, they allegedly entered into her house, assaulted her with knife and iron rod on her head. 3 were on ground. Saurabh and Sachin Milord pulled her sari, tried to tease her and took away the ornaments. But so far as the present informant is concerned, she is the own Gotini of petitioner number 1 and own aunt of petition number 3 and 4. Now the father of petition number 3 and 4 and husband of petition number 1 died not while these 2 were the minor kids.
नहीं क्या relationship ऐसा पता ही नहीं चला. Informant is the
husband of the informant and
husband of the informant is the Gotni of petitioner number 1. And aunt of 3 and 4.
4 and mother-in-law, cousin mother-in-law of petitioner number 2.
cousin mother-in-law of petitioner number 2. 498 का मामला था क्या?
जी नहीं, वो पहले हुआ था उनके घर से. इनके हस्बैंड मर गए पहले.
इनके हस्बैंड?
petitioner number 1 के. तो her husband became the कर्ता of the family. They all are
petitioner के husband मर गए तो
informant के husband करता हो गया family के. इन लोग का सारा प्रॉपर्टी को virtually बेदखल कर दिया था. Still today they are living in the same common angan, same house, ancestral house is there. Now when the boys have become grown up, one is married, another is the student of graduation. He has graduated and pursuing the studies. This dispute has arisen.
But Mr. Ajay, yes?
My lord, there appears to be no specific allegation, my lord, but 3 injuries have been found, my lord.
3 injuries on whom?
Nil informant to the informant.
कैसा injury?
One of the injury number 3 is appears to have been grievous.
घर के आंगन की लड़ाई है. Criminal नहीं.
That's not.
Criminal नहीं. Heard Mr. Ajay Thakur, learned advocate for the petitioner, and Mr. Surendra Kishore Thakur for the informant. The state is represented by so-and-so. The petitioners seek bail in anticipation of their arrest in connection with so-and-so. The accusation against all the petitioners is of assaulting the informant and other members of our family. The Stockland Council for the petitioner has submitted that there is a family dispute between the petitioners and the informant. The petitioner number 1 is the own sister-in-law of the informant. The husband of, after the death of the husband of petitioner number 1, the husband of the informant became the karta of the family, and he, in a dishonest way, has divested the petitioners from the family property. In fact, even today, despite such disturbance having been created for the petitioners, they have been residing in the same courtyard. The petitioner number 2 is the wife of petitioner number 4, and petitioner number 3 and 4 are the nephews of the informant. Though one of the injuries suffered by the victim is stated to be grievous,
all sick.
though the informant has received, though one of the injuries suffered by the informant is reported to be possibly dangerous to life, but considering the background facts where parties are residing in the same house and there is a dispute with respect to apportionment of family property, the petitioners are directed to be released in the event of arrest or surrender 10,000.
Case 23. Mr. Dr. Om Prakash Om.
My Lord, anticipative offense under section 135 of Electricity Act. My Lord, the instant FIR has been instituted.
Subject to the deposit of 50,000, we are granting you bail before the concerned authority. Go and deposit. Under protest, with your rights and obligations intact, we will contest it. ये बिजली चोरी बड़ा झंझट है, पैसा जमा कर दीजिए. I am not asking you to deposit 83,947. Deposit 50,000 upfront before the concerned settlement officer, whoever is the officer.
इंस्टॉलमेंट में हुजूर
नहीं, 50,000 में इंस्टॉलमेंट क्या है? इतनी बिजली जला रहे. फीस इंस्टॉलमेंट में तो नहीं लिया था मिस्टर ओम प्रकाश को. हम subject to your rights and contentions later, the money shall be returned to you if the accusation is found to be false. I think that will be the end of the prosecution. Do it. You want to take instructions from your client? I don't think so. The order would be contingent on your making payment. If it doesn't pay, all right, he surrenders and takes bail.
कर दिया जाए.
कर दें. Heard Dr. Om Prakash Om, learned advocate from the petitioner. आप इतनी जल्दी कैपिचुलेट कर गए क्यों? केस बताते कि क्या है केस?
केस तो जो है हम
गलत केस हो सकता है.
ये हुजूर हम यहाँ भी गए हुए हैं शिकायत निवारण अधिकारी, वहाँ सुपरिटेंडेंट इंजीनियर
शिकायत निवारण में गए.
जी जी.
NH
2 पेज 17 हुजूर देखा जाए, हमने ऑर्डर भी लगाया हुजूर. सुपरिटेंडिंग इंजीनियर को मतलब वहाँ से डायरेक्शन.
आपने कौन सी लाइन से थेफ्ट की? क्या हुआ था?
LT से दिया हुआ है.
LT क्या हुआ?
वो कुछ डायरेक्ट लाइन होता है हुजूर, उसमें से दिया हुआ है. और हम लगातार हुजूर 2013 में मतलब उसका कनेक्शन लिए हैं. 2017 तक हम लगातार.
लोक शिकायत निवारण क्या हुआ? ये पब्लिक ग्रीवेंस रिड्रेसल सेल. ये बिजली विभाग वाला तो नहीं है, ये पब्लिक जनरल पब्लिक रिड्रेसल.
जी जी. तो वहाँ भी हम हुजूर गए हुए थे.
और उन्होंने डायरेक्ट किया था कि सुपरिटेंडिंग इंजीनियर टू ड्यूली इंक्वायर.
जी जी.
तो ये सब बात क्यों नहीं बताया आप? हमने शुरू में कह दिया, आप मान गए. बड़ा डिस्प्यूट है इसमें.
जी 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 डिस्प्यूट है.
तब आपको मैं जमा करने क्यों कहूँगा?
आप
बताएंगे तब मतलब ऐसी जनरल बात का.
वहाँ हुजूर इंक्वायरी करने के लिए भी वहाँ का फर्स्ट
इंक्वायरी हुई
ना? कुछ नहीं है.
Heard Dr. Om Prakash Om, learned advocate for the petitioner and so-and-so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so-and-so under section 135 of the Electricity Act. The petitioner is said to have stealthily consumed electrical energy to the tune of rupees 83,947. That counsel for the petitioner has submitted that his electrical line was disconnected and he reported the matter to the public grievance redressal cell. The grievance cell directed the superintending engineer of the electricity department to look into the matter and pass necessary orders. No decision as yet has been taken at the level of the superintending engineer of the electricity department. The claim of the informant of the petitioner having misappropriated electrical energy unauthorizedly to the tune of 83,947 is absolutely false. Instead of settling the dispute, the department has chosen to falsely prosecute the petitioner. Considering the aforesaid background facts, the petitioner is directed to be released and filed. हमेशा कोर्ट की विधि से विड्रॉ नहीं कर लेना चाहिए। पॉइंट हो तो बहस करनी चाहिए।
3 days time may be given. File our supplementary.
क्या है supplementary?
Actually, one sentence is incorrect in paragraph 6. Last sentence.
We will permit you to correct it during the course of the day. Supplementary affidavit may not be required unless it relates to the name or the PS case number. If there are minor corrections, we will allow you to do it now.
Then I am ready, sir. That's it. There is allegation under section 406 of IPC.
All right. Only
the petitioner. The allegation is the accused number 3. Yes.
Complaint case है ना? 406 का.
Yes.
पार्टी बनाया है?
हाँ बना. इसमें no lord sir.
इसमें पार्टी बनाया है?
No lord sir.
बनाया है?
अरुण कुमार सर yes काफी दिन के बाद एकाएक कराया मैसेज की।
तो आप काफी दिन के बाद फाइल तो नहीं देख रहे ना? फाइल तो पढ़ के आए होंगे?
Yes lord sir.
तो ठीक है। और कौन सा करेक्शन करना है?
पैराग्राफ 6 में लास्ट सेंटेंस जो है ना, the petitioner is one of directors of Universal Microcredit Service. I am neither the director of bond issuance company not this company herein mentioned.
कंप्लेंट केस 406 का है, मैं नोटिस करूंगा, भेज दूंगा। वो करेक्शन उस दिन करेंगे आप। वो तो जो आपने पिटीशन में लिखा है वो उससे बेटर पोजीशन आपका है, इसलिए अगर कुछ अपने मन से आप लिख दिए होते हैं गलत वो ठीक है, ये आप कह सकते हैं कि दैट स्टेटमेंट इज इनकरेक्ट। लिखिए, heard, what is your name?
Kuldeep Sahai.
Heard Mr. Kuldeep Sahai, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with complaint case number so and so, in which cognizance has been taken under section 406 of the IPC. Let notice be issued to OP number 2 on the steps being taken by the petitioner within a period of 2 weeks, both modes, 2 सप्ताह में हो जाएगा, period of 2 weeks, both modes, returnable on 28th of February. So the petitioner in the meanwhile, in the event of his arrest or surrender, shall be released on original bail 10,000.
25, Mr. Sanjeev Kumar.
May please. 379 and other sections of IPC and 27 of the Arms Act. There is case and counter case. My case is annexure 2, my lord.
379 में काउंटर केस क्या होता है? कौन सी चीज चोरी किया है?
चोरी नहीं किया, कहते हैं कि हमारे खेत के फसल को लूट रहे थे, और जब वहाँ मना करने गए तो कहते हैं पिटिशनर अदर्स के बारे में क्वालिफाइड किया। जी हाँ, मेरा भी सेम केस है हुजूर, लैंड डिस्प्यूट है, जो कहते हैं हुजूर प्लॉट नंबर 2 और खाता नंबर 2।
एक सेकंड
जी
ऑन द बेसिस आप फूलो देवी कौन है?
फूलो देवी है हुजूर प्रेजेंट केस का इंफॉर्मेंट, इन्हीं के नाम से हुजूर कहते हैं, मेरे नाम से ही जमीन है।
और एफआईआर किसने फाइल किया? फूलो नहीं?
फूलो नहीं। और एनेक्चर 2 में जो इंफॉर्मेंट है उसके बटाईदार हुजूर हम हैं, एनेक्चर 2 के इंफॉर्मेंट के हुजूर हम बटाईदार हैं।
एनेक्चर 2 तो काउंटर ब्लास्ट बाय वन फूलो, इंफॉर्मेंट तो फूलो नहीं है ना?
तो इंफॉर्मेंट हुजूर फूलो के हुजूर बटाईदार है।
इंफॉर्मेंट है इसके संजय महतो, और फूलो जो है सो काउंटर केस फाइल की है।
काउंटर केस
आप फूलो के आप बटाईदार हैं?
फूलो के बटाईदार
वो कहिए ना। और ये संजय महतो और फूलो में क्या है? दोनों
को भी
फैमिली से आती हैं या प्रॉपर्टी परचेज किया है?
प्रॉपर्टी परचेज भी नहीं किया हुजूर, को भी लेजर है, दियारा का हुजूर खेत है। जब गंगा जी हुजूर करके जाते हैं क्लेम करता है कि ये खेत मेरा है, ये खेत मेरा है, यही डिस्प्यूट है।
Heard, learned counsel for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. The accusation against the petitioner and others, and about 40 others, is of having made attempts at reaping the standing crops in the field claimed to be of the informant. The Stopland counsel for the petitioner has pointed out that there is a dispute regarding the ownership of the land which has come in existence because of the accretion, because of the alluvial accretion of the river. The counter case has been lodged by another claimant to the property of whom the petitioner is only a bataidar. Because of the petitioner being associated with Phulo Devi, the author of the counter version of this case, he has been made accused in this case. For the reason of a dispute between the two claimants over a plot of land, and the reason for falsely implicating the petitioner in the present case with general and omnibus allegation is directed to be released 10,000.
Mr. Pankaj Kumar.
May I permitted to withdrawal of this case?
Mr. Pankaj Kumar, Pankaj Kumar है?
नहीं, संतोष कुमार.
तो नाम बताएंगे ना? Mr. Santosh Kumar, on instructions of Pankaj Kumar, advocate on record, seeks permission to withdraw this. Dismissed is withdrawn.
27, Mr. Amit Kumar Anand.
Yeah, I plead, Lordships. There is an application for grant of anticipatory bail, Lord, under section 354B and 509A, 509B, 76 of the Indian Penal Code, Lord, and 3 of the POCSO Act,
FIR.
Lord,
You are Mohan Kumar.
Yes, my Lord. Annexure 3, page 19, my Lord.
FIR Annexure 3 थोड़ी होगा. 164 बाद में देखेंगे.
My Lord.
पहले FIR देखेंगे.
My Lord. Page 12, my Lord.
Yes.
पढ़िए. सबने निवेदन है कि मैं राधा कुमारी उम्र 17.5 वर्ष, पिता चरित्र बुसाक साकी गंधर्व, थाना 17 जिला 17, विद्यालय में 9वीं कक्षा की छात्रा हूँ। 10/8/20 को मैं अपनी बहन अनिता देवी के साथ अनिता देवी के घर पर थी। उस समय अनिता देवी काम में बायसी गई थी। लगभग 10:30 बजे मेरे मौसी सब्जा देवी का लड़का मोहन कुमार बुसाक उम्र,
ठीक है, छोड़ दीजिए, मैं पढ़ ले रहा हूँ। Heard Mr. अमित कुमार आनंद, लर्नेड एडवोकेट फॉर द प्रिम। शादी इसकी उम्र 17 साल की है, शादी कैसे कर लिया आपने?
17.5 साल उस समय था।
शादी कब किया? 17.5 साल नहीं था, अपनी उम्र 17 बता रही है।
FIR में तो है 17.5।
FIR में 17.5, 164
ऐसे 1/1/2003 का हुजूर ये है, आधार कार्ड है।
साथ रह रही है?
जी जी।
आपकी मौसेरी बहन है?
यस।
क्या करते हैं? एक तो माइनर है, दूसरी आपकी बहन है, ये इंसेस्चुअस मैरिज है। and I don't believe this statement. आपने उस पर जबरदस्ती करके लिखवा लिया है कि
164
है, पारिवारिक प्रेशर डाल के आप मजिस्ट्रेट के सामने करवाया है।
साथ रह रही है।
Heard Mr. Amit Kumar Anand, learned advocate for the petitioner and sons of the state. The petitioner seeks bail in anticipation of his arrest in connection with so-and-so. The accusation against the petitioner is of having misbehaved with the victim and also of having raped her. Learned counsel for the petitioner has submitted that he is the son of the aunt of the victim, and therefore the accusation is absolutely false. In fact, the petitioner and the victim were carrying on amorous relationship amongst themselves, but when the matter was reported to the elder members of the family, such a case was lodged by the victim for giving herself a protection from the onslaught of the relatives. However, later the families decided that the petitioner and the victim should get married. Today the petitioner is living as man and wife with the victim. Stop. This statement is borne out from the 164th statement given by the victim before the learned magistrate. Considering the aforesaid background facts, 10,000.
K20 Secretary Bill for offence under section 30A and C of the
Excise Act.
Yes. 5 लीटर घर से गिला है.
घर से तो 1 लीटर भी दिक्कत है. घर के बाहर से हो तो फिर मैं 1000 में भी करता हूँ.
असल ये लोग मुसहर लोग हैं, लोग का तो घर वैसा ही रहता है.
घर वाला तो बड़ा मुश्किल है. वो कानून के खिलाफ तो जाएंगे.
मजबूत रहता नहीं है कि पक्का के घर हो, मिट्टी का घर बना हुआ रहता है.
घर के पीछे बगीचे में कहीं भी रहता तो मैं पूछता भी. घर में कानून हमारे आगे आ जा रहा है.
5 लीटर ही केवल है, कोई क्रिमिनल एंटिटी
साहब. 50 लीटर 100 लीटर मैं डिस्टिंक्शन कहाँ करता हूँ. बस घर से नहीं होना चाहिए और पहले का मुकदमा नहीं होना चाहिए. यही उपाय है. और तो कानून अभी तो बदला है. I'm so sorry for not allowing anticipatory bail, but nonetheless the law prevents me.
Not renewal ऐसे में आ जाता है.
Heard Mr. What is your name?
Prithviraj.
Heard Mr. Prithviraj Singh, learned advocate for the petitioner and so and so for the state. पहला पैराग्राफ लिखने के बाद लिखिए. In view of recovery of 5 liters of liquor from the hut of the petitioner, I am not inclined to grant anticipatory bail to him, notwithstanding the fact that he is a person of clean antecedent. Stop. The prayer is rejected. The prayer for anticipatory bail is rejected. Should the petitioner surrender before the court below and seek bail, the aforementioned ground shall be taken into account, and an order shall be passed without being prejudiced. The fact that the present petition on his behalf has not been made.
I want to withdraw my lord. Petitioner is arrested, my lord.
Mohammed Musawwir, learned advocate for the petitioner, seeks permission to withdraw. Dismissed is withdrawn.
May I please, Lordship, application for anticipatory bail. Offence is under section 30A of the Excise Act, Lordship. A recovery is from a Scorpio vehicle, Lordship. Vehicle is not mine. My name is transferred on the basis of the Koi Kujwa.
You said recovery from my vehicle.
No, no. From a vehicle.
From a
Scorpio
vehicle which is stated to be yours.
No, it is not mine, Lordship.
Then?
Koi was arrested. He has disclosed that I was the driver of that vehicle.
You are the driver and you ran away.
Lordship. That is the allegation.
What is the amount or quantity?
Quantity is 387 liters of country milk.
आपको तो मालूम था ही. वो क्या explanation है?
वो explanation है कि I was not arrested. The कोई हुआ apprehended.
आपका ये कहना है कि आप ड्राइव नहीं कर रहे थे?
ड्राइव नहीं कर. I was not driving. The कोई was arrested from the vehicle, Lordship. He is my co-villager. We have previous enmity.
And who is this co-villager?
Nuran Ansari.
No, I am not interested in name. How is he related to the vehicle?
No, he is also not related to the vehicle, Lordship, as far my information goes.
तो आपका नाम क्या है?
He is just going by name, Lordship.
गाड़ी किसका है?
2 डिफेंस आपका हो सकता है कि आप ड्राइव नहीं कर रहे थे.
I was not driving.
एक. और दूसरा ये हो सकता है कि साहब आप ड्राइव कर भी रहे थे लेकिन पुलिस को देखकर भाग गए, क्योंकि वो जो पकड़ाया है वो कुछ कंसाइनमेंट पैक करके रखा था जो आपको पता नहीं था कि वो लिकर. इस दो डिफेंस में से आपने लिया क्या है वो बताएं.
I was not driving the vehicle, Lordship.
ये तो बड़ा आपके टास्क हो जाए.
I stated in my para 9, Lordship, that the said Nuran has behaved some money exchange between us, Lordship. He was not returning.
ऐसा थोड़ी बताइएगा कि कोई कहीं पर किसी ने स्टेटमेंट दे दिया.
अब कोई क्रिमिनल इंसिडेंट नहीं है.
ये बड़ा मुश्किल है. अब मैं दूसरी डिफेंस लेकर तो आपको बेल दे नहीं सकता. आपका प्रोबेबल डिफेंस ये हो सकता था कि वो कंसाइनमेंट में वो पैकेट में क्या था वो आपको नहीं पता और आप ड्राइव कर रहे थे लेकिन पुलिस के डर से भाग गए. वो मोर प्लॉजिबल होता. आपके पास से रिकवरी नहीं है और आपकी एंटीसीडेंट नहीं है तो मैं कंसिडर करता हूँ, लेकिन सोच आपकी एंटीसीडेंट है?
नहीं एंटीसीडेंट नहीं. So far the seizure list witnesses, they are all the
नहीं, आप अरेस्ट ही नहीं हुए तो सीजर लिस्ट विटनेस से क्या?
Just I was persuading my lawyer.
Heard Mr. Indrajit Bhushan, learned advocate for the petitioner and so for the state. पहला पैराग्राफ लिखिए. 387 liters of liquor is recovered from a Scorpio vehicle. The person who was arrested along with the liquor has disclosed before the police that the petitioner had been driving the vehicle. Learned counsel for the petitioner has submitted that he, though is a driver by profession, but he had not been driving the same vehicle, and he has been falsely named by the arrested accused person because of his earlier enmity with him. The petitioner does not have criminal antecedents. On these two grounds, it has been urged that no offence under the Excise Act can at all be said to have been made out as against him. For the reasons aforestated, 10,000.
Thank you.
Mayor Lords. Your Lordship, offence under section 341, 323, 50, 450, 6807, 379 of and oblique 34 of the IPC. Your Lordship, it is alleged, Your Lordship, that on the alleged date, Your Lordship 6/3/19, Your Lordship, the FIR named accused person came in the house and Your Lordship started hurling abuses, upon which Your Lordship informant objected and abused persons attacked upon him, Your Lordship, and also snatched away the locket of the informant, Your Lordship. Your Lordship, you will find that from the FIR itself, Your Lordship will find that, Your Lordship, nothing, there is no any specific allegation against petitioners, Your Lordship. It is said, Your Lordship, that all the persons, Your Lordship, have attacked. However, Your Lordship, the real fact is that on the alleged date, Your Lordship, the informant was in drunken position, Your Lordship, and abusing to the villagers. Whenever petition number 1 objected and complained to the guardians, Your Lordship, and then, Your Lordship, the present FIR has been lodged, petitioners having no criminal antecedent, my Lord.
What is the nature of injury?
Nature of injury in the primary injury, Lordship, the Lordship, the abrasion and lacerated wound on the back of the body, which are simple in nature, but on the Lordship subsequent, Lordship, it is said that there is secondary report of the injury also.
उसका rib fracture
in which he has said,
शराब पीने के लिए आपने इतना मारा उसे?
मारा नहीं हुजूर, वो तो पी कर गाली दे रहा था हुजूर, कई जगह गिरा भी था हुजूर, हमारा सबमिशन है। और हुजूर हम लोग पर कोई भी स्पेसिफिक FIR को अगर हम पढ़ देंगे तो हुजूर को कहीं से भी कोई स्पेसिफिक मारने का अगर आ जाए तो हुजूर फिर आई विल बी नॉट प्रेस द लॉर्डशिप, कहीं स्पेसिफिक हुजूर हम FIR पढ़ देते हैं।
Heard Mr. Salesh Kumar led an advocate for the petitioner, for the petitioners, and so and so for the state. The petitioners are said to have assaulted the victim and others. Learned counsel for the petitioners has submitted that because of the victim behaving in a drunken manner, he was precluded from doing so. Instead of mending his ways, he started fighting with the family members of the petitioners and petitioners themselves. In this scuffle, the victim has received superficial injuries. Unfortunately, later, one of the injuries on the person of the victim was found to be grievous. Such injury was the fracture of a rib bone in the chest cage. Learned counsel for the petitioner has submitted that the possibility of the victim having fallen on the ground in the scuffle cannot be ruled out. The whole occurrence arose because of the victim behaving in an irrational manner, in a drunken stupor. Considering the background facts and the general and omnibus allegation of assault at the hands of all the petitioners, and prima facie, in the first instance, the injuries being only in the nature of abrasion, the petitioners are directed to be released 10,000.
Mr. Suresh Pandey.
Excise Act Lords and Secretary Bill. Lords, the recovery is from the sugar cane field of Lords 1 Fulender Sharma Lords. Though the petitioner number Lords 1 is of clean past, while petitioner number 2 Lords had one case Lords earlier. That was
Heard Mr. Subhesh Pandey, learned advocate for the petitioner, and so for the state. After some arguments, learned counsel for the petitioner seeks permission to withdraw the application with respect to petitioner number 2, who has earlier been made accused in a case of similar nature. The prayer for anticipatory bail for petition number 2 is thus dismissed as withdrawn. Should he surrender before the court below and seek bail, his application shall be considered on its own merits without being prejudiced by the fact that the present petition on his behalf has been withdrawn. The petitioner number 1 seeks bail in anticipation of his arrest in connection with so-and-so. He is sought to be prosecuted in the present case on the basis of recovery of liquor from the sugar cane field.
Of Phulender Sharma.
Sugar cane field of one Phulender Sharma. Considering the fact of recovery from an open space not belonging to the petitioner and his clean antecedent, he is directed to be released in the event of arrest or surrender. Number 1, league then announced.
Lord, 420, 406, 467, 468, 471. एलिगेशन है कि पिटिशनर नंबर 1 और पिटिशनर नंबर 4, पिटिशनर नंबर 4 जो है पिटिशनर नंबर 1 की मदर है, इन्फॉर्मेंट का एक कार्य कट्ठा जमीन जो है इन्होंने लिखा लिया, कुछ पैसा दिया कुछ पैसा नहीं दिया, तो उसने कहा कि मेरा कंसिडरेशन मनी नहीं दिए हैं इसलिए FIR कर दिया, एक सूट भी फाइल कर दिया फॉर कैंसिलेशन ऑफ सेल डीड। दोनों पार्टी में कंप्रोमाइज हो गया और हमने उसका जमीन लौटा दिया। ऐसा हमने फाइल कर दिया है, उसमें एनेक्सर भी लगा दिया।
आपने जमीन लिखा लेकिन कंसिडर आपने जमीन लिखवाया
जी, कुछ पैसा दिया, 95,000 दिया, कुछ पैसा नहीं दिया।
हाँ,
तो उसने केस कर दिया कि हमको भूलिया करके हमारा जमीन लिखा लिया और हमारा पैसा नहीं दे।
वो ये वही मुकदमा
है जी।
तो इस बीच में आपने क्या किया फिर?
इसके बीच में उसने एक सूट फाइल किया फॉर कैंसिलेशन ऑफ सेल डीड और उसमें फिर दोनों पार्टी में कॉम्प्रोमाइज हो गया और पिटिशनर जो जाकर उसका जमीन रिटर्न कर दिया सेल डीड
और उसने आपको अपना पैसा
लौटा दिया सब हम लोग का।
Heard Mr. Ramadya Singh, learned advocate for the petitioners and so and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so and so. The petitioner number 1 and 4 are said to have got a sale deed executed in their favor of a land belonging to the informant. However, the consideration money, or however, only part consideration money was paid. This led the informant to lodge the present case, lodge the subject FIR as also a suit for cancellation of the sale deed. However, in the interregnum, the parties sat across the table and settled their dispute. The land said to have been conveyed to petitioners number 1 and 4 have been returned to the informant, and the informant has also promptly returned the part consideration amount paid by the petitioners number 1 and 4. Considering the aforementioned background facts, the petitioners are directed to be released 10,000 sureties. 2 और 3 क्या है?
2-3 तो उसका ब्रदर है इसलिए उसको बना दिया, उसका कोई एलिगेशन नहीं।
Be it noted that petitioners number 2 and 3 have been made accused only because of their being related to petitioners number 1 and 4.
Mr. Kedar Jha.
My lord. 498A, my lord, husband, my lord.
What is your stand?
मेरा स्टैंड है माय लॉर्ड, अभी रिसेंटली वो 1 साल से दूसरी शादी कर ली है।
अपोजिट पार्टी करेंगे। यू आर रेडी फॉर सेटलमेंट ना?
हुजूर हाँ।
जाएं लोअर कोर्ट में। लोअर कोर्ट में जाएं, सेटल करने का प्रयास करें, डिस्प्यूट सेटल करें, जो भी होगा वहीं जाएं।
इन्वेस्टिगेशन में हमने ज्वाइन किया था और चार्जशीट भी सबमिट हो चुका है।
उसे क्या हो?
तो सतेंद्र कुमार अंटिल का जो केस है हुजूर, उसका वही हुजूर लिखा दिया जाएगा कि उसके लाइट में।
नहीं, मैं आपको प्रोविजनल बेल दे रहा हूँ। अंटिल का केस से नहीं है, मैं सेपरेट नया सिस्टम लेकर। हर्ड मिस्टर केदार झा। Within 6 weeks, if you surrender, you shall be granted bail. Notice shall be issued to the other side, and arrangement shall be made so that you will talk together. Let us see how you settle the dispute.
Mr. Amit Narayan.
May it please your lordship. Excise Act, my lord, section 30A of the Bihar Provision and Excise Act. There has been the case of the prosecution is that from an abandoned place, that is Bhusoli, foreign liquor of 361.440 liters.
Bhusoli open space नहीं है. Bhusoli is a fodder house. Does it belong to you or not?
No, ma'am. It does not belong to me.
How do you say so?
I have stated in my petition, my lord, not only this, my lord, the name of my and my family came out on some hearsay persons who has stated that.
Whose Bhusoli is that?
It is stated to be of my father, but I have particularly stated that it does not belong to me or my family members. Even one two-wheeler vehicle was also being seized from that place, and same also does not belong to me.
Instead of earning your livelihood from Common Service Center under the Digital India,
exactly, my lord,
you are earning your income from trade of liquor.
No, my lord, we have.
Perhaps it is fetching you more benefits to you.
No, my lord, we
have no qualms in implicating your father. In fact, you should have taken it upon yourself that my father is an old man. Don't prosecute him, even though he owns the property, family property,
my lord,
is the karta, but I am the culprit. You should have said that.
My lord, my father has already been arrested and my brother has been in this case. Yes, my lord. And my brother has already been granted bail by this honorable court. And because of my brother has already been implicated in other cases as well. That is why the police has been implicating the entire family in several other matters. And in this matter, this petitioner is not having any antecedent.
Any proof of the fact that you were a non-resident villager?
My lord,
instead of writing all this about your Digital India scheme, you should have said that you are residing not in your village where Bhusau is situated, but somewhere outside, and because
my lord, no one resides there. That is away from the.
Heard, Mr. All right, we are inclined to grant you bail. Heard, Mr. Amit Narayan, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. Stop. What is the quantity?
361.440 liters.
361.440 liters of liquor is said to have been recovered from a fodder house belonging to the father of the petitioner. Stop. Now, counsel for the petitioner has fairly stated before this court that his father and brother have been made accused in this case. The petitioner has been made accused in this case only on the presumption that the entire family is involved in the trade of liquor. The fact of the matter is, according to the learned counsel for the petitioner, that the petitioner hardly visits his village home, and for his livelihood, he runs a common service center under Digital India scheme. Merely because the father and brother of the petitioner have been made accused in this case, and the investigator is of the opinion that the entire family is involved in this liquor trade, the petitioner is sought to be prosecuted. The petitioner does not have criminal antecedents. For the facts stated, on behalf of the petitioner, 10,000.
Obliged.
Section 36, Mr. Vasant Vikas.
During the pendency of this case, petitioner number 1 is arrested. Right. So therefore, petitioner number 1 is withdrawn, my lord. The application for petitioner number 2 and 3, my lord. My lord, the allegation, my lord, the anticipatory bail application under section 341, 323, 324, 379, 354, 504 of IPC, my lord. My lord, the FIR is a third bayan is page number, my lord, at page 14, my lord. The allegation against the petitioner number 2 that he assaulted by iron rod to one.
Father से लड़ाई करते हैं. Father को मारते हैं. Family dispute का मतलब क्या है? माँ बाप को मारेंगे.
मारे नहीं है हुजूर, 307 भी नहीं है, लेकिन लगा हुआ है सब कुछ 307
फादर को मारते हैं, अपनी पत्नी के साथ पिताजी को मारते हैं,
पत्नी बेटा सबको फैमिली डिस्प्यूट है।
फादर कहीं
बेटा तो जेल चला ही गया,
बेटा तो फादर पर गलत केस करता है, फादर थोड़ी करता है।
दूसरा बेटा भी उनके सपोर्ट में हो, जो डिस्प्यूट तो बेटा बेटा में है, दूसरा बेटा उनके सपोर्ट में। अब एक बेटा तो जेल चला ही गया हो, जो
तो क्या करेंगे?
एक लेडीज है, एक बच्चा है, सबको एक्यूज बना दिया गया हो। हनुमानी छीलने का है, 379 का, ये सब है।
नहीं, बट राजू कुमार को मैं क्यों बेल दूं? रीता देवी आई कैन अंडरस्टैंड।
राजू कुमार पर तो सिर्फ 354 लग रहा है, वो जो किस सारी चीज लिए ही एलिगेशन उसके खिलाफ।
फैमिली
तो
में
बना
ऐसा
हुआ है,
एंटीसिपेटरी बेल क्यों?
जो उनके खिलाफ तो मारने का है नहीं, राजू कुमार के खिलाफ 354 बन रहा है,
Mr.
बनाया
Vasant
गया।
Vikas, learned advocate for the petitioners and so and so for the state. Sri Vikas seeks withdrawal of the application with respect to petitioner number 1 who has been arrested during the pendency of this application. The application with respect to petitioner number 1 is dismissed as having become infractious. Petitioners number 2 and 3 seek bail in anticipation of their arrest in connection with so and so. The petitioner number 2 and 3 are the daughter-in-law and grandson of the informant. Though there is accusation against them of assaulting and misbehaving with the female inmates, but the nature of accusation clearly reveals the domestic dispute between two brothers, one of whom is sided by the father of one of whom is cited by the father of the husband of petitioner number 2. Considering the aforesaid background facts, petitioners number 2 and 3 10,000. Very unhappy situation in our family.
Yes, that is true, Milord. That is true, Milord.
Yes.
37 plus Sri Krishna Ranjan.
May I please, Lordship, the petition for anticipatory bail in connection with Khargar PS case number 33 of 2020, registered for the offences 147, 148, 8, 149, 323, 341 and other section of IPC. Lordship, FIR plate page 15. Kindly come. सभी इस दोनों petitioners पे general and omnibus allegation है. Accused number 1 to 15 named है. Both petitioners are named. FIR के हिसाब से कहना है कि सीओ गए थे इंक्रोचमेंट हटाने के लिए, उसमें हम लोग डिस्टर्बेंस किए। हमारा डिफेंस ये है कि हम लोग वहाँ पर सिर्फ स्पॉट पे खड़े थे और व्यूअर कुछ ऐसे
खड़े नहीं थे, आप सर्कल ऑफिसर का गला दाब रहे हैं।
ये सर
बड़ी हिम्मती है।
अदर कोई एक्यूज पर्सन को कोऑर्डिनेट
मिस्टर श्री कृष्ण रंजन, यही नाम है ना?
नहीं सर, मेरा नाम यतीन्द्र नारायण, AC2 Krishna Ranjan.
Heard Mr. Yatindra Narayan, learned advocate for the petitioners and so and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so and so. The petitioners are said to have attacked the party which had gone to remove encroachment under the orders of the competent officer. The circle officer who was heading the team was also misbehaved with. The Upland Council for the petitioner has submitted that the accusation against the petitioners are absolutely general and omnibus. Merely because they were the bystanders, they have been made accused in this case on their names having been supplied by persons who have definite acts to grind against them. Under similar circumstances, some of the other accused persons of this case have been granted anticipatory bail. For the reasons aforestated, 10,000.
Okay, Mr. Santosh Kumar. Happy Mr. Santosh Kumar.
Password.
Happy Mr. Ashish.
Offense is under section
louder, sir.
341, 323, 354, 379, 500.
Yes, Mr. Rajendra Narayan. What brings you here?
I have a fear to oppose.
Later on added section 376 of the IPC.
376, no wonder.
Case 11 is prosecution story, Lordship.
Let us see the prosecution story. You are Vikram Kumar.
Yes, Lordship.
बढ़िए FIR।
सेवा में थानाध्यक्ष महोदय स्वयंसो, निवेदन है कि मैं मनीष कुमार पिता श्री सुनील साव स्वयंसो का निवासी हूँ। बीते दिनांक 7/9/2020 को समय करीब 3 बजे दिन में मेरी भाभी सुलेखा देवी मकई के खेत पर खड़ी थी कि मेरी भाभी को देखकर विक्रम कुमार पिटिशनर लॉर्डशिप स्वयंसो गया ने छेड़खानी करने लगे। जब मेरी भाभी सुलेखा देवी ने इसका विरोध की तो गंदी गाली गलौज देते हुए पैट मुक्का से मारपीट करने लगे तथा मेरी भाभी के गले से सोने का चैन छीन लिए। तब मैं आज दिनांक
फिर इस पर 376 कैसे ऐड हुआ?
164 statement if he has annexed.
I have also filed a supplementary affidavit in this case, Lordship.
हाँ 164 स्टेटमेंट
तो सप्लीमेंट्री में हम दिए हैं हुजूर कि ये जो विक्टिम है खुद अपने इन्फॉर्मेंट पर केस कर रहे हैं और अपने फादर इन लॉ पर कि हमसे झूठा केस करवाया जा रहा है।
नहीं 164 की स्टेटमेंट लगाया आपने?
जी नहीं हुजूर, 164 का स्टेटमेंट तो नहीं लगा।
आपने सप्लीमेंट्री एफिडेविट क्या फाइल किया है?
विक्टिम इन्फॉर्मेंट पे केस कर रही है हुजूर।
हमारे पास रिकॉर्ड में नहीं है, आप दें अपनी दिखाइए। अब वो मशीन क्यों नहीं मंगाते हैं सैनिटाइज करने वाला?
164 का
इंफेक्टेड हो जाएंगे कब करेंगे?
164 का एक कॉपी बढ़ा दे।
सप्लीमेंट्री फाइल
वो आपने एफिडेविट क्या फाइल किया? सैनिटाइजर वो
एक साल के बाद पता नहीं क्या ये प्रेशराइज करके फाइल कर।
नहीं वो तो ठीक है, वो आप प्रेशराइज करके वो फाइल किए, लेकिन आपका भतीजा भी तो कुछ और बात कहा था।
नहीं, भतीजा ने जो कहा उसको इमीडिएटली 164 में लेडी ने खुद सब्सटेंशियल उसी के लिए 164 बढ़ा
and 34 against a father-in-law and mother-in-law and brother-in-law state. Yeah, do you dispute this, Mr. Rajendran Roy?
No, Minister, I have not yet seen this. What is this here as well?
Heard Mr. क्या नाम है आपका?
राजेश कुमार। राजेश कुमार।
Heard Mr. Rajesh Kumar for the petitioner and Mr. Rajendran Narayan Leonard, senior advocate for the victim. The petitioner seeks bail in anticipation of his arrest in connection with Chakan, the PS case number so-and-so, which was initially registered for offences under sections 341, 323, 354, 379, 504 and 506 of the IPC, but later, with the 164 statement of the victim girl that she was also raped by the petitioner, section 376 was added. Learned counsel for the petitioner has submitted that the informant, who is the nephew of the victim, is an eyewitness to the occurrence who has alleged that the victim was misbehaved.
Informant is Devar.
Informant who is the brother-in-law of the victim is an eyewitness who has stated that the victim was misbehaved with by the petitioner in the field. Shortly thereafter, the victim appears to have given a 164 statement in which the allegations have been, in which there is an allegation of rape. Learned counsel for the petitioner has submitted that later the victim has filed a case against her father-in-law and another, alleging that she has been pressurized to raise this allegation against the petitioner. Mr. Rajendra Narayan, senior advocate, submits that he has no instruction with respect to the aforenoted averment on behalf of the petitioner. Call for the case diary and list this matter on receipt of the same on 28th of February. The petitioner, in the meanwhile, in the event of his arrest or surrender, shall be released on provisional bail 10,000.
Channel 40, Mr. Ranjan Kumar Jha.
Make lordship. Lord, application for anticipated bail. Offences under section 307, 354, B of IPC and other minor sections. Lord, FIR has been lodged against 33 accused persons.
Yes.
Out of whom, Lord, 21 are named, petitioners are named, and rest 10 to 12 are unknown. So, for allegation is concerned, Lord, in the last portion of FIR, your Lordship will found that a specific allegation, Lord, has been alleged against 7 of the named accused persons, in which, Lord, the name of these petitioners, Lord, has not been placed. And reason behind the occurrence is being assigned, my Lord, that all the 33 accused persons came armed with lathi, and
इंजरीज कैसा है? सब सिंपल है।
इंजरी सिंपल है, कुछ का ओपिनियन रिजर्व रखे हुए हैं ना, हम पर मारने का
स्पेसिफिक कुछ नहीं है।
नहीं, हम पर मारने का
किसी को बेल हुआ है?
ये है।
क्या है मारने का? क्या बोल रहे हैं?
मारने का एलिगेशन 7 आदमी पर, जिसमें हम नहीं है।
एंड व्हाट वाज दिस बम मर्डर केस?
बम मर्डर केस में भी हम एक्यूज नहीं है।
देखिए, heard Mr. Ranjan Jha, learned advocate, Ranjan Kumar Jha,
Ranjan Kumar
heard Mr. Ranjan Kumar Jha, learned advocate from the petitioner, learned advocate for the petitioners. How many of you?
3 persons, my lord.
For the petitioners and so and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so and so. Stop. The accusation against the petitioner, the accusation against the accused persons, including the petitioners, is of assaulting members of the prosecution party for not having withdrawn a murder case in which some of the accused persons have been made accused. The Stockland Council for the petitioners has submitted that 33 persons have been made accused in this case, with 21 persons having been named in the FIR. The petitioners, though, are named in the FIR, but there is no specific accusation against them. In fact, the accusation of assault is against 7 of the accused persons, none of whom are the petitioners before this court. Though some of the victims have received injuries which are simple in nature, and some of them, and with respect to some of them, the nature has not been assessed, but the London Council for the petitioner seeks bail, anticipatory bail on behalf of the petitioners, as they are not attributed with any overt act. The petitioners are also not accused in the Bum murder case. Considering the aforementioned arguments, 10,000.
10 days time may kindly be granted, my lord. Learned counsel for the petitioner is seriously ill, my lord. I have fever, my lord. 10 days time.
कौन बीमार हो गए?
संतोष कुमार, learned counsel for the petitioner.
क्या हो गया उनको?
बीमार, बुखार है। ये उनके क्लर्क ने इंटीमेट किया है।
नहीं, वो ठीक है, फाइल नहीं है आपके पास तो मैं मदद कर सकता हूँ। 307 का मुकदमा देख सकता हूँ, या फिर टाइम कहेंगे तो टाइम दे दूंगा। बीमार हैं तो समय मिल जाएगा।
बीमार क्या?
फाइल उनके क्लर्क से लेकर बहस करिए। 10 दिन का समय कहाँ देंगे? बेल इतना दिन से पेंडिंग है। अगर रिजेक्ट करने लायक होगा तो वकील साहब के लिए इंतजार करेंगे, देने लायक होगा तो कर देंगे। फाइल लेकर आइएगा कल। टेक इंस्ट्रक्शंस, आई एम पासिंग इट ओवर।
ठीक।
1042, Mr. Manendra Kumar Sinha. 1043, Mr. Sameswar Kumar Singh.
Please, Lordship. Application for grant of anticipatory bail, Lordship. Offence under Excise Act. 2 petitioners before Lordship. FIR is at page 14, Lordship. कहते हैं कि पुलिस को मोबाइल पर गुप्त सूचना मिली कि जितेंद्र राय, मुकेश राय सरड़िया के दरवाजे पर एक स्कॉर्पियो गाड़ी लगा हुआ है जो शराब ढो रहा है। जब क्या हो रहा है? शराब ढो रहा है। जब पुलिस टीम जितेंद्र राय के घर सरड़िया पहुंचा तो ईंट खपरपोश घर के दरवाजे पर एक स्कॉर्पियो खड़ी थी। 3-4 लोग खड़े थे। एक आदमी पकड़े गए, बाकी लोग भाग गए। जब पकड़े गए मुकेश कुमार, उन्होंने जितेंद्र राय, शंभू राय और भोला सिंह का नाम बताया हुआ। और मेरे कह रहा है कि मेरे घर के पीछे आंगन में बने शेड से जितेंद्र राय के Lordship 90 लीटर शराब बरामद हुआ।
तो जितेंद्र राय तो गए, उनको तो जाना पड़ेगा।
आंगन कोई जॉइंट फैमिली है, आंगन में है। और शंभू राय के खिलाफ तो एक आदमी का हुजूर बेल भी हो गया है।
शंभू राय कौन है?
शंभू राय हुजूर पिटीशन नंबर 2 है।
नहीं, कौन है? बाहर के। ठीक है, शंभू राय को दे देते हैं। जितेंद्र राय का तो प्रॉब्लम है।
हुजूर बेल हो गया है। आंगन में है, खुला स्पेस में हुजूर।
आंगन खुला नहीं होता।
तो जॉइंट फैमिली है। घर के पीछे लिखा हुआ है जैसे Lordship में कैंडिसी।
इसमें कौन सा दिमाग लगाना है? ओपन स्पेस रहता है तो मैं देता हूँ, नहीं रहता है तो नहीं देता हूँ। नंबर 2 का बिना मेहनत के आपको बेल हो जाएगा। नंबर 1 करेंगे नहीं तो बेकार की बहस क्या करें। देखिए, विड्रॉ करेंगे नंबर 1 का, या मैं रिजेक्ट करूँगा। Mr. Shameshwar Kumar Singh, learned advocate for the petitioner, seeks permission to withdraw the application with respect to petitioner number 1. The application with respect to petitioner number 1 is dismissed as withdrawn. Should he surrender before the court below and seek bail, his application shall be considered on its own merits without being prejudiced. The petitioner number 2 seeks bail in anticipation of his arrest in connection with so and so. He is sought to be prosecuted in this case on the basis of statement made before the police party by an arrested accused person as one of the persons who ran away at the time of raid. The counsel for the petitioner has submitted that he is a person of clean antecedent, and the only material against him is is the statement of an arrested accused person. First off, the place of recovery does not belong to the petitioner. For the aforementioned reason, petition number 2, for the aforementioned reasons, the petition number 2 is directed to the
May I please, Lordship. Petition number 7 arrested, Lordship, due to pending of the application, Lordship. Offences under section 147, 148, 149, 341, 323, 307, 353, 427, 504, and 506 of IPC, Lordship. FIR is 14 named and about 100 unknown persons.
Yes.
इसमें कहते हैं हुजूर कि दो पॉलिटिकल राइवल हैं, सरपंच और मुखिया दोनों के बीच में झगड़ा है, एविडेंट फैक्ट है, दोनों के बीच में झगड़ा है और उसी को लेकर के ये पूरी भीड़ जमात थी और इन लोगों पर एलिगेशन है कि इन लोग मारपीट का प्रयास किए हैं और पुलिस पर्सनल पर भी गाड़ी क्षतिग्रस्त करने का प्रयास किए हैं, उनको मारने की धमकी दी है।
स्पेसिफिक तो है नहीं?
स्पेसिफिक किसी पर नहीं है हुजूर।
कईयों को बेल हो गया होगा?
हमको जानकारी नहीं।
आप नेम्ड में हैं अननेम्ड?
हम नेम्ड में हैं।
कुछ तो होगा, क्यों पहचाना आपको?
ये हम मुखिया के फैमिली में हैं हुजूर। कहते हैं सरपंच कहते हैं कि उनको घर के अंदर बंद थे, ये मुखिया के फैमिली लोग सारे लोग और बहुत सारे लोग मिलकर उनको घेर लिए और उनको बाहर निकाल कर मारने की धमकी दे। पुलिस को इन्फॉर्मेशन मिली, पुलिस पहुंची वहां पर।
ठीक। इंजरी बहुत है किन लोगों को?
इंजरी नहीं है हुजूर, कोई इंजरी नहीं है, एज पर माय इन्फॉर्मेशन कोई इंजरी नहीं है हुजूर।
देखिए, हर्ड मिस्टर, नाम बताएं अपना?
निशांत कुमार सिन्हा।
Heard Mr. Nishant Kumar Sinha, learned advocate for the petitioners and so and so for the state. The petitioners seek bail in anticipation. Heard Mr. Nishant Kumar Sinha, learned counsel for the petitioner. Sri Sinha seeks permission to withdraw the application with respect to petition number 7, who has been arrested during the pendency of this petition, dismissed as having become infractious. Petitioners number 1 to 6 seek bail in anticipation of the arrest in connection with so and so. The FIR has been lodged by a police officer alleging that during the patrolling duty on the eve of Nag Panchami festival, a clash between two groups was reported. Hearing the aforesaid news, the police party reached the place of occurrence only to find that the members of two warring groups were stationed eyeball to eyeball against each other. Notwithstanding the warning given by the police party, none of the persons belonging to the warring groups budged and resorted to brickbats, which resulted in damage to police vehicles also. 14 persons have been named in the first information report, in which the petitioners also are there, but about 100 other persons have been made accused in this case without naming them. No specific overt act has been attributed against any one of the petitioners, and according to the information to the learned counsel for the petitioner, there is no injury on any one of the persons of either side. Considering the general nature of accusation against the petitioners and there being persons of different disciplines, they are directed to be released.
Your matter relates to Excise Act. There is a recovery of 90 liters and 750 ml of foreign liquor from a Magic car. Two persons were apprehended, namely...
Magic is the name of the brand? Or
Magic
is that some, it has some magical...
No, Magic
is the name of a brand. Name of a
logo
brand.
of Tata.
All right. So it doesn't have magical properties. Huh? Water bottles converted into liquor bottles. ऐसा तो नहीं कुछ है?
No.
Magic brand. पढ़िए, बताइए क्या हुआ फिर?
Two persons were apprehended, namely Vidya Sagar and Vijay Rishi. They disclosed the name of the petitioners, that the liquor seized belongs to the petitioners. In para 6 of my petition, I have written that Milord, petitioners are neither the owner nor the driver of the seized.
वो तो claim भी नहीं कर रहे हैं, कहते हैं शराब आपकी है.
मिलोड
ड्राइवर और व्हीकल ओनर की बात तो है नहीं.
जी, तो रिकवरी मेरे पास से है नहीं, हम वहाँ
Who has been arrested? Name of the person who has been arrested.
Vijay Rishi and Vidyasagar.
Vijay Rishi and Vidyasagar. And
Milord.
what is the quantity?
90 liters and 750 ml.
All right. And how about your antecedents?
No antecedent, my lord.
Look here, heard Mr. Your Dr. Vidhuranjan?
No, my lord. Saurav Anand.
Heard Mr. Saurav Anand, learned advocate for the petitioners, and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so and so. Stop. 90 liters of liquor is said to have been recovered from a vehicle, and 2 persons were arrested along with the seized vehicle, along with the seized liquor. Stop. The aforesaid 2 persons have named the petitioners as the owners of the liquor. Stop. Land counsel for the petitioners has submitted that, but for the statement of 2 of the arrested accused persons, there is no other material to connect them with the offence. Stop. The petitioners deny the statement made by the arrested accused persons of their being the owners of the liquor in question. Stop. The petitioners have clean antecedents. On these grounds, it has been urged on behalf of the petitioners that the offence under the Excise Act cannot be said to have been made out against them. For the reasons before stated, then house.
46, MS Uttar Kumar Singh.
जो 304B का केस
कौन है?
petitioner is husband.
तब क्या करेंगे? इसमें एंटीसिपेटरी क्या करेंगे? कोई मिटिगेटिंग फीचर हो तो बताइए। फांसी से लटक रही थी, कमरा अंदर से बंद था, कुछ था।
She committed suicide by consuming poison. और FIR में कहते हैं कि जहर खिला के सबको गुप्त रूप से मार दिया। ऐसा नहीं है कि
आपका क्या एक्सप्लेनेशन है? 106 में तो आपको बताना है घर के अंदर मरी है।
Of course not.
तो आप समय बर्बाद करेंगे, डायरी मंगवा के कहेंगे तो डायरी मंगवा दूंगा, लेकिन इंटरनेट कर दूंगा नहीं।
इन-लॉज का उसमें डायरी मांगे हैं।
आप सरेंडर करिए तो उन लोगों को भी बेल हो जाए।
हम विड्रॉ कर लेते हैं।
विड्रॉ नहीं करिए, आफ्टर सम आर्गुमेंट्स कर देते हैं।
एक चीज हुजूर से शेयर करना चाहता हूँ। 1986 के बाद से सोसाइटी में बहुत चेंजेस आया है हुजूर। When this act was enacted, 304B, बहुत सारी चीज, ललिता पवार सास से अब किरण खेर टाइप की सास हो गई है, फ्रेंडली। तो जनरली अब कोई हस्बैंड मारता नहीं है उसको।
ये बड़ा ही कंट्रोवर्शियल सा स्टेटमेंट आपने दे दिया है। ऐसा है नहीं। In fact, the opinion is otherwise. The cases of dowry murder is on the rise. This is what the statistics would tell you. 498 is different. People are not getting along well. But so far as death is concerned, the number has risen high. Maybe not in this state, but the number has risen high. Anyway, we have after some arguments करते हैं। तो उषा कुमारी सिंह कौन है?
ये हमारे ऑफिस।
They heard so and so paragraph. After some arguments, land counsel for the petitioner seeks permission to withdraw this application in order to enable the petitioner to surrender before the court below and seek bail. Should he so surrender before the court below, his application shall be considered on its own merits without being prejudiced by the fact of the present petition on his behalf.
47, Mr. Amarish Kumar Sinha.
Care for not today.
48, Mr. Sanjeev Kumar Singh.
May the lordship allegation presented by under section 392 of the IPC manual. Petitioner not named the FIR manual. Only on the basis of suspicion whether this petitioner is implicated by the police in the present case, my lord.
कोई
Nothing will be recovered, no recovery.
किसी ने नाम नहीं लिया है।
इम्प्यून ऑर्डर में हुजूर कहीं ऐसा कुछ नहीं आ रहा है।
आप बताएं ना, इम्प्यून ऑर्डर छोड़ दें।
हमारे पास डायरी नहीं हुजूर।
ये तो कोई बात नहीं हुई ना। आप बहस करने आए हैं एंटीसिपेटरी बेल। द कोर्ट हैज आस्क्ड यू अ सिंपल क्वेश्चन, इज इट ओनली ऑन सस्पिशन और इज इट ऑन द स्टेटमेंट ऑफ एनी को-एक्यूज्ड?
हमने तो लिखा है सिर्फ सस्पिशन के आधार पर।
आपने लिखा नहीं, आपकी स्टेटमेंट लिखाऊंगा। अगर गलत स्टेटमेंट होगा तो आप परेशानी में फंस। ये सिंपल सा मैटर में इतना कंफ्यूजन, इतना दुविधा क्यों है, इतना टेंटेटिव क्यों है? FIR पढ़ सकते थे, डायरी पढ़
से आ रहे तो
ठीक है, आप समय चाहें तो समय दे दें, लेकिन ये कोई जस्टिफिकेशन तो है नहीं।
अभी एडजस्टमेंट में थोड़ा टाइम लगेगा, मुझे बता
कोर्ट ने एक सीधा सा सवाल पूछा है, अगर आप फाइल में एक नोट बनाए रहते तो बताते।
नोट्स में तो
अगर किसी ने नाम लिया है आपका तब भी मैं बेल देने को तैयार हूँ, सस्पिशन पर है तब भी बेल देने को तैयार हूँ, अगर आपके यहाँ से रिकवरी नहीं हुई।
आज मैं तेरे पासवर्ड कर दिया, कल हम असिस्ट कर देंगे।
ये मुझे ये खराब लगता है कि जब एक लाइन की बहस में भी अगर तैयारी नहीं होगी तो हाईकोर्ट हमारा क्या करेगा?
असिस्ट कल कर देंगे प्रॉपर्ली।
Heard Mr. Sanjeev Kumar Singh, learned advocate for the petitioner and sons of the state. The petitioner seeks bail in anticipation of his arrest in connection with so-and-so. The petitioner has not been named, and his prosecution in the instant case is only on the basis of suspicion. Nothing has been recovered from the constructive possession of the petitioner, and he has clean antecedent. Considering the aforestated facts, 10,000.
May be clear. Offense is under section 307, 302, 34 of the IPC and 27 of the Arms Act. Alleged to the petitioner is assailant. Petitioner is the man assailant.
बड़े वाह, और आप पर मुकदमा भी पड़ते हैं।
जी।
Anticipatory will.
ठीक है। You are not Girish Chandra.
Rajesh Kumar.
You are Rajesh Kumar. You are junior to Girish Chandra.
तो सर्किट के साथी हैं, श्राद्ध में है वो।
नहीं, वो हमें कोई परेशानी नहीं है, मैं आपकी आइडेंटिटी केवल जानना चाहता हूँ। You are associated. Heard Mr. आपकी का नाम लिखाऊंगा, क्या नाम है आपका?
राजेश कुमार।
Heard Mr. राजेश कुमार झा, लड़े
नहीं, सिर्फ राजेश कुमार है।
Heard Mr. राजेश कुमार। ये कोर्ट में जब पूछा जाए कि कौन है, क्योंकि नाम यहाँ एडवोकेट ऑन रिकॉर्ड है, तो ये नहीं कहना है कि सर्कल के हैं। You can say that I am his associate, I am his friend, I am his junior, I am his colleague. And please don't mind my saying so, but these are general expressions which are acceptable in courts of law. तो आप कह सकते हैं कि I am on instructions from Mr. Girish Chandra, who is associated with me, I am arguing this case. No problem. Because I know the faces of most of the advocates, I would not prevent you from arguing. But the expression should be apt. सर्किल के हैं और साथ में ऐसा की जरूरत नहीं है, हमारे एसोसिएट हैं, हमको उन्होंने कहा all these instructions I am doing it. Heard Mr. Rajesh Kumar, learned advocate for the petitioner and sons of the state. पहला पैराग्राफ लिखने के बाद लिखिए कि in view of the accusation against the petitioner of assaulting the deceased, I am not inclined to grant anticipatory bail to him. The prayer for bail accordingly is rejected. However, if he surrenders,
Mr. Rajesh Kumar.
Anticipatory bail. Allegation offense under section 147, 148, 149 and 302 of the Indian Penal Code में कहते हैं हुजूर कि बीते कल दिना अपने भाई मृतक भाई राम स्वरूप के साथ कमाने के लिए मुजफ्फरपुर आए थे। शाम में मुजफ्फरपुर जाने के क्रम में बाजार गए, सब्जी खरीदे। झापा में हम दोनों भाई को राम बाबू राय जिला मुजफ्फरपुर मिले। राम बाबू राय हमारे भाई को बोला आपका सब्जी हम घर पहुंचा देते हैं। तब मेरा भाई सब्जी राम बाबू राय को दे दिया। राम बाबू राय सब्जी लेकर के घर की ओर चल दिया। मेरा मृतक भाई झपा से ताड़ी पीने के लगा, उसके बाद घर की ओर चला। पूरब जाने पर 3 आदमी को गड्ढा में देखा। देखते देखते आदमी सड़क पर आ गए। पांचों मिलकर के मेरे भाई राम स्वरूप राय को लपड़ तपड़ से मारपीट करने लगे तथा राम बाबू राय, रामनंदन राय, प्रयाग तथा राम बाबू राय को पहचान पिटिशनर
Mr. Raju Kumar Goswami, learned advocate for the petitioner and sons of the state, Palam called the case and this matter will receive the same on 17th of April.
Permitted to withdraw the case, Your Lordship.
Which matter?
Criminal miscellaneous number 31626.
Where is that?
Consolidated list, Your Lordship.
Tomorrow.
Oblige.
That was salary matter.
Is this the time to mention, Mr. Kam? You have to wait for 10:30. But anyway, salary matters. So what salary matter?
Teachers हैं हुजूर, salary बंद है।
February में कभी लगाइए. Please mention on the correct time.
रखाए हुए थे लेकिन ढूंढने में
अजीत बाबू अजीत बाबू
अभी मास्क के आप तो फ्रंट में बैठे हुए
इसलिए मेंशन करना था, इसलिए खुल नहीं।
जब तक मेंशन का उस समय आप मास्क रिमूव कर लिए, लेकिन आप एकदम फ्रंट बैठे हुए थे और विदाउट मास्क।
नहीं, मेंशनिंग करना था इसलिए मास्क। एनीवे सॉरी, हम ये कह रहे थे कि वेकेशन से पहले एक मेंशनिंग मैंने किया था, ऑर्डर में कुछ टाइपोग्राफिकल एरर हो गया था, मेंशनिंग अलाउ हो गया था, कहा गया था मंडे ट्यूसडे को लिस्ट करने के लिए। वेकेशन से पहले मंडे ट्यूसडे जो हुआ था, लेकिन वो मैटर लिस्ट नहीं हुआ है। तो इसीलिए हम थे आज, कल सुबह में
मेरे लिए कल मुझे बढ़ा दिए हैं
तो उसका कुछ दिखाना पड़ेगा ना?
कुछ नहीं, अभी तो आ जाएगा तो वो तो पास बनेगा।
तो पासवा कैसे बनेगा?
बनेगा, सेकंड जा रहा है, वो सोल्यूशन करेगा वो।
आप भेज रहे हैं? आज भेज दीजिए। विनीता सिंह नाम याद है ना?
विनीता दिया हुआ है, विनीता सिंह
देख लीजिए। अच्छा, ये रीट नहीं सुना?
परवीन बाबू नहीं है, सब सुनेंगे।
पानी ले ले
पानी
विनीता सिंह
ये कर ले वो।
हाँ कैसा विनीता सिंह और हम जा रहे हैं वो सिली आ रहे हैं।
वो लड़की मिला क्या रजिस्टर? हैं? वो कहाँ है? वो जिसमें सिली कराता है सब है ना?
वही ना रजिस्टर, वही में नहीं है
ना। आपका नंबर नोट कर लीजिए,
अनवारी में होगा।
1 मिनट सर, आपके तरफ तेज रहते तो हम भी
933
933 1 2 3 जी
0451
0451।
अगर कल फिजिकल चलेगा तो कल तो बोलेगा आगे अटेंड करेंगे, वहाँ पे बैठ जाएंगे। अगर वर्चुअल चलेगा हमको ईमेल आईडी रात में दे देंगे।
मेरा ही है सर, मेरा ही है सर, हम ही अपनी ट्राई करें। फिजिकल चलेगा तो यहाँ आके अपना बैठेगी आप पास।
वर्चुअल चलेगा तो ईमेल आईडी देंगे, वो उन पर सिस्को वेबसाइट से ऐप डाउनलोड कर लेंगे मोबाइल में, और वहाँ को लिंक मिल जाएगा, से जुड़ के वो अपना ड्रेस में
एड्रेस सिखाइएगा, जो भी प्रॉपर ड्रेस होगा उनका।
इसी पर ईमेल आईडी आपको यदि वर्चुअल चलेगा
एक्सक्यूज मी सर, सेकेंड हाफ सिविल करेंगे?
अभी 16 बिल है,
16 बिल करेंगे मतलब?
ये भी आज इसको दे दे, कल रहेगा। बाकी रजिस्टर देखिए, मैं तो इसी में चाह रहा हूँ। अरे तो हम देख लेंगे, अलमीरा होगा अलमीरा चाबी कहाँ है? ये ठीक रहेगा, ये में चाबी,
ये में ना दो चाबी।
ऐसा चाबी दीजिए धर्मराव, अलमीरा पे इसमें होगा चाबी।
पैसे करने में क्या है ना?
चलो मार्केट को ले लो इधर, तो तुम कानून दे हम फिर हम आगे चलाओ। ब्रेक सत्तर है
क्या हां
ले ले रहा है।
हां ले ले
चलो नहीं बुक इसमें लगेगा ना, वो ना तो टेस्ट आ जाता है, तो लेवल नहीं है ना, चला नहीं उसको उठा देंगे रिमोट से, रिमोट से उठाओगे तो भी जो है ना वो टकराएगा, ये टकराएगा ऊपर जाएगा, ठीक है? गिरिया खाना इधर करना चलो ऐसा करो तो मालूम चला कि गिर गया।
वो तो कर दे पहले, किताब में सर लगे कहीं गिरे नहीं। चलो से
ठीक है, हम आते हैं।
सेकंड हाफ में बिल स्टार्ट होगा,
बिल कंटिन्यू रहेगा, उसके बाद हम आते हैं। चलो
Okay, have you covered?
खाली चढ़ा कर
50 मीटर या
खाली उसको सिर्फ कुछ खाली डायरेक्शन उठाना लिखनी है सर।
चलो चल आओ ना
इसका सर वो चले गए जरा से इनका लिस्ट दिखाइए तो हम लोग के लिस्ट में विथ करके नहीं आता है। एक सेकंड कर दीजिएगा। इसके साथ ही कॉल हो जाएगा क्या?
जी
जो सैलरी स्कूल का मैटर है उसके साथ टोटल कॉल हो जाएगा।
विथ लिखा हुआ होगा तो
नहीं नहीं, जैसे 71 वाला मैटर 70 वाला मैटर है 5 ठो, तो सेम हमको लगता है सिमिलर मैटर होगा और आगे भी वो भी विथ करके अलग अलग करके है, एक साथ हो जाएगा तो रुकना पड़ेगा ना। अभी तक एक भी दिन रीट में इंटर किए हैं या नहीं?
नहीं, अभी 15 पेज के बाद होगा।
तो 15 पेज होते होते फिर टाइम नहीं हो जाएगा।
हाँ सर, हेलो जी जी सर कुछ भाषा नहीं है। वहाँ बहस करने की जरूरत नहीं है।
लगातार चलेगा अकाउंट
अरे कंटिन्यू पहले डेट बचा हुआ है 51 से बोल होगा सरकार की एस्टीमेट
15 बचा हुआ है तो बाद अपडेट वाले सब क्या रहेंगे
बेल नहीं चलेगा बेल पहले चलेगा सर जो बचा हुआ है सवाल नहीं
16 हुआ बचा हुआ है काम में 66 मतलब
110 है आप कभी आदमी 110 पकड़ाएगा
110 है कौन 10 मिनट पकड़ाएगा अभी तो आप ले रहे आपको ठंडा नहीं लगता
बड़ा सॉरी कर मेरा तो ठंडा लग रहा है तो आने को अच्छा महसूस है
कैसे इसका कंट्रोल नहीं दिया कंट्रोल नहीं दिया
सर यहाँ से कुछ नहीं है सर
बोल देते तो ऑर्डर कहा बोले कि गौतम जी कल
मास्क लगाइए सर काइंडली मास्क लगाइए आप तुरंत बैठे हो मास्क लगाइए मास्क लगाइए कल देखिए बेल तो चलेंगे बाकी लर्निंग तो है
अरे हमारा पहला है सुनिए ना तो 5% तो वही रह जाएगा ना चले पड़ेगा आप उधर से कम है आप यहाँ कम है
चले जाओ निकालो
क्या कम है
उधर रिटायर की इधर का तो अच्छा
पासवर्ड पर डे में तो ही हो जाएगा ना वैसे कुछ ना के बाद अपना
पैसा विड्रॉ करना है
पैसा विड्रॉ
हाँ कर लीजिए पकड़ा गया है। सब कुछ
राजा पासवान कैसा ना
मुझे अच्छा संगत में भी अच्छा ही नहीं है।
किधर आना छुट्टी हम बोले घर
अरे आपको तो लगे हमको सीधे खाना हमको तो 15-20 मिनट में आना पड़ेगा।
आपको बोल रहे
एक दिन आने
वो बोले कि हमको नहीं करेगा
अरे तो दे दे अपने बोले कि भाई सब लोग को आने आज कुछ पता नहीं
ईमेल आईडी भेज देना आपको।
Serial 16.
60. So, 60.
उनका भी ड्रॉप करना मिशनर सबके खड़ी मेंशन ऑफ करके भी ड्रॉप करना ठीक
प्रवीण कुमार
वही निकाल
पास करते तब पास करेंगे तो सेकंड करते लिया अगर यार अगर यार कौन देगा आइए अच्छा अपन भी जा हो गया नहीं पब्लिक अब घर में पानी नहीं हटके इसीलिए ऐसा 15 किलोमीटर होगा हो गया तो 20 किलोमीटर बढ़िया हाल है जजमेंट का सर्टिफिकेट को जजमेंट और ऐसा निश्चित हो गया है कि ज्यादा संभावना है ठीक है एकदम नहीं है राइट तरीका है हमें दो तरह का बोला अभी तो क्या होगा दो तरह का हो रहा है वहाँ आदमी के लिए हड़बड़ हो जाएगा जवान आदमी के लिए हो गया आगे जमाना दौड़ने से देखिए कौन से दौड़ने से होता
Yes. 58 pass over.
Serial number 60, my lord. I ask for, I permit to withdraw this application.
Mr. Ram Sumuran, Royal and advocate for the petitioner, seeks permission to withdraw this action. Your request is withdrawn.
65, my lord, withdraw.
Same order, Virendra Kumar.
My lord. I will not permit to withdraw conspirator list at serial number 239.
Tomorrow. Yes.
My lord, one general prayer, Lord. Some time may be fixed, Your Lordship, for.
Wait for some time. It's not a general prayer. It's a prayer which I think all of you, and in fact the court also, would like to resort to. Now we can't possibly only handle bail matters.
That is the difficulty, my Lord.
That's the problem. The roster is not of bail. The roster is of something else.
Yes, my Lord.
But because of a huge pendency and the matter being taken very seriously by everybody across the board, all judges are hearing bail matters. But then wait for 1 week. We do not know from tomorrow what kind of mode we will be following.
I was there, my lord, in the.
Has any notice come for?
Notice has not yet come, my lord. I was there in the court number 1, my lord.
Court number 1 is whose court?
Honorable the Chief Justice Court, my lord, today morning. And, my lord, he was addressing to Learned Advocate General, and, my lord, the view has been expressed by Honorable the Chief Justice that from tomorrow we may go for virtual.
That's right. I also consider
yes.
that this might happen from tomorrow. So we'll have to take a call again with respect to roster. I mean, I wouldn't be able to promise anything for delineating special time for all such matters, but wait for this week. Next
at
week
least
we will.
first half, my lord, either writ or bail, or second half, my lord, either
We'll do it for second half.
Any time, my lord,
but
as
for
per my
that,
lord's
the number of bail
convenience.
petitions will have to be restricted to 50. Let's see. From next week, we are going to devise some way.
My lord, much of that. Because everyone, my lord, we are at least.
I know this. It's really needed. No court is doing anything except bails. The system cannot run like this. We'll see. Next week, hopefully, your reverse would be requested.
Much of that.
All right. Yes.
In the present case, my lord, the offence is in the section 38A of the Bihar Provision and Excise Act, my lord. From possession upon Prabhu Yadav, 9.4 liter country-made liquor is said to have been recovered. And he disclosed before.
Anybody coughing, please, there is a request. He may leave the court. The case will be passed over. Yes, 9.4 liters.
Country-made liquor was recovered from on Prabhu Yadav, and he disclosed before the police. इनके कहने से लगता है कि यूपी से पिटिशनर जो यूपी के रहने वाले हैं वहां से ये खरीद के लाए। ये लिखते हैं बरवा घाट के उस पार पचरुखिया भट्टी के लाल बाबू यादव जो एड्रेस सो यूपी के द्वारा दिया गया था।
Heard Mr. Sanjeev Kumar, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. First of one, Prabhu Yadav is said to have been arrested with 9.4 liters of liquor. First of, he is said to have disclosed before the police that the liquor was sent from UP to Bihar by the petitioner. The Stockland Council for the petitioner has submitted that beyond the confession of an arrested accused person, and that also a vague statement, there is no other material to connect the petitioner with the offence. The petitioner does not have criminal antecedents. For the aforementioned reasons, 10,000.
May I please, Lord?
Yes.
Lordship allegations under section 307, 379 and LR section of the IPC. The informant Millers alleged that on account of prior land dispute, the accused persons Millers, altogether 10 in number, assaulted them Millers. Millers will find a specific allegation of assault is on Mandev Rai and Gandhi Rai.
Mandev Rai and
Gandhi Rai. They alleged to have assaulted by means of harsa on the head of one Chinta Devi. Other person Millers, they are general and other allegations on all petitioners. There is counter version Millers, Manager 2.
Lodged by Mandev?
It is lodged by Nirmala Kumar, the wife of Millers, one of the petitioner here. Millers.
Who is the petitioner here?
Bhola Rai.
What is the nature of injury received by Chinta?
Chinta Devi received grievous injury. That is another 3. Millers will find at page 18.
How many persons have received injuries?
To my knowledge, Millers, she is the only person from the informant side who has received injury. One person from our side also has received injury.
That's right, mother of Bhola. Now tell us one thing. The injury is on which part of the body of Chinta?
That is Miller's temporal
on head.
Region. Yeah, Lordship, it appears. Temporal region. Size.
Which document are you referring to?
Lordship, I am an injury, lecture 3, page 18. Sharp cut wound over left temporal It could be reason, my lords.
Persons of counter case, have they been granted bail? You have no idea.
I'm not sure, my lords.
And how are you related to Mandeo and Gandhi?
All are related, my lords. They are patidars. Informant side and accused side both. It is a case of information.
How many persons have been made accused?
10 persons have been accused, 6 are here, lords, petitioners.
And has Mandeo and Gandhi surrendered?
Lords, I will have to seek instruction on this point. Since they are not here, therefore.
And that's right, but you should have.
They have not filed any petition here also. This much I have checked.
We don't know. Grievous injury, I'm slightly apprehensive in granting anticipatory bail,
but it is not attributed to petitioners.
No, that's true. That's true. Otherwise, there would have been no time in rejecting the bail.
Exactly, I was also not argued that.
What kind of dispute?
Land dispute is admitted prosecution case, my lords. शुरू में ही कह रहे हैं, lords, 5th line from the top portion.
Heard Mr. Vishwajit Singh, learned advocate for the petitioners and so and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so and so. Though the petitioners have been named in the FIR, but there is no specific accusation of assault against them. First up, one Mandeo and Gandhi are said to have assaulted Chinta Devi, who has received grievous injuries on her person. First up, a counter case has been lodged by the wife of petitioner number 5, petitioner number 6. First up, the mother of petitioner number 6 has also been injured. In the occurrence. Land counsel for the petitioner submitted that from the averments made in the FIR itself, it would appear that there is a pending land dispute between the parties. The possibility of the parties having clashed amongst each other with injuries on both sides cannot be ruled out. Since the petitioners are related to Mandeo and Gandhi and have not been attributed with any specific overt act, they are directed to be released in the event of arrest or surrender of the house.
Mr. Ajay Kumar.
Pass.
Secretary for Mr. Mukesh Kumar Singh.
Excise matter, my lord. As per allegations, 6,200 liters recovered from the truck. My
very small quantity, Mr. Sanjay.
Yes, my lord.
6,000 liters? Were you?
My name has come on the basis of confession made by co-accused Pankaj Kumar.
In what capacity?
As a local supplier. But my lord, 3 co-accused persons.
अगर आप भागने वाले में से होते, अनलोडर होते तो मैं समझ सकता था. ये सप्लायर वाली एलिगेशन तो बड़ा मुश्किल है. 6,000 लीटर तो.
3 co-accused persons have been granted anticipatory bail. My lord, I have an action except 2.
They are also suppliers.
Yes.
How do you say?
My lord, from FIR.
तो ये किस ग्राउंड पर मैं ये हूँ? कानून तो मना करता है. हमने ऑर्डर कर दिया, क्या कर रही है?
जी नहीं हुजूर.
क्वांटिटी की चर्चा नहीं है एक्साइज एक्ट में, बट दिस काइंड ऑफ एन एक्यूजेशन आई डोंट थिंक. एंड हाउ इज योर एंटीसीडेंट?
नो एंटीसीडेंट. क्वांटिटी बहुत ह्यूज.
इन लोग के बारे में भी सप्लायर का है जिनको बेल हुआ है.
जी हुजूर.
मुश्किल है.
FIR
क्या करेंगे?
जी हुजूर, ये पेज 14 पर है. लोकल कारोबारी के रूप में इन लोग का नाम है. एक्यूज नंबर ये 10, 11, 12 को हुआ है. ध्रुव सिंह हैं, नरेश गिरी हैं और हवलदार मियां हैं.
How many persons were caught along with the liquor?
3 accused persons were caught.
They have disclosed.
They have Pankaj Tiwari disclosed.
मुश्किल है. देखिए Third, Mr. Sanjay alias SK, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. 6,200 liters of liquor is said to have been recovered from a truck, and 3 persons were arrested. One of them has disclosed that local traders, including the petitioner, were responsible for were responsible in bringing the liquor in the town. Land Council for the petitioner has submitted that similarly situated accused persons have been granted anticipatory bail by different benches of this court. He further submits that the accusation by way of confession of arrested accused person is also too vague to be relied upon. Whether the liquor was brought from outside or brought from outside at the instance of the petitioner or others, or it was handled locally, is not known. The only material therefore against the petitioner is the confession of an arrested accused person, which has no foundation or basis. The petitioner does not have criminal antecedents, which also is indicator of the fact that the petitioner has not been locally handling the trade of liquor. For the reasons aforestated, 10,000.
Mr. Pramod Mishra.
Lord, prayer for anticipatory bail, Lord, 406-420 of IPC. 2 full brothers before my Lord. As per the prosecution case, my Lord, ये हुजूर पेज 12 पर इंफॉर्मेंट हुजूर कहते हैं कि हमने जमीन 10 फूल खरीदने के लिए इनको 1 लाख रुपया एडवांस किया और जरिमाना बना, बाद में इन्होंने हमको जमीन रजिस्ट्री नहीं की। दैट इज ऑल इन शॉर्ट। पिटिशनर नंबर 1 के लिए है कि हम पैसा दिए थे हुजूर। एनएफआई 2 इज ऑन रिकॉर्ड इन 2018 my Lord. Petitioner number 1 had filed a case, Lord, against this very informant and one Sambhu Saran Singh, Lord, who is said to be witness on Jariwana, Lord, who is uncle of these petitioners, Lord. Due to Lord, uncle wants to grab the land, Lord. That is the reason, Lord, whole episode has been, Lord, has done.
Mr. Pramod Mishra, learned advocate for the petitioner, is permitted to add the informant as opposite party number 2 during the course of the day. The petitioner seeks bail in anticipation of their arrest in connection with so and so. The accusation in the first information report is that despite having received the consideration money for transferring a plot of land, the same has not been done. The petitioners have stated that earlier petitioner number 2 had filed a case against the informant for making attempts at grabbing a particular plot of land. There appears to be case and counter case. There appears to be dispute over a plot of land which is said to have been purchased, but the conveyance has not been executed. But the conveyance of the purchased land has not been executed. Let notice be issued to OP number 2 on steps being taken by the petitioner within a period of 2 weeks, both modes, returnable on 23rd of February. From the petitioners in the event of their arrest is 10,000. Provisional bail 10,000.
56 Mr. Sandeep Kumar Gautam.
Please, Lordship. Lordship, the matter relates to 30 of Excise Act, Lordship. The seizure list is annexed 1 at page 11. 15-liter containment liquor kept in one plastic container jar has been seized from the अभियुक्त के घर के मुख्य दरवाजे पर से, that is purely open place, and the petitioner has no
दरवाजे के बाहर ओपन प्लेस होता है,
दरवाजे पर से है हुजूर, अभियुक्त के घर के मुख्य दरवाजे पर से।
उतना डिस्टिंक्शन कोई वायरस है थोड़ी ची
वाइट है हुजूर की ओपन प्लेस से रिकवरी है हुजूर, और पिटिशनर का क्लीन एंटीसीडेंट है हुजूर, इस चीज को कंसीडर किया जाए हुजूर। वेरी स्मॉल क्वांटिटी है हुजूर।
दैट्स ऑल राइट।
एनी पर्सन
अभी सुना ना 6000 लीटर में दिया
जी,
6000 लीटर में सुना ना अभी एंटीसिपेटरी बिल दिया
जी हुजूर।
तो फिर सेट पैरामीटर है, उसके अलावा आई डोंट गो बियॉन्ड दैट।
लेकिन हुजूर ये क्लीन एंटीसीडेंट है, एनीवन कैन कीप दिस लिकर इज सच ए स्मॉल क्वांटिटी बिफोर द
बड़ी महंगी चीज,
गेट ऑफ एनी,
बहुत महंगी चीज है, बिना मतलब आपके दरवाजे पे क्यों कोई रखेगा? रखना वाला छिपा कर अपने घर में रखेगा।
यही तो है जो नथिंग लिकर हैव बीन सीज्ड फ्रॉम माय हाउस।
Mr. Heard Mr. You withdraw and surrender.
ऑर्डर कर दिया
Heard Mr. Sandeep Kumar Gautam, learned advocate for the petitioner and sons of the state. Pala paragraph लिखिए 15 liters of liquor kept in a plastic jerkin was found from the veranda of the house of the petitioner. Stockland Council for the petitioner has urged for grant of anticipatory bail on the ground that veranda is an open space which is accessible to all and sundry. Thus, it has been argued that the recovery cannot be saddled on him. He further submits that the petitioner does not have criminal antecedents. However, considering the fact that recovery has been made from the veranda of the house of the petitioner, recovery of liquor, I am not inclined, dismissed.
Self-petition, Mr. Prakash Saurabh Kumar.
Offense under section 30 है बिहार एक्साइज एक्ट.
You are which item?
57.
57.
Recovery of the 9 liter country-made liquor मिला under open heart.
कहाँ से?
Open heart मड़ाई से.
Please switch off your mobile phone. Whoever is carrying a mobile phone without putting it on vibrator. सब डिसिप्लिन खत्म हो गया है ये कोरोना टाइम्स में. Yes, recovery from where?
Open heart मिला मड़ाई से हुई.
ओपन हट होता है कि हट कवर रखता है? मड़ई आपका
ऊपर खुला, चारों तरफ से मड़ई खुला हुआ है.
ऐसा थोड़ी होता है. मड़ई होगा ही नहीं. मड़ई कहते हैं मरवा को, और मरवा जो होता है ऊपर का छत होता है. ये कौन सी नई भाषा और लिंगों का प्रयोग करते हैं?
मड़ई देहात में जो लगाया जाता है
पलानी
हाँ हुजूर वही
ओपन हट. तो आपने उसकी अंग्रेजी ट्रांसलेशन कर दी. ओपन नहीं है, हट है. हट की ओनरशिप होती है, और ओनरशिप हट में आप रखें. मकान या तो प्लास्टर किया हुआ
प्लास्टर नहीं है हुजूर.
नहीं, या तो ईंटे का होगा या फूस का होगा, बट मकान ही है.
मकान में हुजूर नहीं है. और हुजूर सिमिलर सिचुएटेड कोई
उसका क्या करेंगे? हमारा जो नियम है कानून के खिलाफ तो नहीं जाएंगे. कोई कोर्ट ने दिया होगा.
जी
नहीं कर सकते.
और नो क्रिमिनल लैंड से 9 लीटर है हुजूर.
9 लीटर नहीं, 90 लीटर पर भी हमें कोई परेशानी नहीं है. आपके घर से नहीं मिलना चाहिए.
घर से हुजूर बाहर में मड़ई जो फूस है उसमें, हाउस से नहीं.
आप कुछ बताइए कि वो मड़ई आपका नहीं है तो कुछ सोचूंगा. I will not make any aberration, any departure from the set practice, whether it is for 1 liter, 0.5 liter or 5,000 liters.
सर हुजूर पेज 18 पर सीजर है और उसी में है हुजूर सोफवा नौका हाथा स्थित राम सेवक महतो के.
पेज 18 तो सीजर है.
हाँ जी सीजर है, बता रहे हैं हुजूर. फूस के पलानी.
क्या इसको कैसे कहें कि नहीं है? ग्राम सोफना नोडा टोला स्थित जोधा महतो प्रेशर फूस के पलानी से. और दूसरे जिसको मिला भी होगा वो उसका तो पलानी है
नहीं. वो सीजर हुजूर है उनके यहाँ तो हमसे ज्यादा है हुजूर. वो सीजर पेज नंबर 17 पर है.
कानूनी तौर पे मैं जिनके यहाँ से बिल हुआ उनके यहाँ भेज भी नहीं सकता क्योंकि टाइटल तो है नहीं, और मैं तो बिल दूंगा नहीं.
और हुजूर
आप बताएं क्या करना चाहेंगे?
उनके यहाँ तो 26 लीटर हुजूर है.
बताएं क्या करेंगे? मैं तो नहीं. सिस्टम को तो जो रूल ऑफ हाउस कीपिंग हमने अपने लिए रखा उसको चेंज नहीं कर.
हाउस से तो लानी है तो अब हुजूर.
I'm absolutely unhappy to reject your bail petition when somebody else with 26 liters has been granted bail. But what do I do? The orders of courts are respected because of its consistency. हमें खुद अफसोस है आपकी बेल खारिज करने में, especially when another court has granted bail to another accused person. But my hands are tied, Mr. क्या करेंगे आप मिस्टर? यू आर उपाध्याय सौरभ कुमार.
जी हमारे जैसे.
आपका नाम क्या है?
रघुनंदन कुमार. रघुनंदन कुमार.
हाँ आप मास्क लगाएं इसलिए मैं पहचान. सॉरी मिस्टर, मैं एक ऑब्जर्वेशन आपको देता हूँ. यू माइट गेट बे. Heard Mr. Raghunandan Kumar, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. 9 liters of liquor is said to have been recovered from the hut of the petitioner. Mr. Appellate Counsel for the petitioner has submitted that in the same transaction, 26 liters of liquor was recovered from the hut of another person, but he has been granted anticipatory bail by a bench of this court. Regarding taking into account recovery, taking into account the fact that liquor has been recovered from the hut of the petitioner, I am not inclined to grant bail, anticipatory bail to him, notwithstanding the fact that a similarly situated person has been granted anticipatory bail by a coordinate bench in this court, and that the petitioner does not have criminal antecedents. The prayer for anticipatory bail is rejected. I've tried to be as fair as I can. हमने लिखा दिया है कि दूसरे बेंच ने दिया है कि नहीं. In fact, however, if the petitioner surrenders before the court below and seeks bail, his application shall be considered on its own merits, taking into account that similarly situated person has been granted anticipatory bail by a bench of this court, and an order shall be passed without being prejudiced by the fact that the present petition will be held.
Lordship, anticipatory bail for the offence punishable under section 413, 414 of the IPC.
413?
जी, 413 and 414 of the IPC, Lordship. Huzur, first bayan on page number 13.
413, 414, you did not read the further bayan. Tell us what is the case.
हुजूर कहते हैं कि चोरी की मोटरसाइकिल बरामद हुई है.
कहाँ से?
मेरे पोजेशन से नहीं बरामद हुई है.
कहाँ से बरामद हुई है?
वही उसी के लिए पढ़ रहे थे हुजूर.
पढ़ने की क्या बात है, आप बताइए.
अजय कुमार के पास से बरामद हुई है और उन्होंने फिर फर्दर बताया पूछताछ में कि इनके साथ चोरी करने में हम शामिल थे. हुजूर, नो रिकवरी हैज बीन मेड.
नहीं, कैसे रिकवरी होगी? आप अरेस्ट ही नहीं हुए तो रिकवरी तो होगी नहीं. आपके घर से हो सकती थी, वो है नहीं. एक ही मोटरसाइकिल रिकवर हुआ है
जी.
और ये अजय कुमार के आप दोस्त हैं.
हुजूर, इम्प्यून ऑर्डर एक लास्ट पैराग्राफ पढ़ना चाहेंगे हुजूर. हुजूर, सेकंड लाइन, last paragraph. I also perused the part of the case diary which is in 2 pages, considering the aforesaid fact that on the basis of the confessional statement of the co-accused person, stolen motorcycle has been recovered from the house of the co-accused person, namely Binod Kumar and co-accused Vikram Kumar. इनके पास से हुजूर बरामदगी हुई है, हमारे पास से कोई बरामदगी है नहीं.
ठीक. Heard MS Aparajita, learned advocate for the petitioners and also for the state. वाला paragraph लिखना. वो लिखा कि 1. Ajay Kumar was arrested with a stolen motorcycle. On his pointing, 2 other motorcycles were recovered from the house of Vikram Kumar and
Binod Kumar.
Vikram Kumar and Vinod Kumar. The petitioner also has been named by aforesaid Ajay Kumar as one of his associates. The Appellate Counsel for the petitioner has submitted that except for the confession of an arrested accused person, there is no other material to connect the petitioner with the offence. The petitioner does not have criminal antecedents. There has not been any recovery of stolen vehicle either from the possession of the petitioner, either from his personal or constructive possession. Regard being had to the nature of accusation against the petitioner 10. Yes.
61 Mr. Nafis Joha. 62 Mr. Devanand Prasad.
May please. Petition for anticipatory bail, manual officer section 304B, read with 34 of the IPC manual.
Who are you?
Petitioner number 1 is my lord, father-in-law. Petitioner number भैंसूर है. Petitioner number 1 भैंसूर है. Petitioner number 2 father-in-law. Petitioner number 3 mother-in-law है. Petitioner number 4 गोतनी है. Husband is in jail, my lord.
Allegations क्या है?
Allegation is general and omnibus allegation है. May I read mine?
नहीं, तो ठीक है. क्या पढ़ेंगे? शादी कब हुई थी?
शादी हुई है जो 4 वर्ष पूर्व.
कुछ लिखा है कि कहीं बाहर रहते थे, क्या रहते थे, कैसे हुआ? क्या लिखा है? Doctor bolted from inside. क्या है? She committed suicide.
My lord, you लिखते हैं frustration, out of frustration she hanged herself.
ये frustration क्यों मारते थे?
हम ही लोग इन्फॉर्म भी किए थे।
पोस्टमार्टम क्या है? लिगेचर है।
लगाए हुए हैं।
आप बोलना नहीं चाहेंगे?
जी माय लॉर्ड। बोलिए ना।
आपने लगाया है वो तो सही है, लेकिन अगर वो पूछ रहा है तो बोलना चाहेंगे कि आपको क्या पूछने से क्या फायदा? हमने तो लिख ही दिया है, तो फिर बहस ही करने की क्या जरूरत है? आपने पिटीशन फाइल कर दिया, मैं देख लूंगा।
मैंने लिखा हुआ है इसमें डेथ ड्यू टू हैंगिंग। मैंने कोई इंजरी नहीं बता।
Heard Mr. Brajnandan Prasad, learned advocate for the petitioners and so and so for the state. The petitioners seek bail in anticipation of their arrest in connection with so and so. The petitioner number 1 is the brother-in-law of the deceased, whereas petitioner number 2 and 3 are the parents-in-law of the deceased. Petitioner number 4 is the wife of petitioner number 1. They seek bail in anticipation of their arrest in connection with so and so. The accusation against the petitioners is general and omnibus. Come on. It has been submitted that because of the deceased not happy with her husband, she committed suicide by hanging herself. So the matter was promptly reported to the police, and in presence of doctor and the police party, the door of the room in which the deceased was found hanging was broken open. Since the door was found bolted from inside, Land Council for the petitioner submits that the story narrated by the petitioners is more plausible that the deceased committed suicide. Even the post-mortem report discloses that the deceased died of hanging. There is no accusation or alluding on the fact that the deceased was killed and was hung from the ceiling in order to give an adroit appearance of suicide or self-hanging. The husband of the deceased is in custody. Regarding had to the aforestated facts, 10,000.
My lord, kindly pass over the case.
Just a minute, Where is the file?
Sorry, I don't have the file, sir.
Prayer refused. Shashidhar Jha is your senior.
Alok Kumar Alok. Another name.
I don't accept such prayers from young councils.
Sorry, sir.
I am rejecting your petition by stating that the lawyer only sought password. He was not even ready with the file. He did not want to do it. Let this go against your senior that he sends a junior to a courtroom without file, without instructions.
Sorry, my lord. His health is not good for last.
That's all right, but you should have come with the file. The court would have helped you.
But the file with him, sir.
आप कल बहस करेंगे, पास ओवर कर रहा हूँ.
Okay, hello.
Tomorrow I will hear you only.
Okay, my lord.
Sir, 64 Mr. Glesper Srivastava.
Yes.
Anticipatory bail, my lord, on behalf of the sole petitioner. The case has been instituted under section 147, 149, 341, 323, 353, 224, 504 and 506 of the IPC, my lord. My lord, the informant is the ASI of said police station. He given the written information before the OC alleging inter alia that he along with the police.
Who is this Ambuj Thakur?
Ambuj Thakur.
Who is this Ambuj Thakur? A very known criminal of the area.
नहीं ऐसा नहीं है केस में वो
किस दफा में वो उसको किस केस में वो
उसमें वो जो 307 and other alert section में उनका.
But how are you clashing with the police because of that arrest?
वही हुजूर हमारा सबमिशन है कि 2 दिन के बाद हुजूर ये रिटर्न इंफॉर्मेशन सबमिट
आपसे पुलिस की क्या दुश्मनी है?
इसलिए हुजूर हम एक्यूज के भाई हैं।
आप एक्यूज के भाई जी? तो ऑल द मोर रीजन व्हाई द स्टेटमेंट ऑफ द इन्फॉर्मेंट शुड बी एक्सेप्टेड कि उसके अरेस्ट करने में आपने बहुत व्यवधान डाला।
हुजूर हम बताते हैं।
अब क्या बताएंगे आप?
नहीं, 2 दिन के बाद हुजूर FIR होता है और ये कहीं एलिगेशन देखा जाएगा पेज 14
आप ये बताइए कि वो अंबुज ठाकुर अरेस्टेड होके कस्टडी में चले गए या उनको चुरा कर ले गए आप?
नहीं, वो तो हुजूर बाद में अरेस्ट हो गए।
Mr. Akhileshwar Kumar Srivastava, learned advocate for the petitioner and so and so for the state. The petitioner seeks bail in anticipation of his arrest in connection with so and so. He has been named in the FIR with the accusation of clashing with the police when an attempt was made to arrest his brother Ambuj Thakur in a case in Lauria PS case number 119 of 2019. The Supplement Counsel for the petitioner has submitted that there may have been some opposition at the time of arrest, but the petitioner has been made accused in this case because he is the brother of the arrestee. The brother of the petitioner is languishing in custody ever since his arrest. Considering the general nature of accusation and the background facts, the petitioner is directed to release 10,000.
66, Mr. Rakesh Mohan Singh.
My lord, petitioner was arrested. Kindly withdraw.
Mr. Kindly withdraw नहीं, kindly it may be withdrawn. Withdraw हम हमें आदेश करना
My lord, sorry.
हमसे withdrawal की permission लीजिए। क्या नाम है आपका?
राकेश मोहन सिंह।
Mr. Rakesh Mohan Singh, learned counsel for the petitioner, seeks permission to withdraw this act. Dismissed is withdrawn.
और ऑर्डर सिले 67
हमारे इन सब बातों को बताने से बुरा नहीं मानते ना?
खुशी मानना चाहिए कि सीखने का मौका मिल रहा है।
और ऑर्डर सिले 67 मिस्टर संजय कुमार।
डेट्स आ गया? Yes.
It may be possible, my lord.
Mr.
Sanjeev Kumar is arguing.
That's all right,
yes,
but you have
but STG is on list, my lord.
You had just heard that lawyers were saying that only bail matters are being taken up, writs are not being taken up, and I had decided that from next week I shall.
My lord, just few cases, my lord. Just few cases with humble prayer.
नहीं, humble prayer. कोई इसमें हम्बल प्रेयर करने की जरूरत नहीं है। क्या केस कुछ बताएंगे तो ठीक है।
डिसमिसल का मैटर है
ये हुजूर
और डिपार्टमेंटल प्रोसीडिंग में रोकना है।
फैक्ट ऑफ द केस यही है।
काउंटर एफिडेविट फाइल कर दिया आपने?
जी
और नाउ वी विल हेल्प यू। आप तब तक फाइल खोलें अपनी। लेट अस सी द ऑर्डर ऑफ डिस्मिसल। 3 बजे से मैं करूंगा क्या इस तरह से पासवर्ड कराते रहेंगे तो नोबडी इज रेडी विद हिज रिट
जस्ट फ्यू केसेस।
कहाँ मैं ऑर्डर नहीं पास कर रहा हूँ अभी, आपसे केवल कह रहा हूँ कि आप पढ़िए, ऑर्डर दिखाइए, हम लोग लेट अस रीड।
एनेक्चर सी जो है ना वो
ये कुछ मैं देख रहा हूँ रूप सिंह नेगी वगैरह आपने लिखा है।
फेमस जजमेंट।
Well, till the time your senior comes, let me go through the brief. CCA rules 2005 ले आते हैं यहाँ पर रखिएगा।
My lord, annexure 12, my lord.
Yes, give me one.
Page number 101.
Give me 1 minute.
Annexure
12.
Let us see the charge.
My lord, kindly see page number 73.
Yes, Mr. Sanjeev, come on. Take over.
Page number 73, my lord. I am panting, your lordship, so
You can hold your breath, just point out the relevant, show us the charge.
May kindly come to page 75, your lordship.
Till the time the court reads the document, you can hold your breath.
Page 75, your lordship.
Page 73 is the charge.
Yes, your lordship. But relevant in the format that is mentioned at page 75.
Yes.
आरोप अनियमित नियुक्ति. She was directly appointed on regular basis by the inspectors of school Bihar on the recommendation of district inspectors of school Dumka without following the proper procedure for such appointment. No advertisement of the post was made in any local newspaper or agency of employment exchange. No roster clearance was obtained and the evaluation rules were also not followed. There are no proceedings of any select committee for selection through interview/test.
Yes.
साक्ष्य सीबीआई से प्राप्त जांच प्रतिवेदन की छाया प्रति.
Oh, ठीक है. This is the charge.
Yes.
Now let us see what is the finding of the inquiry officer.
Yes, your lordship. May kindly come to lordship page number 93. संचालन पदाधिकारी का मंतव्य. लॉर्डशिप हैज गॉट दैट. पेज 93.
Yes.
श्रीमती नीलिमा कुमारी तत्कालिक सहायक शिक्षिका राजकीय कन्या मध्य विद्यालय दुमका संप्रति जिला कार्यक्रम पदाधिकारी भागलपुर के ऊपर आरोप के संदर्भ में विभिन्न तिथियों पर सुनवाई की गई. आरोपित वर्तमान पदाधिकारी द्वारा अपने बचाव में लिखित पक्ष रखा गया. उपास्थन पदाधिकारी ने कोई साक्ष्य अपने विभाग की तरफ से कोई उपस्थित नहीं किया. लिखा कि सीबीआई का आरोप पत्र ही साक्ष्य है. श्रीमती नीलिमा कुमारी के द्वारा अपने पक्ष में साक्ष्य रूप में कोई कागजात उपस्थित नहीं किया गया जिससे यह प्रमाणित हो सके कि इनका नियोजन स्थानीय समिति द्वारा अनुशंसित हो. सिर्फ नियोजनालय में निबंधन संख्या 1982 से पंजीकृत है. यद्यपि विद्यालय निरीक्षिका सह उप शिक्षा निदेशिका बिहार पटना को बिहार सेवा संहिता की कंडिका 64(1-3) में नियुक्ति का अधिकार है, परंतु शिक्षिका के नियोजन में कोई विहित प्रक्रिया नहीं अपनाई गई. सीधे तौर पर जिला विद्यालय निरीक्षिका दुमका के अनुशंसा के आधार पर विद्यालय निरीक्षिका द्वारा सीधी नियुक्ति कर दी गई. रोस्टर आरक्षण का पालन नियोक्ता का दायित्व. Before that, your lordship, may I'll take
the order and then you will.
Yes, your lordship. May kindly come to page 101, annexure 12. May I read that, your lordship?
Not the entire thing. Read from paragraph 4.
श्रीमती नीलिमा कुमारी से प्राप्त द्वितीय कान परीक्षा के उत्तर के समीक्षोपरांत संतोषजनक नहीं पाए जाने का स्वरूप श्रीमती नीलिमा कुमारी अवकाश शिक्षी पदाधिकारी पूर्णिया को बिहार सरकार सेवा वर्गीकरण नियंत्रण अपील नियमावली 2005 के नियम 14 में अंकित बिहार दंड सेवा से बर्खास्त प्रस्तावित किया गया है तथा उक्त दंड प्रस्ताव का अनुमोदन प्राप्त होने के उपरांत
must be the reason in the appeal.
Yes, sir.
Before the principal secretary. Now, Mr. Sanjeev Kumar, there are two things only.
Yes, sir.
there is no allegation of your having procured the appointment.
Yes,
Nothing of that kind.
Oblige, Your Lordship. That is one
So
of
that's
the.
one aspect of the matter, but the fact remains that your appointment has been absolutely irregular. So therefore, the justification of holding a departmental inquiry with this kind of charge does not mean anything. But for all practical purposes, even if there is a violation of any one of the rules under the CCA rules of 2005, your appointment on face of it is bad in the eyes of law because the procedure has not been followed. You don't require any law precedent for this. Now, assuming for the time being that we take notice of certain lapses, certain departures in the process, but the end result would be the same because your appointment is against roster clearance. It's against the basic principle of appointment that it should be advertised, post should be done. So therefore, there is a presumption that it is a backdoor appointment. Fortunately for you, there is no accusation against you in the chance that you have contributed to this procurement of job individually without any process. Now, why should this court interfere?
Yes, Lordship. May kindly come to page number 98 in Extra 11, Your Lordship.
What is that?
That is this reply I have given to them.
No, that's
Your Lordship, the fact of the matter is that, Your Lordship, that my appointment was valid. It was as per the advertisement.
Let us.
आरोप संख्या 1 के संबंध में निवेदन पूर्वक
एक ही आरोप है ना, आरोप संख्या 1 क्या कर रहे हैं?
वही एक नहीं, इसको दो एक और दिया गया है, इसमें रोस्टर आरक्षण उसी को दो ब्रेकअप कर दिया गया। आरोप संख्या 1 के संबंध में निवेदन पूर्वक अंकित करना है कि जिला विद्यालय निरीक्षक दुमका के अधीन राजकीय कन्या मध्य विद्यालय में मैट्रिक प्रशिक्षित वेतनमान की रिक्ति के विरोध नियुक्ति हेतु जिला विद्यालय निरीक्षक दुमका के सूचना पत्र विज्ञापन प्रकाशित किया गया। सो एडवर्टीजमेंट फॉर देयर योर लॉर्डशिप।
रीड फर्स्ट।
प्रकाशित विज्ञापन के आलोक में मैट्रिक प्रशिक्षित वेतनमान के रिक्त पद पर नियुक्ति हेतु अपेक्षित अर्हता एवं योग्यता रखने का
पहला आंसर तो आपका यहाँ गलत है कि सूचना पत्र पर लिखा हुआ को प्रकाशित नहीं
लॉर्डशिप दैट टाइम इट वाज
होल्ड ऑन प्लीज टेक इट
यस लॉर्डशिप
प्लीज टेक इट प्रकाशित जो वर्ड है they are right and you may raise this point but this is no circulation. Advertisement is for knowledge to the aspirants.
I'll come to that aspect.
So therefore read the whole of it and then
yes sir. Yes, I am harping on certain things which I consider that
प्रकाशित विज्ञापन के आलोक में
प्रशिक्षित वेतनमान के रिक्त पद पर नियुक्ति हेतु अपेक्षित अर्हता एवं योग्यता रखने के कारण भागलपुर नियोजनालय में निबंधन संख्या का उल्लेख करते हुए अपना आवेदन जिला विद्यालय निरीक्षक दुमका के कार्यालय को समर्पित किया गया। It means I was registered with the employment exchange.
We understand. You read and then you make comment.
जिला विद्यालय निरीक्षक दुमका विद्यालय उप निरीक्षिका एवं राष्ट्रीय कन्या मध्य विद्यालय गोड्डा की प्रधानाध्यापिका के गठित चयन समिति द्वारा अंतरिक्षा में मौखिक प्रश्न पूछे गए जिसमें दूरस्थ पदस्थापन पे सेवा देने संबंधी में सहमति प्राप्त की गई। प्राप्त सहमति के आधार पर चयनित अभ्यर्थियों के नामों की अनुशंसा हेतु विद्यालय निरीक्षिका बिहार पटना द्वारा जिला विद्यालय निरीक्षक दुमका को प्राधिकृत किया गया और प्रतीत होता है कि संभव उसी प्राधिकार पत्र के आलोक में जिला विद्यालय निरीक्षक दुमका द्वारा अंतर्वीक्षा के आधार पर मेरी नियुक्ति की अनुशंसा बिहार विद्यालय निरीक्षक बिहार पटना जिन्हें बिहार शिक्षा संहिता की कंडिका 100 में नियुक्ति हेतु सक्षम प्राधिकारी घोषित किया गया था को प्रेषित किया गया और जिला विद्यालय निरीक्षक दुमका के अनुशंसा के आलोक में विद्यालय निरीक्षक बिहार पटना के ज्ञापन संख्या 100-183 द्वारा राजकीय मध्य विद्यालय गोड्डा में मैट्रिक प्रशिक्षित वेतनमान के रिक्त पद के
आपने अपना जवाब सही दिया है कि ये दायित्व तो अपॉइंटिंग अथॉरिटी का है कि रोस्टर क्लियरेंस करने।
जी
The only thing that you can now argue is that I have not obtained the job by any fraudulent means, and when I could see the advertisement, I applied oral interview, and therefore there should not have been a ground. The fact of the matter is that the entire proceeding is vitiated for the reason that the appointing authority should have been proceeded against. Because there appears to be some latches on the part of the appointing authority, but whatever logic you may press, your appointment is not in tune with the procedure established under law. So therefore, dismissal is different thing. Your appointment has to be declared non est per se because fraud or no fraud, it does not follow the principle, and you are sole appointee.
No, not the sole. In that school, I was the sole appointee. Yeah.
In that process, you are the sole appointee. So therefore, you could have taken a plea that there has been a cherry picking with respect to teachers. You can't say that because you are the sole appointee. There was no other person in the interview. You should have brought it on record.
I have asked for the documents since 2006, Your Lordship.
You should have brought on record that it was not only me who was interviewed pursuant to the advertisement, but there were others also. And this fact has not been correctly stated in the charge. Where is your statement? You have offered no evidence of any kind.
Lordship, Honorable Supreme Court says that is the presenting author or inquiry author, they have to prove the charge, not the delinquent. Number one, Your Lordship. Then again,
I told you in the beginning, you are not at fault. They are not charging you for any fraudulent or corrupt practice. So far, you are protected because this will not entail any criminal action against you. But the fact of the matter is that this challenge will not vindicate the appointment because it is beyond rules.
Lordship, it was within the rule, Your Lordship. No.
Oral interview.
No, not Lordship. May kindly come to
Suchna advertisement in Suchna Patika, and therefore only one.
Lordship, therefore, I impress upon Your Lordship by showing one particular.
We don't see any fault on your part, Mr. Sanjay.
That is not against Your Lordship. That is not against because it was a prevalent.
We don't find any fault against you personally.
Lordship, may kindly come to page 105, Your Lordship. The type copy.
Where have you argued that pursuant to that advertisement on Suchna Pat, many people came and the process was conducted fairly? Give me one instance and we will interfere because both the authorities, the appellate and the disciplinary authority, have not taken into account. And this is a lopsided proceeding. The inspectors of school should have been proceeded against, which I am going to record now.
Lordship, I have asked for certain documents, Lordship, from them. It's not the case that I have not asked, but they have not given me. It is similar case was taken before.
What document did you demand?
May kindly come to Annexure 2, Your Lordship, page 69. That they have asked you questions in 2006 itself, Your Lordship.
69?
Yes, Your Lordship. In 68, they have asked for certain, they have asked for notice. Page 68, 2006.
सहायक शिक्षिका के रिक्त पद पर
अनियमित रूप से नियुक्त शिक्षकों का कारण शिक्षा पूछने के संबंध में तो बिना निषेध से देव एक क्वेश्चन
जस्ट मिनट मेरा नाम नियोजनालय में दर्ज था रोस्टर क्लियरेंस सर You are appealing for whom, Mr. Prabhakar Jha?
My lord, I am appealing behalf of the state.
Then one more fact, Your Lordship. Similar question was taken up.
We are working for starting another proceeding against your inspectors of school. We are not vindicating his stand, but this is no way to conduct a proceeding.
Certainly.
Lordship, another thing is that a similar question was taken up before Honorable Jharkhand High Court, Your Lordship. May I have annexed the order, Your Lordship. May kindly come to reply to the counter affidavit, Your Lordship.
Counter affidavit में क्या लिखा है इन्होंने?
कुछ नहीं, they have written nothing that it was found satisfactory. Counter affidavit in paragraph 9 they have written.
Just. The facts of the case before Jharkhand High Court was absolutely different.
In Roshe Clean, they have said that it is a prerogative of the employer.
We are only concerned with this, that there was no advertisement at all.
No, Lordship, even assuming the charge to be true, Your Lordship.
No parallel can be drawn from the facts before the Jharkhand High Court and this court. Unless you would have said that this Suchna Patri publication, if you may call it, that invited, that attracted students and then something was done. Where documents were not, we quite see your point that the CBI inquiry report was not made available to you. Good.
That was taken behind my back, Your Lordship. I was not participated. Nothing was opportunity would have been given. All the author of the
set aside kar denge to kya hoga?
Then the author of the charges would come here, Your Lordship. Because may kindly come to page 105, Your Lordship. वहाँ पर हमारा है कि हमारी तदर्थ नियुक्ति होती है और the inspectress of school was fully competent to appoint me. Rule as per the rule provides so.
What is the rule?
Rule says may kindly come to Your Lordship, page 105. I'm reading that. Srimati Nilima Kumari, the relevant to the last three line. इनकी नियुक्ति पूर्णतः
जो किसी सरकारी सेवा में नहीं है को जिला विद्यालय निरीक्षक के अनुशंसा के आधार पर दुमका में मैट्रिक प्रशिक्षित शिक्षिका के रिक्त पद के लिए इतना एवं सरकार द्वारा स्वीकृत अन्य भत्ता पूर्णतः स्थायी रूप से नियुक्त कर योगदान करेंगे।
Now,
Santi Upadhyay, whoever she is, whether she is serving, she is retired, she ought to be in the CBI case, and proceeding should be initiated against her.
Now the rule says, Your Lordship, Rule 97 says that the district
Rule 97 of what?
Bihar Education Code, Your Lordship. I have annexed that page 96.
Yes.
I'm reading at Your Lordship serial number 11 of the said rule, power of the district inspector. To make appointment of class 4 government servants and of teachers in the scale of so and so or below in the school under her control and to sanction pension to all such cases. Now, Your Lordship, just for a moment of discussion, Your Lordship.
And that's all right, but that is the power of making appointment.
And that was duly, and that was duly.
Making appointment.
And Lordship, therefore, what I am impressing upon this honorable court, right from Uma Devi till this date, Your Lordship, the law has remained the same.
Uma Devi doesn't apply.
No, because Lordship was of the opinion that this vitiates because of the backdoor entry. Now, as per the CBI report, say irregular appointment, not an illegal appointment.
So therefore, no criminal case against you.
Therefore, Your Lordship, if there is a sanction post that is there, if the person is competent to qualify for, I'm qualified to competent to get into the job. The third thing is that if the person is competent to appoint, the person competent has appointed me and has continued for so many periods. So therefore, maximum it can be case of an irregular appointment. Now, Honorable Supreme Court in recent judgment, Bobde Sahab has passed the judgment, Your Lordship, that there
Honorable Justice.
I'm sorry, Your Lordship, I'm so sorry. Honorable Justice Bobde Sahab has passed the order, Your Lordship, when it was held that even in a case of irregular or illegal, now it's not a per se illegal, Your Lordship, maximum it could be, assuming the charge to be true. The charge itself is full of defects, Your Lordship, because in the charge it is mentioned that inka regular appointment hota hai. So therefore, Your Lordship, an opportunity be given and a time may fix, Your Lordship, whatsoever. At least the CBI inquiry, had it been done in my presence or I have been called for, I could have afforded this very document I could impress upon them. But nothing was here that the inquiry officer has said, because CBI report aa gaya, isliye theek hai.
Heard Mr. Sanjeev Kumar, an advocate for the.
And then there are three judgments of Your Lordship, wherein I have made a note to Your Lordship when the grounds of challenge I have mentioned. Now this CBI inquiry.
Give me one. We are not on that CBI inquiry, gentlemen. Assuming but not admitting that there would have been any material of a regular appointment for cancelling your appointment. Perhaps I would have taken this breach of the process very seriously. That you are not given the copy of the CBI report. We are quite on the same page with you. What is passing on in my mind is that your appointment cannot be made regular because it is sans the rules. That is the whole question.
Lordship,
we are not commenting on you.
Lordship, this can be, in my respectful submission, Your Lordship, this can be This can be examined when the entire documents is asked for your lordship is produced before this honorable court.
Anything that you would have done to...
Your lordship, lordship, I'm sorry. This is not my domain to ask for.
This is not under your domain, but
83 selection, lordship. Till then, I've been continued, promoted, and everything has been done, your lordship.
83, you have been selected.
Yes, your lordship. The appointment is of 83. Now I'm in the verge of retirement. 15 days after, I'll be retiring, your lordship. 33 years I've been working continuously with all promotions.
You will be retiring when?
January last 2020.
So with this dismissal, what happens? They will not withdraw salary that you receive, your work. So this,
nothing.
This litigation ultimately leads you nowhere.
Lordship, on a legal aspect, your lordship, that what I'm submitting your.
No, we quite see your point that you are nobody to explain. They have put you under a charge. They are required to prove it.
That is,
there can be no difficulty.
Yes, sir.
Now you have not been given the charge of the CBI, charge report of the CBI, and therefore you have no occasion to defend yourself. Now, assuming that I take these two grounds very seriously and I set aside the order of the disciplinary authority and the appellate authority, but I'm not going to leave it at that. I would ask for a continuation of inquiry with all the documents to you.
Yes, your
now, would it fetch any benefit to you? That's the question that you need.
Lordship, at least I won't be prejudiced, your lordship, for violation of principle of natural justice.
Right.
A time frame may be given, your lordship. 3 months, 4 months. It's not that I'm evading that. It's not that my grounds are not perfect. I'll be showing whatever document they have. A time frame may be please, your lordship.
What happened in that CBI case?
Kuch nahi, no FIR had been lodged, your lordship. This shows that the appeal was taken up, your lordship. There after so many cases were instituted, there many persons were found irregular. Behind that, the entire proceeding was conducted. All of a sudden, in 2006, they have asked.
If that satisfies you, that's all right. But you're not getting any benefit. Just lingering on. Let us see the judgment which you have brought for the consideration.
In one of the judgments, your lordship has heard that. I'm collecting your lordship.
I have heard.
2021 का एक
दिया नहीं आपने?
दे दिया।
मेरा जजमेंट क्या है?
एक हुदूद है आप तो जिस पे ये है 2019 तक की दिखाइएगा पेज 1120 11 नहीं 2019 का नहीं दिया अच्छा तो बात नहीं देखिए
2019 का वॉल्यूम
3 अब जो हमारा एक सबमिशन है कि जैसे विजिलेंस केस में एफआईआर को गॉस्पेल ट्रूथ नहीं माना सकता तो उसमें जो सीबीआई को गॉस्पेल ट्रूथ नहीं माना सकता है I think that should be given an opportunity whatever outcome I'm ready to face that इसमें मुझे एक और जजमेंट है शिव दयाल वर्मा का 979 पेज 979 इसी साल का किस साल का 2019
ठीक है
उसी में 979 देखा जाए पेज 979
किस साल का
सेम उसी में 979
2019 का है 2019 वॉल्यूम 3
हां 979
वॉल्यूम 3 या वॉल्यूम
3 इसमें हुजूर का लास्ट टाइम बहुत maybe the corruption will be there but there has to be the order has to be at least semblance of and Hujur has quoted so many judgments taken into consideration of so many judgments right from the principles got into practice your lordship
ये कौन सा जजमेंट है ये कौन सा
979 although I've quoted the principles enunciated in Kanti Associates that it has to be a reasoned order that's all.
So that is the order is sans reason your lordship both the reason even the inquiry officer has done it perfunctory manner that हो जाता है prove हो गया ये बोल दिया there has to be at least your lordship in my humble submission there has to be semblance of at least what the rules provide so whatever the result outcome may be that we are ready to face it your lordship
When was the proceeding initiated against you?
2006, Your Lordship, the first.
And you were the appointee of which year?
83.
83, 2006. And you have no idea about the vigilance case, what happened?
No. CBI case, Your Lordship.
CBI case.
I was appointed on 4/8/83.
Now don't take the plea that since you have not been served with a charge report, therefore you do not know. Since you have been dismissed from service, you will be knowing what happened in the PIL.
PIL में उसमें when the in the contact activity came to we came to know that when the report was submitted, the PIL was it became infructuous, Your Lordship. That okay, the purpose has been solved. I came to know from the
And
contact
what was the charge sheet and any case proceeded on the basis of that charge sheet?
No, nothing.
Do you know this?
Yeah, I'm certain of.
So no proceeding was initiated.
No, nothing. No criminal proceeding. Nothing. No.
Nothing was initiated. Yes, Mr. Prabhakar. You rise from the slumber only after 30 years of somebody's doing service. And you don't even consider it necessary to give the report. And you don't bring anything on record to say that this advertisement was not an advertisement and only one person was appointed. And if your bona fides are so telling, why have you not prosecuted or why have you not talked about the conduct of the inspectors of school? Let all these things come to the fore and let such appointing authorities be also subjected to proceeding. Give him the copy, give her the copy. Why should you do like this? We are not asking for any reinstatement, not at all. We'll fix a time. This exercise is an exercise in futility. Nonetheless, he has a ground which we cannot overlook. Okay.
Only ground before the dismissal is because of the
no personal charge. You have not raised any personal charge. It was very intelligent of you. For the reason that if you had raised anything, conspiracy, Sashi Upadhyaya she would have taken a hit. Okay? But she will not be saved, let me tell you. Has she retired or is she in service?
I don't know, my lord, if she is retired or.
उनकी पेंशन रोकेंगे इन लोग 139 में 45 दी किसी वो भी नहीं होगा क्योंकि 4 years से ऊपर हो गया होगा. You must inform us. This is bad. These matters should have been brought to the notice of the authorities.
Certainly.
Okay. Third, Mr. Sanjeev Kumar, learned advocate for the petitioner, and Mr. Prabhakar Jha for the state. The petitioner has challenged the order dated 31/8/2020 containing memo number 339, whereby she has been dismissed from service under Rule 14 (Roman 11) of Bihar Government Servant CCA Rules 2015, as also against the order passed in appeal upholding the order of dismissal. So the only charge against the petitioner is that her appointment as matric trained teacher in a school way back in the year 1983 was sans the rules, as there was no roster clearance and there was no advertisement for filling up such post. On this solitary charge, the petitioner was put to a departmental proceeding. So be it noted that a CBI inquiry had been held in the matter of illegal appointment of the petitioner pursuant to a PI petition before this court. The legal counsel for the petitioner has informed this court, and that also without any demur from the counsel for the state, that in the inquiry conducted by the CBI, it was found that the appointment of the petitioner was beyond the rules. The appointing authority, namely the district inspectors of school, may have had the competence to appoint a teacher under the Bihar Education Code, Bihar Education Service Code, but without any advertisement for filling up any vacant post, such appointment could not have been made. Mr. Kumar has further informed this court that except for the filing of such charge report that the appointment of the petitioner was not in accordance with the rules, nothing happened thereafter. Neither the petitioner nor the appointing authority were put to a criminal charge of conspiracy in obtaining an appointment through backdoor. The petitioner continued to remain in service for about 30 years, and during the period that she served as a teacher, she was promoted as well. The petitioner is shortly to retire, shortly to superannuate. The major ground of challenge of the order of dismissal is that the documents which were demanded by her for an effective representation was not supplied to her. So the only document which perhaps would have helped her frame the answer to the poser, namely the charge report of the CPI, was not made known to her. With about 3 decades having served in the department and having got promotion in the service also, the petitioner was absolutely sanguine that her appointment has been vindicated and as no sequel action was taken after the submission of the charge report. After the submission of the charge report, the learned counsel for the petitioner reiterates that, assuming but not admitting the fact that there was no roster clearance for such appointment to have been made, she could not have been saddled with any responsibility as it is in the domain of the appointing authority. He has further submitted that the appointment was made by a competent person and only after the post was advertised. It appears from the charge memo that the advertisement was not in regular sense, it was not in a regular pattern. The post appears to have been advertised by inscribing it on the blackboard put in front of the office of the district inspectors of school. Mr. Prabhakar Jha, learned advocate for the state, has submitted that prima facie such advertisement is no advertisement in the eyes of law. An advertisement is meant to disclose information to aspirants in general about the vacancy and the prospective procedure which would be adopted for filling up such vacancy. That the vacancy was advertised only by inscribing it on a blackboard kept in front of the office of the appointing authority is no advertisement in the eyes of law. Apart from this, it has been contended on behalf of the state that no doubt the petitioner has not been charged with any conspiracy for obtaining appointment in an unauthorized manner. But the fact remains that her appointment was not in accordance with the rules, and therefore the same cannot be saved by taking resort to the argument that the provisions under the Bihar Civil Service Classification and Control, Bihar Civil Government Servant Classification, Control and Appeal Rules 2005 has not been strictly adhered to in the departmental proceedings. As opposed to the aforesaid contention on behalf of the state, the counsel for the petitioner has reiterated that in the absence of the report of the CBI having been served upon her, it was not at all open for her. It was not at all convenient for her to answer to the charge that the advertisement and the appointment thereafter was irregular. According to the learned counsel for the petitioner, all that the petitioner can contend is that she was qualified at the time of her appointment to be appointed as matric trained teacher. The appointing authority also had the competence to appoint. The only question therefore remains is that it was not, the appointment process had not been fair, as there had not been any advertisement and there had not been any roster clearance. Assuming but not admitting these two facts to be correct, the charge cannot be saddled on the petitioner in the absence of any conspiracy with the appointing authority. Since there is no charge with respect to such ingredient, which stands further vindicated by the fact that no criminal case was initiated against the petitioner, the petitioner would according to his argument, according to the argument of the learned counsel, would be justified in raising the plea that even with respect to demonstrating that the appointment was fair and after observance of rules, could have been effectively defended if the CBI charge report would have been handed over to her. There is no justification, it has been argued, for not handing over the aforesaid charge report. There is nothing on record also to indicate that the petitioner was the sole person who was interviewed before giving appointment letter to her. No doubt the petitioner did not offer any evidence in support of the contention that her appointment was regular, but the primary job of proving that the appointment of the petitioner was not regular was on the authority concerned. The respondents have not chosen to proceed against the appointing authority, which also is an indicator of malified motives in passing on the buck to the appointee and giving undue protection and patronage to the appointing authority. The last of the arguments urged on behalf of the petitioner is that in view of the violation of Rule 17(3), Roman 2, bracket B of the Bihar CCA Rules 2005, the principle of injuria sine damnum and damnum sine injuria shall apply. Had the petitioner known the contents of the charge report, perhaps her defense would have been different before the disciplinary authority and the appellate authority. A perusal of the disciplinary authority, perusal of the disciplinary as well as the appellate authority reflects that there has been a complete non-application of mind. None of the aforesaid authorities have taken care to find out as to the action taken on the appointing authority when such singular/solitary appointment was made of the petitioner some 3 decades ago. What was the charge in the CBI investigation is also not known. None of the authorities, therefore, had the curiosity to know about the background of initiation of the departmental proceeding against the petitioner. Merely stating that no evidence has been brought forth on behalf of the petitioner to prove her defense is no application of mind. The authorities have not at all addressed themselves to the issue that the main document which could have been explained, which could have helped the petitioner in explaining away the circumstance appearing against her, was not given to her. There could be no justification in the opinion of this court to avoid giving the charge report of the CBI, which is the basis for initiating the prosecution, which is the basis for initiating the departmental proceeding against the petitioner. No doubt, the tenor of the departmental proceeding is not geared towards saddling the petitioner with any charge of obtaining an appointment by collusive means. But considering the fact that the entire proceeding was initiated on the basis of a CBI inquiry, the report of which has not been provided to the petitioner, the disciplinary inquiry appears to be vitiated and lopsided. The orders passed by the disciplinary authority as also the appellate authority are set aside. While saying so, the court takes note of the वो क्रांति एसोसिएट्स हमने कहाँ लिखा है?
2019 वॉल्यूम 3 PADR पेज 979.
While saying so, this court has. While saying so, this court has taken.
ऊपर से पढ़ो, फिर तो भूल गए. Last two lines.
Considering the fact that the entire proceeding was initiated on the basis of a CBI inquiry, the report of which has not been provided to the petitioner appears to be vitiated and lopsided.
Lopsided. While the orders passed by the authorities below, the disciplinary and the appellate authority are set aside. While saying so, the court has taken note of the principles summarized in
Kranti Associates.
Just a minute. In Kranti Associates Private Limited and another versus Masood Ahmed Khan and others, bracket में लिखा reported name 2010 9 SCC 496. The reason for the paucity of reasons in both the orders impugned, the orders cannot be sustained in the eyes of law. The application is allowed, but with the caveat that the petitioner, but with the caveat that the respondent would provide the charge report of the CBI, provide the inquiry report of the CBI to the petitioner and permit the petitioner to file a response to the aforesaid document, and then the disciplinary authority shall pass a fresh order in accordance with law. The entire exercise must be completed within a period of 3 months from the date of production of a copy of the order before the concerned authority.
Right.
During this period, the petitioner shall not be reinstated in service, nor would she be afforded any fiscal benefit. The respondent authority shall also consider subjecting the appointing authority to a departmental proceeding as the appointment process was vitiated because of the same not being in consonance with the rules in that regard, equal responsibility would lie on the appointing authority as well.
राशि का है वो
देखो, you must respond non-application of one. Chलिए next.
Your Lordship, be pleased. Lord, my salary has been stopped.
For what?
Lord, only actually in charges of having not training of DL.
So hey, DL. DLE.
But Lord, the fact is different, Lord. Actually,
File a counter affidavit, Mr.
Lord.
Let counter affidavit in the matter be filed. इन्होंने जो explanation दिया है कि it was not because of this, जो भी एरिया होगा, रूल जो है उसके हिसाब से इन्होंने पास नहीं किया, क्यों नहीं
उसमें
पास
ऐसा
किया?
है, एक मिनट सुनिए, उसमें है कि ये जो है
counter affidavit come, Mr. Yadav, without counter
वो जो alternative forum है कि मैं ventilate before the district teacher.
आप जाएं district teachers appellate authority.
कि that is the best forum and
स्टॉप ऑफ सैलरी का इशू है।
Lord, that is under.
ये हमारा रिप्रेजेंटेशन डिस्पोजल के लिए डायरेक्शन दे दिया जाए।
कौन सा?
ये रिप्रेजेंटेशन।
अरे हम फ्रेश आपको देते हैं, वही रिप्रेजेंटेशन में आपने क्या लिखा क्या नहीं लिखा, जाइए
हमने ये लिखा है, उसमें इशू यही है कि जब हम टर्मिनेटेड थे,
District Teachers Appellate Authority is functional, state authority also is functional. इसके बाद आइए. देखिए, after some arguments, Mr. SSP Yadav, learned advocate for the petitioner, seeks permission to withdraw this application in order to agitate his claim before the District Teachers Appellate Authority. should such an application be filed within a period of 30 days, the same shall be taken up on priority basis, keeping in mind that the petitioner is not being paid his salary. He is not being paid her salary. So, if the petitioner stands dissatisfied with the order of the district teachers appellate authority, he may approach the appellate authority thereafter. The petition stands disposed of accordingly. Yes.
Mr. Ranjan Kumar Srivastava.
My Lordship, requesting for a passover for today and tomorrow.
See, every day a request is being made for taking up
time. Sorry.
It is expected that the district teachers appellate authority shall dispose of the proceeding within a reasonable period, preferably within a period of 3 months from the date of filing of such representation. Yes.
My senior is not present.
That's no ground.
And I don't even have a file.
You stop making such prayers for fixing time for writs. I will allow. I don't shy away from giving time in criminal matters for the reason that there are many matters. Here you raise a plea that no time is being given to these. And when the case is called out, you are not available. I mean, I'm not blaming you, I'm blaming your senior. It is quite fortuitous that the court is free after doing criminal cases. Many a days, criminal cases would consume the whole of the time. But आपको आज ही विंडो मिला है, आपको यूज करिए. फाइल तो लेकर आते हैं.
I don't even have the file. I'm so sorry.
No. The court is sorry that your senior has not given you the file. You don't have the file, that is no justification. You should have the desire, the fire inside you to carry the file of your senior to the court and take this time, utilize this time to prepare yourself. That's how you will hone up your skills. And I'm not going to pass any order to your disadvantage. That's for sure. But don't do this in my court. Come with your file, we will read the file, we will try and accommodate you as much as we can. पर ये सीधा कहना है कि फाइल नहीं है, पास ओवर कर दीजिए. अब बताएं मैं क्या करूं, तीसरा केस कौन सा? You get me a case and then I leave you. You request one of your colleagues to argue a case, I will have to sit here till 4:15, 4:30. Why should I go back to my chambers? Look at the discomfiture of the court. You may be feeling embarrassed because the court is saying all these things in open court. But look at the court.
No, I get that.
The court will be requesting some advocate to start his argument. Now you realize why I insist for young lawyers carrying their file. Tomorrow I will try my best to finish my criminal matters before lunchtime. Be ready for the argument.
May it please the Lordship.
Yes.
If my Lord would see the last order, your Lordship has sought a report, affidavit from the vigilance. But vigilance has filed an affidavit indicating.
Just give me a minute.
I'm so sorry.
मांग लीजिए ना, वो घर में बैठे हुए हैं तो मांगिए ना
क्यों?
आप सरकार की तरफ से हैं। किसकी तरफ से? बीएसईबी से कौन है?
भी तो सरकार की तरफ से
हैं? बीएसईबी का सब कुछ आपके फेवर में है तो क्या?
Yes, Mr. Anjani Kumar.
Lord,
Now we are not going to expand the scope of this writ petition. The only question now, though of course you have been impleaded as a party, vigilance has been impleaded as a party for us to know. I mean, we were not satisfied with the manner of investigation. Nonetheless, the ground raised by the petitioner is that he has not made any misrepresentation. He has passed in paper 2 and he has failed in paper 1, and the scheme of the examination permits of passing in one paper for being appointed as teacher in class 7 and 8. What do you have to say to this?
that is right, Your Lordship.
Then take the necessary sequel action.
Action has been taken, my lord. Counter has been filed by vigilance. My lord, both personnel, my lord, who were responsible for, my lord, for this inquiry, Your Lordship, they have been proceeded against. And as far as the vigilance inspector, Mr. Rahmat Ali, is concerned, my lord, he has been in a disciplinary proceeding. Punishment of 1 black mark has been awarded to him. And one Rameshwar Prasad, who was appointed as nodal officer by the district police, pursuant to the order of the High Court, my lord, he has also been proceeded against, Your Lordship. Both personnel have been.
That's all right. So what is to be done to them?
With respect to those
Their
personnel.
payment of salary.
With respect to the petitioner.
Yes.
My lord,
the investigation is
if
pending.
Your Lordship will not record my statement, my lord, in one case, my lord, if I correctly remember, it was listed before Honorable Mr. Justice Hasanuddin Amanullah. And my lord, I had suggested, as a vigilance counsel, my lord, I had suggested that let it the scope. Your Lordship has limited me, my lord, while making submissions, my lord. Pursuant to my humble request, my lord, the scope of the petition came to be enlarged, and thereafter, my lord, that led to quashing of the prosecution as well. I do not remember that case, my lord. They can find out. As far as, my lord, the petitioner's grievance is concerned, my lord, wrongly he got proceeded. He or she.
No, let the investigation proceed. Let it take its let it come to a logical conclusion. So far, so good. But in the meantime, reinstate, conditional reinstatement and payment of salary. Yes, take.
इससे और बेहतर तो कुछ हो नहीं सकता। नहीं तो वही
कोर्ट के ऑर्डर के लिए क्यों रुके?
नहीं रुके, उन्हें विजिलेंस का रिपोर्ट क्लियरली शो किया।
विजिलेंस का रिपोर्ट दूसरे एस्पेक्ट के लिए मिस्टर रामविलास प्रसाद सिंह। हैरेसिंग नहीं है। Your government would be justified in holding back the salary on the sole pretext of investigation being pending because it has fiscal connotation. The fact of the matter is that this has been found to be wrong. This allegation has been found to be wrong. So therefore, the vigilance of General Police may take years. We are not concerned. Allow him to be reinstated in service in the meanwhile. Take a call. Make a statement that you are ready. Then we don't pass an order. Otherwise, this order goes against you. Mr. Anjani Kumar has removed the blot on his sketch on only by saying that departmental proceeding has been initiated against vigilance officers. That does not give you any justification to follow what the court is saying. You dispute and then I pass an order, or you accept then I affirm, ratify. आप बात समझे कि नहीं? Vigilance की इंक्वायरी मैं इसको एक्सपेंड नहीं कर रहा हूँ. I am not interested in action being taken on such erring officials. No, that's not the scope. I could have expanded under Article 226. I could have expanded, but it will fetch benefit to no one. Unnecessary fomenting litigation. They are concerned. They are the custodian of the police personnel. The personnel they'll take care. Now, so far as these petitioners are concerned who are before me, they are being prosecuted on an issue which is non-existent. Okay, take a call, decide, or else we ask, or we charge you with taking decisions without application of mind. And I call your principal secretary education that look here, this is what you're doing to your employees. इंतजार करना होगा उन्हें, आप इनकी सैलरी रिस्टोर करिए, इंस्टेट करिए, notwithstanding the fact that the investigation is pending against them. आपके पास कारण है, मैं आपको इतना जवाब आपको पैसेज दे रहा हूँ मिस्टर राकेश. With this statement I could have given an order straight away that reinstate him in service, and people, government will be behind your neck that the investigation is pending and you have taken an order from the court. आपको लेना पड़ेगा, कोर्ट को क्या करना पड़ेगा?
ये तो हुजूर का जो आप चाहे कर सकते हैं.
ठीक है. Heard Mr.
Prince Kumar Mishra, Your Lordship.
Heard Mr. Prince Kumar Mishra, learned advocate for the petitioner. Mr. Anjali Kumar, learned senior advocate for the newly added Vigilance Department, and Mr. Ramveer Prasad Singh for the state.
And for examination board.
Lordship, there are
examination board, Your Lordship.
Let me complete this.
And for examination board.
And Mr. Girjesh, क्या नाम है पूरा?
Kumar.
Girjesh Kumar for the Bihar School Examination Board. The petitioners have approached this court for a direction to the respondents to consider the certificate of their certificate of PET as valid and genuine, as the same has been issued by the Bihar School Examination Board Patna after the petitioners had passed the PET 2011 examination successfully. And further for a direction to the respondents to pay the arrears of the salary since November till date, November 2021 till date, 2021?
Yes, sir.
November 2021 till date, as the same is not being paid on the pretext of an investigation pending against them. The charge against the petitioners is of having obtained employment on the basis of forged and fabricated TT certificate. The background to this litigation is that in one of the public interest litigation cases, it was found that undeserving persons with forged degrees had obtained employment. Under the orders of this court, an inquiry was instituted with the mandate to find out and identify such teachers who had used the forced academic qualification degrees for obtaining such appointment. So consequently, an FIR was lodged in which the petitioners have also been arraigned as accused persons. So far as the charge against the petitioners are concerned, it is limited to the extent that the petitioners are said to have passed in paper 2 of the PET examination, even when they were shown to have failed in paper 1. It has been argued on behalf of the petitioners that because of the petitioners having failed in paper 1, it was presumed that their passing in paper 2 was forced and their passing in paper 2 was anomalous and hinted at the certificate being forged, semicolon, for the reason that anybody who has failed in the first paper would not be permitted to appear in the second paper. Or even if he is permitted to appear in the second paper, the result would not be published unless both the papers are cleared. In order to dispel this confusion, Learned Counsel for the petitioner has drawn the attention of this court to the entire scheme of the TET examination, which inter alia provides that for persons desirous of being appointed as teachers for class 5 to 7,
5 to 8, Your Lordship.
5 to 8, they are required to pass in paper 1 only, whereas aspirants for being appointed as teachers in class
1 to 5
would be required to pass in paper 2. So any candidate passing in paper 1 and 2 both would have the eligibility to apply for teachers for all the classes. So this necessarily implies that if the petitioners have passed in paper 2, they are eligible to be appointed as teachers for class 1 to 5.
No, my Lord, 6 to 8.
Class 6 to 8.
ऊपर में भी हजूर करेक्शन
करेक्शन करना है, इतना हम फाइल देख कर class 6 to 8. During the course of the vigilance inquiry, during the course of the inquiry conducted by the local police, even when the investigation was, even when the FIR was lodged by the vigilance police, no definite material could come against the petitioners to indicate or substantiate the charge of the petitioners having obtained employment on a forced degree. However, while going through the investigation reports, it came to light that 2 of the officers of the vigilance department,
one of the vigilance and one of the district police,
2 of the officers, one from the vigilance department and one of the general police department, were reckless in making investigations and had signed the reports in a mechanical manner without verifying the scheme of the examination. On a complaint made by these petitioners and others before the Director General of Police with respect to such faulty investigation being conducted in their cases, an inquiry was set up. And before the inquiry committee, the aforesaid 2 erring police officials admitted of having signed such reports mechanically without verifying the correctness of the allegation or the correctness of the allegation or of the defense of the petitioners. At that stage, the court found it necessary, the court found it expedient to notice the vigilance department to inquire as to the action taken against such reckless investigators for their incompetence or recklessness has brought havoc to the lives of many of such suspect teachers. Mr. Anjani Kumar, a senior advocate representing the vigilance department, has very carefully gone through the entire material and has intimated this court by way of counter affidavit that the conduct of the vigilance officer was found to be absolutely unpardonable, and he was subjected to a departmental proceeding, and he has also been given a punishment of 1 black mark. The fact of the matter now is that the petitioners have passed in paper 2 examination of the TET. The BACB in its report has admitted that in their database, the petitioners are shown to have passed their paper 2 examination thereby making them eligible for being appointed as teachers, which they were appointed and had been serving in respective schools where they were posted. Now, the present litigation has come up only on the stoppage of the salary of the petitioners since November on the pretext of an investigation against them being pending. With this fact scenario, the withholding of the salary till the investigation is brought to a logical conclusion would be absolutely harsh and even unnecessary. The respondent authorities therefore are directed to, unless the facts are proven otherwise, to resume payment of salary to the petitioners after posting them to their respective assignments, with the caveat that in case they are found to be persons with forged degrees, they would be required to return their salary and they would lose their job. So the writ petition stands before the
Lord, just one small, Lord, our salary has been stopped from March 2019, Lordship, for last 3 years, Lordship.
March 2019. March 2019.
So I would beseech your Lordship, my Lord, may only consider that part, Lord. March 2019.
Okay. My Lord, I am assisted by my Lord Miss Archana Palkar Khopade, my Lordship, in vigilance. See this.
Mr. ऊपर में लिख देना अर्चना MS Mr. Anjani Kumar assisted by MS Archana जो भी नाम.
I'm grateful, my Lord.
हो गया.
There are 3 cases.
इसमें 5 cases में आप लोगों का क्या है?
My Lord, I am appearing only in Chandri.
That's right.
4 केसेज है जिसमें सामने एक ही FIR है, सारे में एक ही.
नहीं, आपका भी वही है, पेपर 1 पेपर 2.
हाँ, पेपर
देखेंगे कल. इस ऑर्डर को टाइप करिए. If we find that this order will cover their cases also, we will do. Otherwise, we will decide your case independently.
All right.
Mr.
I'm sorry.
Mr.
Yes, sir, Lordship.
एक मिनट फाइल देना. We are making. Mr. Anjani Kumar, please hold on. For the concern of the order being within the parameters of law, I'll make necessary changes here. Now what I will do is that with this finding, I'll ask you to appear before which authorities along with a copy of this order. Thereafter a decision shall be taken to resume the salary. That's the proper method. You will go before whom?
My Lord, the Director Primary Education, Your Lordship.
In this fact scenario, therefore, this court deems it appropriate to direct. This court deems it appropriate to direct that in case a representation is filed before the Director Primary Education Department, Government of Bihar, Patna, along with a copy of this order, within a period of 3 weeks, the concerned respondent shall look into the matter and shall pass necessary orders accordingly, resuming the salary of the petitioners, which has been stopped only on the ground of pendency of the investigating process since जो भी date है
March 2019, Lordship.
In lieu of Lord, it is. I'm sorry, Lordship. It is Lord unit प्रखंड विकास पदाधिकारी.
नहीं, हम डायरेक्टर प्राइमरी एजुकेशन के पास भेज रहे हैं. Unit resume नहीं करेगा investigation.
DPO, I was suggesting DPO or DPO.
No. Director Primary Education.
Other batches will be not listed tomorrow.
Tomorrow we will see the order, make necessary changes if at all, or a separate order would be passed.
Because my case is different, Lord.
Naturally, his case also would be different. We don't believe in passing one stop order. अलग-अलग pass करेंगे.